Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Good morning, Justice Serve TV family. Good morning, Shy Gal 8, one of our moderators, and legal-minded friends from Karen Cole from across the pond, who I know feeds your feed into ours in 007 Texas. Good morning, Annie H. Oasis Cat, good morning. I know you've been busy cutting things for me, and everybody else, Kathleen XO. Denise is starting to go too fast for me to even say good morning specifically, but I have a little bit of a mini rant today, and it's a little bit different than we normally have. I want to talk about, here's what I want to talk about: health. I want to talk about people making fun of people because of health issues. I want to talk about people making fun of people because of how they may look. I want to talk of people shading on people because they think they may be better than them. And what am I really have discussed this with last night? And I talked to Michael Bryant, our pod partner, on this last night. It was Dr. Laposata. When she was testifying, was she having to eat that microphone? In other words, was it so close to her that it was catching her breathing? Or did Dr. Laposata have a health condition like COPD, like my father had and died from, like emphysema that a lot of people have, like heart disease where you may need a heart valve replacement and you can't breathe very well because of it? What I have seen just appalls me on some of the website social medias from some major networks, okay? One of which I used to have an association with. All right, people complaining, not complaining, saying, oh, I just can't with this woman. Oh, her breathing. Oh, how awful. She's a disgusting witness because of her breathing. That's what people were saying. They were making fun of her. They were rude to her. I want you all to be in a position of being somebody who may be an older woman. Older women generally don't get seen, although I think Dr. Laposata got herself seen very well yesterday, in my opinion. But you're working for a living. You're working hard. You're coming in front of a whole group of worldwide TV, media, social media watchers, streaming watchers. And what you want to comment on is not the quality of what she is saying, but her breathing and making fun of it, not even knowing what the medical condition she may have is, if she has one. How dare you? How dare you? And I'm going to call a specific blogger out, okay? One of which who I've been on the air with. What's with the breathing, he says. Sounds like an obscene phone call. Well, if you want to talk about Dr. Laposata and her actual testimony and the truth about her testimony, not making things up and putting them on your social media so you can get hits and impacts and tweets and all, fine. But if you want to go after her breathing, which may be a medical condition, not fine. And I have the same issue when it comes to making fun of Judge Beverly Kenney. Now, all of you are attacking, a lot of you are attacking her, saying she needs to be drinking, she needs to go to the bar. First of all, I don't like that, all right? That's ridiculous. She is a judge. And quite frankly, anyone is, and let's put her aside. Anyone who may have an alcoholism problem, a drinking problem relating to alcoholism, you know that is a disease that is treatable. It's no different than being a drug abuser and needing to be treated. It's no different than having cancer and needing to be treated. It's no different than having some type of physical condition that leads to a medical condition and it needs to be treated. So to make fun of a person, and then that brings me to the third portion of my rant with regard to it. I've seen people make fun of people because of their looks, how fat they are, how they speak, how they talk, what they wear. I myself, and I have a thick skin, have been the receptor of those swords when I'm in a high profile case, because people don't want to talk about what you say or how you are or your competence. They want to talk about your physical ability. When I was inspector and I came back after 3 weeks from having pneumonia, I can tell you that one of the major magazines in Los Angeles did not talk about the fact that maybe I was a little pale and gray. I hope you're okay, because we know that you were very sick with pneumonia. They wanted to talk about it, and she came back with her split ends. How dare all of you who may be commenting and may be influencing other people about putting a woman in jail for the rest of her life deal with these type of issues instead of the real issues that confront our society and confront testimony in the courtroom. I think it's disgusting. I think it's outrageous. I think all of you owe her an apology who are doing that. And for those major networks that have social media that don't put a kibosh on that and say, hey, look, why don't we be a little bit more, shall we say, human? Why don't we be a little bit more understanding? And why don't you all look at your own houses and all of your own people in your own houses who may be sick, who may be ill, who may be dying, who may have some type of mental disease, who may have some type of physical disability, who may have some type of dependency. Look at your own houses first. And if you can find that your own houses are clean and wonderful and terrific, and you're not making fun of people in your own community, that means your family, your loved ones, and your friends, well, then do not make fun of a woman who is working for a living, who came before us to try to tell her truth for the defense, and I thought did a great job of it. If you want to attack what she said, that's one thing. But if you want to attack her looks and her breathing, that's another. And please, don't do it on this network. We've decided while you have a First Amendment right to say what you want to say, we are not going to put up with it, and you will be blocked. That's my rant for the day for Karen Read. Okay, let's get back into what's going on here in the courtroom. And by the way, when I just did that, I didn't get much sleep because I was very annoyed and upset by that last night. And I just wanted to do it off the cuff. I didn't want to write it down. I wanted to tell you how I felt. And I hope you can all go out there and tell people how you feel and how you believe. And if you see somebody who is being attacked because of any medical condition or their physical appearance, set the person straight. Speak up. Because if we don't have a community that does that, if we don't shout out and make that movement by making our voices heard, then those type of people will take over the discussion about Karen Read. Can you imagine, by the way, having a jury discuss that in the jury room as opposed to the issues? Wow. So all of you in this community, please go out there and make your voices heard, even if your voices may be raspy, even if your voices are subject to having some type of COPD or emphysema, even if your voices are, shall we say, mild or meek, because they're really not once you speak out. And I do hope that it wasn't a medical condition. I do hope it was just because the judge had the microphone so close to her she had to eat the microphone. But having said that, it's irrelevant because what I'm seeing is people commenting on it. All right, so here we go into I see the fan of injustice, as I call it, although I think the defense yesterday was taking no prisoners. Alan Jackson went right at Judge Kenney by putting back in her lap and said, to use a phrase that's been bandying about, I have grave concerns. All right, because we all know that was the judge's first discussion when she thought the defense didn't reveal some discovery because Hank Brennan actually misrepresented and lied to it. Susan, let me just expand this because I can't see right now. I have eye drops in my eyes. Susan Bartelt, I don't want to get your name wrong. Thank you for that donation. I love how the female experts are standing tall and strong in the wake of Hank Higgins and Proctor's misogynistic, I should say, misogynistic, right? That's how the accent goes. And misogynistic treatment of women. Free Karen Reed. Yes, I did a rant on that. I believe this whole trial has been very misogynistic against women by the Commonwealth. You notice how the men, except for Dr. Welcher and Wolf, that's because the judge didn't really like them. She thought because of the defense, she thought had pulled the wool over her eyes. But the women, Marie Russell, remember it was a close call whether she could testify. And then you have Dr. Laposata, who is a forensic pathologist. I take it personally because my husband's a forensic pathologist, not being able to testify on the issues that is what she is trained on. As a matter of fact, she is the only person trained to read the wounds on a dead body and to tell you what it's like. And you know that if you find a child who has in a crib who's been bitten, what do they talk about? They talk about dog bites. I think the judge was ridiculous. I think Alan Jackson did a fabulous job yesterday, actually getting as much as he could get in and got it in, and then one right at the court. And I've told you in the past that you have to be willing as a lawyer, like Brian Steele was, to take those handcuffs, to be willing to take the contempt, to be willing to go to jail, because you have to stand up for your client. And he did, and he sort of backed her down a little bit, because the women have been getting basically a raw deal in that courtroom. We have the men who never need a Dahlberg hearing from the prosecution side, right? Oh, no Dahlberg hearing for them. But you take a woman, you take Marie Russell, and you take Dr. Laposata, we need a hearing. And then we're going to decide our own Dahlberg criteria out of the blue, which is that you have to have a differential diagnosis. Sure, yeah, medical examiners who get a bullet wound case in, yeah, we need a different diagnosis, right? Yeah, could he die of a heart disease? Could she die of a heart attack? Could she have had a drug overdose? There's a bullet wound sitting in the forehead, right? But let's have that differential diagnosis. Okay. Joey Kane, thank you as usual for gifting a Justice Serve TV membership. I know the people who receive them are so very grateful for that. So today we're going to have the Crash Daddy 2 continue, Dr. Rentschler. We had Stephen Plord, our own in-house Crash Daddy, who has 45 years experience, most of it on law enforcement side, who basically said last night he thinks Dr. Rentschler is going to do a great job showing why on the body the wounds that would have occurred if that taillight was broken by John O'Keeffe's arm by a clip, as the prosecution has been saying, would be different, okay, than the wounds that we saw. Now, many of you are asking, why did Karen Reed do the testing to show that you could break the taillight when until they did that, we didn't know you could break the taillight at 24, 29 miles an hour? Because they want to show that the wounds on John O'Keeffe's arm were not consistent, were not made by any impact that the prosecution is saying. And they want to show that the prosecution didn't bring that testimony to you. They brought, the Blue Man Group, Dr. Welcher. And while we're on the discussion of Dr. Welcher, who will probably testify after Dr. Rentschler, ARCCA Crash Daddy 2, Dr. Welcher said, and he's not going to get around this, that you couldn't tell, of course, that he would expect a fracture in the arm, the radius, or the ulna, the small bones in the forearm, or in the wrist, or in the arm. But since the medical examiner hadn't x-rayed that, we don't know if there was a fracture or not. And he was just assuming there was. Again, another woman, professional, Dr. Scorty Bell, under attack. The state police called her a whack job. Okay, the prosecution went after her, even though she was her own witness in his examination of her, Hank Brennan's examination of her, and then tried to go around here by bringing in Dr. Wolf. I do 7 brain surgeries yesterday. I have 4 tomorrow. I canceled 2 today. From a gamma ray surgeon from Florida to try to get around the trained professionals that are hired by the state of Massachusetts, or the Commonwealth, I should say, right? And the Commonwealth, I will repeat, for all its money, for all its resources, the government here could not find a trained forensic pathologist to come in and support their case. All right. So Dr. Welcher is going to have to be confronted with those, as somebody put it on X last night. I thought it was great. The X-ray of the arm printed out that was the size of the state of Rhode Island itself, so the jury could see it. And one wonders where they have been. Had they been withheld? Had they been hidden? Had they been not disclosed to the defense until recently? Because no one seemed to have mentioned them. But it's going to come as a big surprise, isn't it? Since Dr. Welcher is not supposed to be looking at the testimony of Dr. Rentschler. Now, we're going to really see how fair Judge Beverly Kenney is. Could she say that's something that you can't get into, Mr. Alisi? That's something you can't get into because that wasn't on the defense case. Oh, right. Could she say that? Oh, well, if she could, she will. But I think she's going to have a problem saying that because you should have grave concerns that there's been misrepresentations in court in the last week by the prosecution. First, Hank Brennan with his questioning of Crash Daddy 1, Dr. Wolf. We went back and looked at that tape, and I hope to play it for you maybe in the lunch hour. Dr. Wolf, when he was asked about the holes, he said, did you mean the cuttings in the back of the shirt? And then Hank Brennan said, he kind of waffled on it. He said, I'm talking about the holes in the shirt, kind of indicating to Dr. Wolf that he was wrong. But Dr. Wolf was right. It was cuttings in the back of the shirt. But Hank Brennan had to know that because he then, after being confronted with that, then says, no, I'm talking about the cuttings. And as we know, he had to say, it appears I am mistaken, okay? And parsing out words, it appears, how about I was mistaken? Or maybe it was more than being mistaken, since he's been mistaken on 3 major things in that courtroom. Now, if you want to convict Karen Read, okay, you're going to take all that and you're going to say all of it is irrelevant. But if you want to follow what we'd like to follow here at Justice Serve TV, the United States Constitution, the fact that the government, with all its resources, must prove somebody guilty beyond a reasonable doubt, right? If you want to follow that, that's the important thing to remember here. Not whether, you want to convict somebody because they think they're guilty, all right? This is not a game that's being played in this courtroom. This should never have been a game starting from the horrible investigation headed by Michael Proctor, the one where he said he hoped Karen Read would kill herself, the one where he said she had a leaky balloon knot, the one he said he decided within 16 hours that this was a murder without ever doing an investigation, not going to the scene, not even having the autopsy. The one where they went after the female medical examiner, Dr. Scorty Bella, calling her a whack job because she wouldn't agree with their theory of the case based on the actual objective physical evidence. All right. So this coming into now, we're coming into this tail end. So we're going to hopefully hear Dr. Rentschler explain how any injuries with the Commonwealth's new theory of how this happened. Remember, in the first trial, it was a full-on backup into John Okeffe that caused the accident, right? That was it. That was the theory. And then they changed the theory in this trial with a clip. And then the defense brings forward the fact that the prosecution didn't bring forward that the injuries on the back of John Okeffe had a pattern in it. And we all know, but the jury won't know because we know what's been pushed out, that clearly there was something in the garage or at the stairs of the garage that had not been changed in any renovation by the new homeowner who was cooperating with the defense. Why do you think that was, all right? Who was cooperating with the defense that could have made the depressed imprints. Okay, not a depressed skull fracture. We went back and looked at the opening of Alan Jackson, and he never said that there was a depressed skull fracture, but that there was an imprint either caused by being hit by something or falling back on something. And it has a pattern. It has a pattern. It's not the radial fracture that you would get if you just fell back on hard ground. It has a very specific delineated pattern. And she saw something that would create that pattern. And we're never going to know what Dr. Laposata saw because the judge wouldn't let the defense put it in, which is ridiculous. If you are a defense attorney, you go out and investigate, and then you bring that to the prosecutors. They have it in discovery. They can then go out and investigate it themselves. But they don't want to because there's so much game playing by the prosecution in this court by withholding things from them. You know, one of the things we didn't hear in this trial, we've heard about Chloe, and the defense is going to talk about Chloe. You know that you didn't hear much from the prosecution, but you know a dog named Chloe was rehomed that had been owned by the Alberts for 7 years. In the first trial, we heard that Brian Albert had let Chloe out that night to go do her business, right? We knew that. All right. And then, by the way, Chloe is apparently nowhere to be found by 5 o'clock in the morning, certainly not in that house being a guard dog. Even Tubi the poodle, who you all know from watching the show, even Tubi the poodle barks if he hears something outside our door. Tubi the poodle barks at a chipmunk, all right? And he's not a guard dog, all right? He's just an innate dog expressing his innate abilities from his DNA that he's inherited, that, hey, this is my mom and dad and my castle, and I'm going to alert you to the presence of somebody who I do not know. So there is a lot that's going on in this case, but I do hope Dr. Rentschler brings home the fact that when you have those injuries, by the way, when you have those injuries, they're not the injuries that were caused by the impact. And they ran the impact showing with the crash test dummies, or the mannequin, as Hank Brennan would like to say, showing it could not occur. All right. Now, Stephen Plort, again, who accident reconstructionist for 45 years, says he expects that Dr. Rentschler will do a great job bringing this home. And by the way, he's testified on the same side sometimes with Dr. Welcher and against Dr. Welcher. So he knows all of them. They all go to the same conferences, okay? They're all certified by the same organizations very well. He says that that Rentschler and Wolf are absolutely right. And that's an independent examiner, okay? That's somebody we found and we brought to you who has law enforcement background, okay? We've done 3 shows with him and last night. And he thinks that Rentschler is going to do a great job bringing it home. And by the way, you want to talk about some setups? Remember when Dr. Wolf said the firm works for the NHL and Hank Brennan is and the military said, is there a reason you wanted to say NHL? He said, no, I just want to tell you what some of the firms we work for. Well, yesterday we find that ARCCA, with Dr. Rentschler and all, designed the whole National Hockey League, that whole acrylic glass panel that goes around, to be round, circular, so injuries don't happen when they get into those scrums inside the hockey rink. And we also learned something even more important. By the way, the 50% crash test dummy that ARCCA used, or the mannequin, as Hank Brennan would like to say, in those tests, they use that for the National Hockey League. That is the accepted standard to use when you're running the actual tests. Then if you want to increase the mass of the body in the test, you increase speed. And that's the protocol. That is the methodology that not only everyone uses, but has been peer reviewed, which is why Judson Welcher, for the prosecution, also used that 50% mannequin. So the only one that had a problem having an arm that supposedly didn't weigh the same as John Okeffe's arm, which we don't know because it's not very common when you bring a body in to be autopsied in the medical examiners before you give it back to the family for burial, to cut the arm off. All right? Think about what the prosecution is saying. Okay? Excuse me. All right. Good time for me to have a, because the fan of injustice is up. I am hearing movement in the courtroom By the way, there's about 4 witnesses for the prosecution rebuttal case after Dr. Rentschler. The judge is pushing for closings tomorrow. I don't think that's going to happen. I think more like Monday, maybe Friday. But why don't we go into court
Right.
and
Good
listen?
morning,
I'll be
counsel.
behind my
Good morning,
Tubi
Ms.
app
Reed.
while the judge
Good
asks
morning,
those
jurors.
questions, and I'll be back when
Have to
there's
ask you those
sidebars.
same 3 questions. Were
But
you
I'm
all
listening.
able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? Everyone said no or shook their heads. Thank you. Can we have Dr. Rentschler again, please?
Doctor, I mind you're still under oath.
Yes.
Thank you.
Good morning.
Good morning, Your Honor.
All right, Mr. Jackson, whenever you're ready. Are you ready, doctor?
I am, yes, Your Honor.
Okay.
Thank you, Your Honor. Dr. Rentschler, good morning.
Good morning.
Yesterday, when we last left off, we were discussing materials that you had been provided to review, and you described much of that material in furtherance of your answer that you were asked to review certain data and undertake certain testing as it relates to testing that was done by Aperture, correct?
That's correct, yes.
Did you prepare a PowerPoint presentation to illustrate the analysis and methodology in your review and testing of this case?
I did, yes, sir.
Did you bring that with you today?
I did indeed.
Your Honor, I have a flash drive I'd like to have marked as next in order.
Okay. Is there an objection?
Not for identification.
Okay, so it's marked for identification.
Thank you. KK for ID.
While they're getting that PowerPoint up, mediocre D&E
Let me know
chicken
whenever
farm.
pardon me, let
Well,
me know whenever you're ready,
let me-
Dr. Rentschler.
Sure, you want me to bring up the PowerPoint? Or?
If you could bring up the first slide, let's start with
Sure.
that.
I'll get back to this as soon as we have like a little break. I know I have a couple questions, but I did want to
There
set
we
up
go.
this morning. I have not forgotten about you.
Is this representative of the PowerPoint that you presented, or sorry, that you prepared for presentation for the jurors?
It is, yes, sir.
Okay. Are there several blank slides, just sort of placeholder slides as we walk through your analysis that the jurors will see?
There are, yes.
Okay. Let's talk about first of all, what was the purpose of your investigation? What did you seek to undertake?
So the purpose of my investigation in this matter was to evaluate the evidence, and particularly as it pertains to the alleged theory of what occurred in this case.
All right, so I'm going to strike that answer. Ask the question again.
Sure. Did you seek to undertake an analysis of Aperture's testing or part of their testing?
I did, yes, sir.
All right. With regard to that testing, what was the reason that you undertook to analyze Aperture's testing?
Sustained.
Ultimately, were you in receipt of a PowerPoint presentation and a report from Dr. Judson Welcher?
I was, yes, sir.
Okay. Did you have an opportunity to review that PowerPoint presentation in whole?
I did, yes.
Were you able to look at his report and read his report and review his report?
I was, yes, sir.
Did you undertake an analysis based on his reporting and his PowerPoint presentation?
So I'm going to see you both at sidebar for just a minute, please.
All right, here's what I said to you tomorrow. She's going to object. Hank's going to object. The whole point of having Dr. Rentschler is twofold. One, he's got to explain that the injuries that were on John O'Keeffe's body were not made by the testing of the hitting of the tail light, the fractured tail light that we saw. But secondly, he was being called in specifically, and the judge has known this is what the whole issue was about, to rebut Welcher's testimony that he gave his new testimony. Remember, Welcher redid his report beforehand and to give the new testimony. And I said to you yesterday, I expect all of a sudden there'd be objections to hide this from the jury. And Judge Kenney is already on the bench. You can see her, that she doesn't want Dr. Rentschler to rebut Dr. Welcher. All right. That would be so unfair and so ridiculous, especially since they spent yesterday going through, she went through what portions of the PowerPoint he had to change. This was one of the things that he was hired specifically to do by the defense. Remember, the government hired him initially to make that determination, was John O'Keeffe hit by the car. They've made that determination. We heard that from Dr. Wolf. Dr. Rentschler is going to explain why they made that determination. Then he has to also explain the new testing they did to undertake, because it's a new theory of the Commonwealth that there was a clip, not a full-on impact. That's why the defense had to hire him to do that additional testing. But then, because Welcher testified and he got the PowerPoint of the testimony, he was hired to go through Welcher's testimony so the defense could rebut Welcher's testimony. And then Welcher is supposed to come on and rebut Dr. Rentschler. That's the way it goes. And all of a sudden, we're getting all these roadblocks already. We've started with nothing but objections. I don't know who the jury is taking that against. If I'm the jury, I'm taking it against the defense, okay? Not the defense, the prosecution. I'm taking it against the prosecution. Why? I want to hear the answers to this question. This is why 18 of those people, and yes, we still have all 18, no one has left after we're into our 31st day, are there. They want to hear everything so they can decide and make a decision whether or not Karen Read is guilty of any of the charges. And when you keep objecting, when you keep withholding, when you keep trying to find things to prevent people from hearing the truth, it's outrageous. Oasis Cat says, by the way, if you notice, Paul O'Keeffe is wearing a suit today. He was subpoenaed to testify in Aiden's trial, which is starting again today at 11 a.m. Yes, the court ruled in that trial because he tried to get out of the subpoena saying he had to be in this courtroom. The court said, you have to be in the other courtroom. You've made an issue out of Aiden Carney with certain charges. You have to be in the other courtroom. So let me go back to mediocre D&E chicken parm. Is the defense allowed to ask Welcher if he saw arm x-rays? Because that question can only be answered by Hank withheld then or knowingly lied under oath. Thoughts? Welcher at some point said he saw some x-rays. But he then said, but I didn't see any indication that there was an x-ray of the arm or the hand taken. You have no proof of that, he actually told the defense. So, yes, they can ask that, but of course it's going to be objected to. I think that was absolutely withheld from all sides.
Yes.
All right, let's go back into court.
Did you undertake to review analysis and testing that was done by ARCCA as reflected in the PowerPoint that you reviewed, as well as the report that you received?
I did, yes.
Did ARCCA, yourself included, undertake testing based on your review of the testing by ARCCA?
We did, yes, sir.
Okay. Tell me, what was the biomechanical analysis? That's the second point on your PowerPoint. What was the biomechanical analysis?
By the way, AJ won that
after
objection.
you reviewed the ARCCA reports and ARCCA testing. What did you undertake to do?
So I touched on this yesterday a little bit. A biomechanical analysis, there's certain steps that you have to do to actually perform a biomechanical analysis. First of all, you have to determine what the injuries are. What are the diagnosed injuries? Second, you have to determine what happened to the individual. So in this case, what would have happened to Mr. O'Keeffe? His kinematics, how would his body move? Was it contacted by anything? Was it contacted by the Lexus? If so, what forces were produced on the arm, on his body? Were they sufficient to cause the injuries that he sustained? And in this case, it's a little more involved. We have, was he hit by the car? What happened after that? Did he somehow move into the yard? And then did something happen in the yard to actually cause the skull fracture? So in order to determine if that's what actually occurred in this case, you have to look at each of those three separate events. And you have to evaluate that from a biomechanical analysis by looking at the force, looking at the kinematics, looking at a human tolerance, and determining or attempting to determine what happened. Now, if you try to determine what happened, not only do you have to prove that that was the case and the facts support that that's what occurred, you also have to eliminate all other possibilities. Because if you're saying this is how it happened, not only do you have to show that that's true.
So the next question, and I'm going to strike that. Next question.
Is there an element of differential diagnosis that goes into biomechanical analysis?
There is, absolutely.
Explain that for us, please.
Let me demonstrate. So there are several peer-reviewed articles that I reference.
Is this slide number 2, by the way?
This is slide number 2.
Thank
correct. This is injury reconstruction biomechanical analysis of accidental injury. And that sets forth the methodology that I just described. It's well written about, well reviewed in peer-reviewed articles. This is the method you need. If you're going to opine on biomechanics, this is the method you need to do, the steps you need to go through in order to provide an actual opinion.
And describe that method just a little bit further. Does that include testing?
That includes testing.
Does that include both lab testing and field testing if it's possible?
Absolutely, yes.
Explain that.
In fact, let me explain. Let me get through here. I just had a couple examples here. This third slide, another reference about biomechanical analysis. Again, it's all throughout the literature, very well established how to do this. Now, it's all based on the scientific method, okay? And the scientific method, which it was really established back in the 1620s, but this tells you how to do a proper scientific analysis. So you have an observation, you observe something. So in this case, you might say, all right, there's superficial abrasions to Mr. O'Keeffe's arm, and there's a shattered taillight. Are those two things related? Well, the first thing you do is you research the topic area. You look through the literature, you find or look for any examples of that happening. You see if there's any reports or peer-reviewed articles written about this very occurrence. Can you actually demonstrate that if your arm hit the taillight would shatter and cause those abrasions? If this occurs or is a common occurrence, it should be in the literature. You should be able to find information about it. Then you form a hypothesis. Either you say, I think this injury is related to hitting the taillight, or it's not. Whichever one you choose, that's where you then start to go into your experimentation. You have to develop tests to get data to actually back up your hypotheses. So if I said, well, I think the injury is related to it, what would you do? You would go and you would test it. You would get an arm. In this case, we got a hybrid 3 dummy arm, and we got an exemplar vehicle, and we hit the vehicle with the arm. Or we hit the arm with the vehicle, we ran into it, to determine what's going to happen when that occurs. Do we get the right circumstances, the right loading to actually occur in that case? So this, and then you go back and you analyze that. And if your results don't match up with your hypothesis, you have to reevaluate. You have to go back and see if we don't get that type of injury, if we don't get the kinematics or the force associated with what we see, you have to reevaluate if your hypothesis or what you think happened is actually true or not. So you have to continuously go through this process. And that's what experts do. That's how you perform an analysis. And that's what's important. I have 3 kids. I have a 9-year-old who's actually.
So I'm going to ask you to wait for the next question.
Okay, sure.
Was there an example that you could use of sort of a real world example that you might want to use to explain some or part of the scientific method?
There is, yeah. And I would like to explain an example of what's important with that. So I was going to say, I have 3 kids, a 9-year-old who's actually turning 10 today. Happy birthday, Kai. And I have 2 older ones.
All right. We're going to stop this. Another example.
Go ahead. Less editorializing.
Minus all the personal.
I'm sorry, Your Honors.
Go ahead.
Details matter, okay? Details in an investigation matter, and details matter here. You need details. You have to explain how things happen, okay? As an expert, I can't come in and just say.
Sustain. It needs to be more question and answer.
Why do details matter?
Because your opinions have to be based on the facts and the evidence.
Why
of
is
the
that?
case. Because that's what determines your conclusions. I can't come in and say, I think
Next question.
What if you don't have all the details and facts?
if you don't have details, if you haven't performed a proper analysis, then you can't come to a conclusion that something happened. You can't depend just on your experience. You have to have the analysis, the evidence, and the details to come to a conclusion in a case.
How do you
I
best?
would
get
remind you,
details
she let
to come to a
Judson
conclusion?
Welcher
You need
talk for
research.
hours.
You
in
need
an answer to a
peer-reviewed
question.
articles. You need evidence. You perform testing. You have to demonstrate what you think happened is A, possible, and B, actually did occur. And in order to do that, you need hard evidence to demonstrate that that's what actually occurred in this case.
Do you get that through both lab testing and field testing?
The form. Ask it differently, Mr. Jackson.
Can you get that in lab testing?
Absolutely.
Can you get that in field testing?
You can get that in field testing as well, yes.
Are those integral to an analysis?
They are. If you don't have any other evidence, if you don't have research, if you don't have peer-reviewed articles showing or demonstrating what happens, you have to formulate, you have to get that evidence. And the way to do that is through field testing, if you have no other evidence and no other source of information to provide that type of evidence.
Let's go to the next slide. Did you undertake, and this is a placeholder, did
Yes.
you undertake the scientific method in this case?
I did, yes.
What was the hypothesis of the incident that you utilized in furthering your analysis?
So the first step, the first part of this event is contact between Mr. Okeffe's arm and the vehicle.
Could you describe for the jurors what hypothesis you used based on your review of the information you got from ARCCA?
Sure. So the hypothesis that I looked at, ARCCA, their testing and report indicates that Mr. Okeffe had his arm out at a 90-degree angle.
Sustained.
What do you see? By the way, where are these from? These two slides.
These two slides are from the PowerPoint presentation that ARCCA provided.
All right. So you didn't create these?
I did not, no, sir.
Describe the angle of the arm in the left photograph with the drinking glass in the hand.
So the angle of that arm is approximately 90 degrees. The other photographs in the PowerPoint demonstrate that for someone the same height as Mr. Okeffe, the arm would be at about 90 degrees with an individual standing erect. That's what was demonstrated in their PowerPoint.
Do you note anything in their PowerPoint, the ARCCA PowerPoint, related to the clothing worn in that left photograph?
Yes, they have the surrogates wearing a hoodie or a sweatshirt, which is the exact same type and brand that Mr. Okeffe was found wearing at the time of the incident.
Did that play a part in your overall analysis? The fact that the individual, the surrogate, as you use the name, was adorned with the same type of sweatshirt that was found on Mr. Okeffe?
It did, yes. I mean, that's one of the details that we have to look at. Details matter. So we look at the clothing that was worn and the evidence found with respect to that actual sweatshirt.
I'd like to stay with that for a second. Why is that important? Why would the clothing matter?
Well, because that tells us, that gives us evidence of what may or may not have occurred. Mr. Okeffe was wearing this sweatshirt when the time of this alleged incident occurred. So if there is contact between his sweatshirt and that rear vehicle, the taillight from the Lexus, there would likely be evidence of that. And we have to look at that sweatshirt to see the condition of that sweatshirt, if there's evidence on that sweatshirt, and be able to pair that or match that up to what happened on the vehicle.
Is that part of a normal biomechanical analysis to evaluate clothing of the body as well?
Absolutely, especially when you look at automobile pedestrian impacts.
Why?
Because clothing tells you or can tell you how the impact occurred, where contact occurred between an individual and the vehicle, what part of the vehicle, what part of the individual. So it either may or it may not, but it can give you very important clues about what may have occurred during the incident.
Is that part of the normal methodology that's utilized in the field of biomechanical analysis, especially as it relates to pedestrian motor vehicle incidents?
It absolutely is. Yes. Look at the damage to the clothing. Look if you compare it up to the vehicle, to the ground, to other sources. It's another tool, another detail, and part of the evidence that allows you to try and determine what occurred.
Do you have experience in reviewing clothing of individuals that may have been involved in vehicle pedestrian incidents?
I do, yes.
How often has that played a part in your biomechanical analysis and the methodology that you employ?
It happens quite often when we look at automobile pedestrian impacts. That's really one of the steps that you need to do. You need to look at the clothing, you need to look at that evidence and see if that matches up with any other evidence in the case.
Would it be a proper methodology to just ignore the clothing in a vehicle pedestrian incident?
It would be, yes. I mean, it's really one of the first things you should do.
I'm sorry, my question was, would it be proper if you just wholly ignored it?
No, it would be improper. It would not be proper. It would be improper if you just ignored it.
Slow down, AJ. Slow down.
Getting back to the slide at hand, and we're on slide, just to stay coordinated, is this slide 7?
That is correct, yes.
Okay. You've talked about the left photograph. What is the right, the short video?
So this short video is what I refer to as the pain transfer test that was performed by ARCCA. And what they did was take a surrogate the same approximate height and weight as Mr. Okeffe and had him stand behind a subject, an exemplar Lexus, the same year, make, and model. And they put paint on the rear taillight cover on the fender, and then they backed it in to the surrogate's arm. And the reason for this is they attempted to show that where the paint contacts the arm, that it's the same area where the superficial abrasions were on Mr. Okeffe's arm.
Did you utilize these photographs and videos from the ARCCA report in conducting and building the field testing and or the lab testing that you ultimately undertook?
I did, yes, sir.
Can we go to the next slide, please? What's depicted in this slide?
So this is from the ARCCA report. And the third conclusion is that the location and orientation of the lacerations on John Okeffe's right forearm and arm are consistent with the geometry and the orientation of the right taillight on the Reed 2021 Lexus LX57.
How did you interpret the phrase geometry?
To me, geometry just means shape. So the way I interpreted this is the one test that was performed with respect to the taillight. This is the only test I saw that ARCCA performed involving the taillight and the arm, is that with this paint transfer test, they concluded that, again, the area where the paint was transferred onto the arm is consistent, the same shape and orientation as apparently the lacerations found on Mr. Okeffe's forearm.
Did this test, in your opinion, establish force multipliers that were exerted on the taillight?
It has nothing to do with force. It doesn't describe the force exerted on the taillight or on the arm. It doesn't describe how the arm would have moved as it hit the taillight. It doesn't describe how the taillight would fracture. It doesn't describe how you would actually get the lacerations on the arm. Again, all this does is generally, and I made an error there. This report, and you can see the slide says laceration. Mr. Okeffe did not have lacerations on his arm.
What did he have?
He was diagnosed with superficial abrasions.
Is there a difference between a laceration and abrasion?
There's a distinct difference, both biomechanically and medically, yes.
Is that an important distinction?
That is.
Why?
The first step of the biomechanical analysis is identify the injuries, and you have to take the diagnosed injuries identified by a medical doctor. So it's superficial abrasions. To put lacerations on, that's simply incorrect.
So I strike the end of that.
Would you describe the injuries on Mr. Okeffe's arm as lacerations?
No,
Would they be more properly described in another way?
it would be, yes.
What's that other way?
So they've been diagnosed as superficial abrasions. An abrasion occurs when there's rubbing or scraping of the skin, and it just rubs away the top layer, the epidermis of the skin. Now, a laceration is a jagged ripping or tearing of the skin, which gets down through the epidermis into the dermis. So abrasions take much less force. They're less severe than what a laceration actually is.
In a biomechanical analysis, if it's done properly, is it is it important to get the proper injury to the body as a foundation to the entire analysis?
That's core to the analysis because you're trying to determine how an injury occurred. You have to know what that injury is. You have to have the correct injury to be able to evaluate it.
Let's go to the next slide. This is a placeholder. I want to ask you a little bit while this is up. We can turn the lights up. First step in the analysis. What is the first step of the analysis after you determine the injuries, the type of injury?
So in this step, after you determine the injury, what we want to do is we want to look at the physical evidence. So we have the abrasions on Mr. Okeffe's arm, and we have the sweatshirt that he was wearing at the time. So the first step in any investigation is to determine, does the evidence from the arm match up to the evidence on the sweatshirt?
Did you undertake that analysis?
I did, yes.
Is that indicated in a slide a little bit later on in your PowerPoint?
It is, yes, sir.
Okay. Let's go to the next slide, please. What are we looking at in this slide?
So this explains the injuries. And this is from on the left side, that is the diagnoses from the autopsy. The right side is from the hospital. And you can see it says blunt impact injuries of head and extremities, abrasions and lacerations. The laceration is on the back of the skull, on the back of the head where the occipital skull fracture is. When you look at the extremities, everywhere where it talks about the extremities, it's superficial abrasions. So the first step in a biomechanical analysis, you review the medical records, determine exactly what the injuries are. And you can see there's a picture of the actual abrasions. Those are the documented injuries or abrasions to Mr. Okeffe's right arm.
Are these acceptable sources? Well, let me ask you this. What are the sources that are reflected on this slide that you referred to or you relied on in coming to your opinions and conclusions regarding Mr. Okeffe's injuries to his right arm?
Again, on the left side is from the autopsy report from the medical examiner, and then the right side is actually from the Good Samaritan hospital where Mr. Okeffe was taken.
Are autopsy records, hospital records, medical records acceptable sources for a biomechanist to rely on in determining or coming to opinions and conclusions?
They are the sources you go to determine what the injuries are. Yes.
Did you see? You reviewed the entirety of the medical records as well as the entirety of the medical examiner's file. Is that right?
I did, yes, sir.
Did you see reference to any fractures that were noted on Mr. Okeffe's right arm, either his arm, his forearm, or his hand?
No, there were no diagnosed or references to fractures on any part of his right arm or hand.
I'm going to ask Mr. Wolk to display a couple of exhibits, the x-rays.
Okay.
So he's going to take over the TV screen.
Sure.
If that's okay, Your Honor?
Yes.
This is an exhibit that was marked yesterday. I want to say 226. I may be wrong, Your Honor. I'll get the right nomenclature in just a second. This is one of the exhibits, one of three exhibits that was introduced yesterday. Do you recognize what's depicted on this?
That's the X-ray of Mr. Okeffe's right hand taken January 31st, I believe.
Did you review this in furtherance of your analysis?
I did, yes, sir.
Was it part of the medical record? Medical records or these records?
It was a series of the X-rays, yes, was attached. It was part of the medical records that were provided to me and that I reviewed in this matter.
Thank you. Just for the record, so I can clarify, this is Exhibit 229A, as in apple. Do you see? Have you looked at X-rays before?
I have, yes.
Have you interpreted X-rays in furtherance of your analyses in years past?
I have during my biomechanical analysis, yes.
Are you trained to look at x-rays and determine whether there are fractures, hairline fractures, broken bones, things of that nature?
I've been doing this for 20 years. In graduate school, I worked with surgeons and doctors to look at x-rays.
Is that part of the normal methodology that biomechanists undertake in furtherance of injury analysis?
It is part of what we normally do, yes, sir.
Would it be an important part of a biomechanist's ultimate analysis and conclusions as it relates to an injury analysis?
It would be, and especially in this case, if we're talking about impact to the arm and the hand, very important to determine, as I said, not only what the actual injuries are, but what injuries did not occur.
Would it be appropriate to come to any opinions and conclusions in an injury analysis if you were to ignore x-rays, if they existed?
No, if x-rays exist, you need to review them. You need to determine what they represent and what injuries either did or didn't occur. You absolutely need to look at them.
Do you see any injuries represented or any defects represented in this x-ray of Mr. Okeffe's right hand?
I do not, no, sir.
Can you describe what you do see or what you would expect to see if there were injuries, broken bones, torn ligaments, things of that nature, swelling? What would you expect to see?
You could actually see the fracture lines on the bones. They are evident along the hands or along the ulna and the radius. Any dislocations you see, there would be a difference in the space at the joints between the bones. Dislocation, then there would be increased space or even a decreased space if there's compression of the joints, the interphalangeal joints, the metacarpophalangeal joints, the wrist joint. There's no indication on these x-rays of any fractures or any trauma or any type of injury to the bones or the joints.
Can we go to 229B as in Bravo with the court's permission?
Yes.
You see what's depicted in this photograph?
I can, yes, sir.
What is this?
So this is a x-ray. The forearm shows the ulna and the radius, which are the two bones in the forearm.
Do you see any defects, injury, trauma to these bones or anything associated with those bones?
I do not. And when you're viewing this on the software to look at the x-rays, you can actually adjust the contrast. So you can adjust the brightness and the darkness, and it allows you to go through the whole range to better evaluate whether there are any fractures. This is a little bright, so when you're looking at this, you would actually decrease the contrast a little bit.
In terms of your review of this particular photograph, what did you note in terms of trauma or injuries at all?
I did not note any indication or any signs of trauma or injury to the forearm or to the wrist in this case.
If we could go to 229C as in Charlie. What are we looking at in this photograph?
This is the right humerus, the right upper bone of Mr. Okeffe's right arm.
Do you notice, or did you note, did you review this in furtherance of your analysis?
I did, yes, sir.
Did you note any defects, trauma, injuries at all with regard to the bone is the
humerus.
The humerus?
I did not, no, sir.
What about the joints associated with the humerus, top or bottom?
I did not note any injuries or damage to either the elbow or the shoulder joint.
What is your opinion and conclusion, having reviewed all three of these x-rays, with regard to the condition of Mr. Okeffe's right arm, starting from the arm, the forearm, and the bones in the hand?
There's no indication of any type of acute injury from the x-ray to Mr. Okeffe's right arm, either his hand, his forearm, or his upper arm.
Thank you. We can switch that back. And if we can go back to your PowerPoint.
Hosanna again. Everyone says hello, applauding. Can't believe everyone was at school 30 minutes early today for this. We'll try to keep you all informed. Thank you for joining us this school, your school. Appreciate it.
Can we go to
Harley,
the next slide,
member. Welcome. Donnie Not Wahlberg, gift of one Justice Certificate membership. I say again because people that get that really appreciate it. Thank you so much. And welcome Renee Stevenson, new member.
Maybe.
That was a direct rebuttal of Welcher without saying it. Who did not look at the x-ray, didn't even know they were existed, and said in one of his answers, there's no proof that you've presented that there's any x-rays. Okay. All right. Well, that's called a boom.
What are we looking at in this slide?
So again, this is the hoodie or sweatshirt that Mr. Okeffe had on at the time of this alleged incident.
Did you consider these photographs in conducting your injury causation analysis?
I did, yes, sir.
What role did these photographs of Mr. O'Keeffe's hoodie play in your injury causation analysis?
So this shows the hoodie, and it was inspected by the police department, and it was noted, as you can see on the right sleeve by the triangles, there were 9 different punctures or holes noted in the sleeve of the sweatshirt.
Can we go to the next slide, please? What are we looking at in these series of photos?
So let's come to Sidebahhh for a minute and Mr. Jackson, bring your PowerPoint, please.
I'm sorry. She has a problem with the PowerPoint now. Can we go back for a moment and back on the PowerPoint? I mean, there was no objection. The judge has all of a sudden, she wants to see everybody. The jury's wondering, well, what did the defense do here? What happened? This has been a wonderful presentation so far. And even though apparently you couldn't say, the judge won't let them say that you undertook this analysis to rebut Dr. Judson Welcher, that's what this analysis is to rebut Dr. Judson Welcher. And of course, we'll see if there's fairness in the courtroom when Judson Welcher comes on to rebut the analysis of Rentschler's new analysis, as they will say, rebutting Welcher's analysis, to see whether she allows it to be phrased in that way. I think we all know the answer to that. And I think one of the problems everyone is having in this trial is the inconsistency of the rulings. Now, a prosecution and Judge Kenney, who is in charge of her courtroom, allowed Judson Welcher, you remember, he had computers and he had his watch and he had calculators, and he went on and on and on in an answer. And when Mr. Alesi, as Hank Brennan would say, actually Bob Alesi is his name, would try to control him, the judge said, let him answer. And then he'd spend 7 minutes to do an answer without being able to be cross-examined on specific points in that answer. Here, the judge won't even let him give a cute example that he was going to give involving his kids. It's done all the time that you give a cute example. When we talk about whether or not blood flows back into the veins after you die and you try to analyze something, a lot of people will use, well, I'm getting on the subway in New York and the gate closes. Or, I see if you talk about circumstantial evidence, I come home and I see my kids and my dog, and there's a whole bunch of pillow inserts on the floor, and it wasn't there before I went. And of course, there's only 2, the kids and the dog are the only people left in the house. So circumstantially, I'm blaming one of them, and then I have to find out exactly what happened between the 2 of them. It's done all the time to bring the witness and bring the jury into everyday terminology and all. But apparently this judge had a problem with it, especially when he wished his child a happy birthday. Big deal, okay? Happy birthday, okay? Happy 10th birthday to Dr. Rentschler's son, who turns 10 today, okay? And his dad has to be away from him from his birthday. So we will wish you happy birthday and all. So this is where we are again. As you see, the judge is sua sponte, which means on her own, bringing them up on, may I see you with regard to the PowerPoint. Now, the PowerPoint was actually gone through by her yesterday, and certain things had to be taken off, and they were removed, all right? So this is, again, why everyone perceives that it wants a fair trial. And as you know, when we got into this case, Michael Bryant and I, we were at Long Crime, and we kind of laughed over the leaf blower. Boy, that seems like such a long time ago, the leaf blower and the solo cups to evidence collect, right? But we said, look, we didn't think in the first trial the prosecution proved the case. The jury tend to agree. And it's the state's burden under the United States Constitution, if we're going to really be Americans and citizens of the United States and love our country, to enforce that Constitution. And that means that you do not get convicted of a crime unless you have your jury of your peers and they find that there's proof beyond a reasonable doubt. Massachusetts has actually added the words proof beyond a reasonable doubt with moral certainty. Okay, that means you really have to be sure. And I'd say, to me, that's 100% sure. I'm not going to send somebody to jail for a murder unless I'm 100% sure that the prosecution has proven their case beyond a reasonable doubt. And that's what this case is about. It's not whether you think Karen Reed did it. It's not whether you like Karen Reed. It's not whether you want to make fun of the witnesses. It's not whether you want to berate experts in their field that were hired by the FBI and call them cash daddies instead of the cute name of crash daddies as everyone gave them. It's not about that. It's about listening to him, his expertise that he's developed over 19 years, and taking in and you coming to a conclusion. And you can see that he's telling you what the proper protocol and methodology is with regard to a case. He's telling us that. The judge is really big into methodology, and she's big into peer reviewed, and she's big into looking at the literature, and she's big into writing articles. So he is talking about that. He's going through it step by step, something that Dr. Welcher didn't go through. And also, he slammed Welcher home without even mentioning his name, that it's improper for anyone to come to a conclusion about saying, well, we don't know if there's arm injury, so there could be, so therefore my test is valid. When there's actual evidence from the medical examiner's office, by the way, it also demeaned the medical examiner by suggesting she didn't do her job. And again, I'll go on that rant about everybody wants to demean the female medical examiner, Dr. Russell, Dr. Laposata. They all want to demean them, right? In my view. And I think it's terrible. By the way, everyone in our feed is wishing happy birthday. I didn't catch the name of Dr. Rentschler's son. It went by too fast. Yeah, so PTSD dealer makes an interesting point. PTSD healer, not dealer, I'm sorry. Again, this keeps coming up. The Commonwealth case has so many mistakes. I would not be comfortable convicting a person knowing this. That's just how I feel about this. I cannot be comfortable convicting anyone on this evidence that is here. Thank you, Shy Gal, for loving my rants. 007 Texas isn't keeping the x-rays a Brady violation. Very interesting, because someone suggested, and I don't know the answer to this, that x-ray was actually hidden from the defense and just produced 3 weeks ago by the prosecution to the defense. Now, when I am handling a case, I told you yesterday, I make an appointment and I go to the medical examiner's office. They never will meet with you, even though they're supposed to, because they're independent, supposedly, of the police, of the prosecution, and they should meet with a defense attorney. All right. But you usually end up meeting with a lawyer who will go through, and I want to see everything. I want to see the originals of everything. I want to see the case folder. I want to see what's written on the case folder, because a lot of times that copy of that case folder, what may have been handwritten on it, is not copied. And yes, even though everything is on computer, there still can be hard copies of various things that come into that office. I want to see the x-rays. A lot of times in Hernandez, I actually wanted the original x-rays because they kept saying, well, we gave you the copies, and I don't want to see the copies. I want the originals, because sometimes when you copy or when you print, things don't come out as good as you want to see them. So if you're going to print them, you want to know that you're printing them from the original, okay? Not necessarily a copy, or that what they gave you in your thumb drive in Discovery or in the Dropbox actually is what you see at the office. So I make an appointment all the time. We did that in the Phil Spector case. I've done that in the Hernandez case. I've done it in every case I've tried where the medical examiner is going to testify. And you'd be surprised what you find. Now, I'm not saying that the defense didn't do that. I don't know. Maybe they did, and maybe this was withheld. I'm not saying the prosecution intentionally withheld. I don't know, because we do know that Dr. Scordi-Bello testified at the trial and said there were no fractures, and no one asked her. I guess everyone assumed that there were x-rays. Welcher said, by the way, that he saw some x-rays. How did he see some x-rays, but not the one that shows the hand, right? The ulna and the radius, the two small bones here in your forearm, the wrist. And you know, when you fall forward, how many people do you know fracture their wrist, right? or the bone up here, the humerus, the longer bone in the upper arm. And remember, Welcher made a big deal about saying it's the forearm, it's the upper arm. We don't say it's the whole arm, you know. Well, the rest of us in the world do talk about the arm. Okay. So, Beth, shouldn't Welcher have done what Dr. Laposata did and taken the initiative to get the x-rays if Hank didn't provide them? Yes. And also, however, if they said no x-rays existed, that would be ridiculous, okay? That would be absolutely ridiculous. And I did love with the fact that Dr. Laposata came, they unrolled, they had printed out, she had printed out, because the court asked, did you print these out? Yes, on the large paper, because you can see. Welcher, yeah, Dizzy says Welcher said that none existed. He actually even went further. He told the prosecutor, he told the defense attorney, Alessi, you have no proof they existed. You have shown me, I think I quoted it yesterday. So this is kind of like not verbatim, but I did put it in our Twitter account. He said that you have you've shown me no proof that x-rays have existed. Okay. You've shown me no proof. Well, my goodness gracious. Joanna Goddess. Hi, Joanna. Yes, Joanna, as you know, was in the trial in the previous case that our friend Dr. Priya Banerjee testified in Judge Beverly Cadoni's courtroom, a bench trial where she found a female woman guilty of a not guilty on a murder count. And Joanna has said that she acted totally different. I had a slipping fall and broke my right wrist. Yeah, it's very, very common, especially as we get out of our 20s to 30s to 40s, that your bones become more fragile and break a lot easier and falls, right? Sandra Martin, gifted one Justice Serve TV membership. Again, we thank you so much. I just somehow hid that and all, because the people that receive these, because they are $2.99 a month, and many people can't afford them, and they're so appreciative. They're so appreciative. Terry Friday wants an interesting question. Linda, have you ever defended anyone you knew was guilty? No one, I believe, was guilty of the crime or of the top charge. And that's an important thing. And I've taken on cases where I've told somebody that, hey, you better plead because my review of the evidence says that you're guilty. Now, whether they let me negotiate that deal. See, defense attorneys have a whole skew of things. They can talk to the client. They can say, look, and they hire experts who will say, look, this is not good for you. So we have a whole area of the practice where we may say this person the best I can do for you is if you are guilty, and you never ask somebody if they are. If you are guilty, I can try to negotiate a plea for you. All right. I strongly believe, because I am at the point in my career that I have seen wrongful convictions, and the last 20 years, I've only taken on cases that I believe somebody is not guilty or not guilty of the top charge, the prosecution. And most of those cases have come out right. Jason Williams, we didn't get the conviction for the murder. He wasn't convicted. Bill Spector, I got a hung. Aaron Hernandez, we got a not guilty.
Jurors,
Michael
I apologize
Skakel,
that took so long, but it was
we have
necessary to do
undid
rather
his
than sending
conviction.
you out.
So all that's on my
Sure.
CV, I think on my law office website, by the way. All right, thank you for asking that question. Let's go back into court. Let's listen.
Thank you.
And I forgot Casey Anthony, which you all hate me for. I believe she was absolutely not guilty. All right, and the jury agreed.
One moment.
Okay. You are most welcome, Terry Friday. You are most very welcome.
Dr.
I'm going to be
Rentschler,
behind my 2B
my eyes aren't good
my
enough to
2B
see the upper
avatar.
right-hand corner. What slide number is this? That's
Number
on-
12.
Number 12, thank you. Did you look at these photographs and consider these photographs in furtherance of your ultimate conclusion?
I did, yes, sir.
Can we move to slide 13, please? Did you also look at and consider these photographs in coming to your ultimate conclusion?
I did, yes.
Can we move to slide 14, please? Did you look at and consider these photographs in coming to your conclusions and opinions regarding
did.
this case?
Yes, sir.
Can you move from slide 14 over to slide 18, please?
Can I switch through real quick?
Sure.
Yeah. So we 18.
Let's go to 18. What are we looking at in slide 18?
So this is Mr. O'Keeffe's right arm at autopsy, and they're holding up a ruler to demonstrate the size and dimensions of the abrasions.
And what are the yellow indicators?
Those are indicators I added based on the length of the ruler to show the approximate size, length, and width of those abrasions.
Was it important in your biomechanical analysis to measure and denote all the injuries?
It was, yes.
Did you actually count the number of injuries on Mr. O'Keeffe's arm?
I did, yes.
How many injuries did he have? How many distinct and separate injuries did Mr. O'Keeffe's arm present?
Conservatively, I counted 36 different superficial abrasions on his right arm.
And did you go through all the photographs in an effort to count and distinguish one abrasion and one defect on his skin from another?
I did, yes, sir.
And you said conservatively 36 separate abrasions, correct?
That's correct.
What does that mean in terms of the mechanism that you would expect to cause that abrasion?
Well, you need 36 different points of contact to get through the sweatshirt and get to the skin to actually cause abrasion to the skin. 36 different separate points of contact to the skin.
How many defects, remind us, how many defects were noted by the crime lab in Mr. O'Keeffe's right sleeve?
9 defects.
Can you scroll to slide 22 quickly, please? What is this?
This is a slide, again, from Aperture, from their PowerPoint. It's the only slide, the only photo, the only indication of the hoodie that I found in their analysis. And it also has pictures showing, looks like they try to line up the top of that taillight cover.
Sustained.
Do you see there's some sort of marking on that lower left photograph with some yellow lines?
I do, yes.
How did you analyze that marking?
I analyzed that. It goes through the part of the taillight cover and then goes through part of the upper arm of the surrogate.
And there's a parallel line to it a little bit in a V shape. There's a parallel line below it. How did you analyze that line?
I analyzed that as apparently showing that the area of the taillight.
So not apparently. What did you
How did you
analyze?
interpret
sure.
that?
I interpreted that represents that area of the taillight corresponds to the area of the upper arm.
And there's a red dotted line around the tail light, correct?
Correct.
How did you interpret what that represents?
That was the part of the taillight that fractured.
Did you put any of these lines on there, or are these all from Aperture?
These are all from Aperture. I did not put any of those on there.
You see the small, it's horizontal, I'm sorry, it's vertical photograph of Mr. O'Keeffe's arm?
I do, yes.
Did you note anywhere in the Aperture report a denotation of the number of abrasions, counting the number of abrasions on Mr. O'Keeffe's arm?
There's no denotation, no indication that the number of abrasions were ever counted. No, sir.
Ultimately, based on your review of and all of your testing, did you come to an opinion or a conclusion as to whether or not the abrasions on Mr. O'Keeffe's arm are consistent with striking the right rear taillight of the Lexus?
I did, yes.
And what is that conclusion?
That they're inconsistent with striking the taillight or being produced as a result of contact with the taillight.
Why did you come to that conclusion?
There's a number of reasons that I came to. First of all, the abrasions, the numbers don't correspond to the number of holes or.
Sustained.
Did you consider, without counting the number of abrasions and the number of holes, did you consider the abrasions?
I did, yes.
Did you consider the sweatshirt?
I did.
Was that an important part of your analysis?
It was, yes.
What else did you consider?
I considered that it was not possible to line up 36 different abrasions with
So I'm going to strike that answer, ask it differently.
Your Honor, if he could finish his answer. He was about to say contact with the taillight.
Yep, so ask it differently, Mr. Jackson.
Sure. What did the 36 abrasions, conservatively, and their interaction with the taillight have to do with your ultimate opinion and conclusion?
Well, that you have to, if those abrasions came from contact with the taillight, you have to be able to correlate them and line them up with contact, 36 different contacts from the taillight.
And ultimately, based on your understanding of Aperture's review and the photographs that you saw, you were presuming, based on Aperture's testing, that Mr. Okeffe was wearing that hoodie. Is that correct?
Sustained.
What was the condition? Let me ask it this way. There's a photograph in the Aperture report that we're looking at with blue paint on an arm, right?
Correct.
Is that your understanding, or did you test that Mr. Okeffe could have been hit wearing short sleeves?
No.
What did you test? What was your presumption and assumption in your testing?
That he was wearing the hoodie that was found on him at the time.
With the 9 holes in the right sleeve?
With the 9 holes in the right sleeve.
Watch the form of the question, Mr. Jackson.
Sure. Let's go to the next slide, please. What is this?
These are the top 2 and bottom right slide are from the Aperture PowerPoint.
How did you interpret the 2 photographs on the right, the parallel lines and the red lines in that slide?
The parallel lines correspond to an area of the fractured tail light, and then the red dotted line corresponds to an area of abrasions on Mr. O'Keeffe's upper arm, and there's a red arrow pointing to part of the fractured tail light.
Can we go to the next slide, please? What are we looking at in this slide?
Again, this is the paint test. This is the only test that was conducted by Aperture to look at the tail light and the arm in this case, and the interaction between the two.
Did you note whether in all of Aperture's data that you reviewed, whether or not there was any measurements to determine whether the abrasions were consistent with contact with the Lexus?
I did. There were no measurements at all taken with respect to that test. No measurements with respect to where the contact happened on the car or on the arm itself. There was no indication of where that blue paint extended on the surrogate's arm, say from the wrist up to where the laceration or the abrasions would have occurred.
Is that important?
It's very important.
Why?
Because you can't say that the area where the blue paint is corresponds to the area of the abrasions if you don't take measurements. If you just eyeball it, all you can say is by eyeballing it, it looks approximately the same. But that's not scientific. You can't come to an actual conclusion that where that paint covers the arm is where those abrasions actually were. They could lie outside, they could lie forward, they could lie above that painted area. You can't say with any scientific certainty that that area of paint corresponds to where the abrasions are.
In this motion video and the still photograph to the left in slide 24, is that what we're on, 24?
We are, yes, sir.
What did you note with regard to the positioning of the surrogate's arm? I think that's Mr. Welcher, as it relates to the taillight and the back of the SUV.
Yes, the positioning of the arm in the photographs as well as the one test that was performed, the arm is approximately 90 degrees, level in line with the rear taillight of the vehicle.
Did you seek to do any testing approximating the positioning of the arm as you saw it, as you interpreted it in the Aperture data?
I did, yes, sir.
What were you seeking to determine when you did your testing?
Well, if we want to determine whether the orientation and the position of the abrasions on the arm correspond to the tail light, you have to have the arm in the position that you claim it struck the tail light and then look at the abrasions. Because if you're looking at orientation and the direction of the abrasions, you can't look at how they exist with the arm. The only pictures of the arm of the abrasions are with Mr. O'Keeffe's arm extended. But that's not how he would have had it according to the test. It would have been at a 90-degree angle.
Dr. Rentschler, were there any peer-reviewed articles cited in connection with Aperture's paint transfer test?
I did not see, I was not provided a single peer-reviewed article with respect to the paint test or any indication of any test or article looking at arm contact with the vehicle or a taillight cover.
Can we go to slide 25? What are we looking at in this slide?
So in this slide, the picture on the far left is the photographs provided from the autopsy in hospital with Mr. Okeffe's right arm fully extended. Again, those are the only photographs we have.
What about the photograph in the middle and to the far right?
In the middle and the far right, what I did was actually take that arm and then rotate the forearm to put it in a position that it would be in as demonstrated by the paint test with the arm at approximately 90 degrees.
What was the import of this undertaking?
Well, if you look at the paint test and the way the arm's at 90 degrees and having the car come and essentially contact and push the arm out of the way, that's going to give you or tell you the directionality or the direction of the abrasions. Because if you have your arm at a right angle and the vehicle comes and pushes and slides against it on that forearm, you would expect those abrasions to be horizontal, to be in line with that forearm.
Are they?
They're not. You can see some of them are vertical, some of them are angled, some of them it's hard to tell what the directionality is. But if your arm, again, is being struck and pushed this way, as it's pushed and as the car goes by, if this would occur in this manner, you would expect those abrasions to be horizontal in the direction that the vehicle's actually traveling.
When you say horizontal, do you mean horizontal from the elbow to the wrist?
Correct, or parallel, yes, with the forearm.
Can we go to slide 26, please? This is yet again the same video that we saw earlier.
That is correct. This is the paint test video, yes.
And what has to happen in order for the paint in this test to reach the upper forearm?
Well, in this case, to reach the upper forearm, there has to be contact between the forearm and the taillight cover.
Can we go to the next slide, please? What is this slide showing?
Again, this shows, you can see on the right, I added arrows to kind of show the directionality of the different abrasions. And on the forearm, they simply do not line up with the type of kinematics or the type of motion shown in the paint test. Again, of the arm getting pushed out of the way and the car traveling past. If there were going to be abrasions from the fractured glass as it moves along, again, it would be lengthwise parallel to the forearm.
If the arm was positioned as it was indicated in the paint test done by Aperture, would you expect to see this pattern of injuries on Mr. Okeffe's arm if in fact it contacted the taillight and if in fact it was abraded based on the taillight?
You would not. You can't get, for instance, horizontal abrasions on the upper arm and somehow get vertical and angled abrasions on the forearm. The kinematics don't work out to actually produce those types of injuries.
Can we go to the next slide, please? What are we looking at in this slide?
So again, this is the paint transfer test, and it demonstrates there were no measurements taken, so we don't know the exact size or location of that paint or of the lacerations. And you can see the photograph on the right basically shows that after doing the test, a picture of the right arm was put next to it and basically eyeballed to say it's the same, well, it's only approximately the same area.
So I'm going to strike that. So next question.
Do you see any measurements, any tape measures, any laser measuring equipment, anything like that in that right photograph?
Nothing, no types of measurements whatsoever.
Can we go to the next slide, please? This is on the left, the same video that we've seen several times, correct?
That's correct.
What are we looking at on the photograph on the right?
So on the right, it is the video of this test taken from the side of the vehicle.
Did you notice anything of note in this this angle of the paint transfer test?
I did. I slowed this video down. And so as you can see, as it starts out, and you'll see the vehicle starts to slowly back. So there was no photographs showing the position of the arm in the back of the car. The video is from the side, and the top video, you can't tell where the arm is positioned against the tailgate. But whatever positions it's at, you can see as the car backs up here, look at the elbow and the upper arm. If the car backed directly in this direction, there would be no contact with that elbow or the upper arm. And remember, this test is to show where the paint would transfer and if that correlates to the lacerations.
You mean before you start the video, when you say there would be no contact with the elbow or the upper arm, you mean the biceps area and from the elbow up?
That's correct.
Is that based on the photograph on the right and the positioning of the surrogate?
Exactly. You can see right now, if the car just backed directly straight back, it would not contact the elbow or the upper arm.
Before you play the video, what did you note when the car from the angle to the right of the video on the right? What did you note as the car, just before the car starts to make contact with the surrogate? What did you note?
So in order to get that pattern on the arm, right as the car contacts the arm, the surrogate pushes his elbow forward, leans into the car against the light, and then rolls off.
Can you play that for us, please? Did you see what you were describing in that video?
I did, and I can slow it down. So you can see even at this point, as the car approaches, it would not contact the elbow or the biceps. So as it comes in, watch the elbow all of a sudden shoot in. Surrogate turns his arm in and then leans against the light cover. So this is not indicative of someone standing there and having a car back into their arm. In order to get that pattern of paint on the arm, someone would have to stand there, and as the car approached and contacted their arm, they would have to actually push their arm forward and lean into it to get that paint pattern.
Is that, in your view, proper scientific testing?
Sustained.
Let's move to the next slide, please. What is this?
And so this is that same event, and you can see I slowed it down even more just so you can see the actual movement of the elbow and the upper arm to get that pattern.
Thank you. Can we move to the next slide, please? This is slide 30. And let's go to 31.
Yeah, this is 31.
I'm sorry, 31. What conclusions or opinions did you reach or could you reach after reviewing the totality of the results of the paint transfer test?
The paint transfer test, all it can show is the approximate of where the arm was covered in paint as the surrogate jammed his elbow in and rolled against the taillight cover. So it tells us nothing about what may have actually occurred, how the lacerations were actually, or the abrasions were produced. It doesn't talk about the kinematics of the arm to actually cause those abrasions. All it does is just say, under this specific condition, if someone was to stand there and then shoot your elbow forward and lean in, you would get paint on this approximate part of your arm, because we don't even have any measurements for it. That's the only thing that test demonstrates, and that's the only test that was conducted to look at the interaction between the arm and the Lexus in this case.
Did you reach any opinions and conclusions regarding whether the physical evidence is consistent or inconsistent with the injuries to Mr. Okeffe's right arm?
I did, yes.
And what are what's the basis?
The basis is looking at the number of laceration or the number of abrasions on the arm, as well as the orientation and direction of those abrasions. And they don't correspond to how the arm would interact with the vehicle if it was at a right angle and struck by the rear of that vehicle.
Do you hold that opinion to a reasonable degree of scientific certainty, Doctor?
I do, yes, sir.
Can we move to the next slide, please? Actually, slide 33. I may have just a moment, Your Honor.
Yes.
Okay, so he basically concluded, as we all know, that the Blue Man test group was ridiculous because, as Steve implored our accident reconstruction, said no one just stands there and moves their arm and elbow into a car when you see it coming. You know, you just got, you're not just gonna,
Any of the
okay,
testing
here it
that
is,
you
let me
saw
move it
in terms of the paint transfer test or any other testing that you saw included in the Aperture report and the Aperture PowerPoint presentation indicate that there was any consistency or any results that were consistent with Mr. Okeffe's right arm being struck by the taillight, causing 36 plus abrasions to his right arm while wearing the shirt, the sweatshirt with 9 holes in it.
That's sustained. You have to ask that differently, Mr. Jackson.
Did you determine, based on the testing by Aperture, whether or not it was consistent, that paint test, that paint transfer test was consistent with Mr. Okeffe's arm being damaged by the taillight at speed?
I did.
Okay, and what is that conclusion?
That does not represent that at all. The evidence from that test, again, it's only puts paint on the arm. So in no way does that determine or demonstrate how, if the arm struck the taillight cover, how the taillight cover could shatter, how the movement of the arm could interact with the cover to produce those abrasions.
Did you go, I'm sorry.
There's just no evidence of that. There's no steps taken to demonstrate how, if that's even possible, would that actually occur in a case like that? First, you have to show it's possible. I saw no peer-reviewed articles, no research data, and the only test that was done that links the injuries to the taillight cover is this paint test.
Is that the paint test in which the arm was leaned into the car?
In which the elbow was shot forward and then the arm and upper arm was leaned into and against the cover.
Doctor, did you also go on to further your injury causation analysis by performing impact tests to evaluate the kinematics involved?
I did, yes.
Can you describe that for us, please?
Sure. So one of the steps involved in the biomechanical analysis is the kinematics, the motion. So we need to look at the motion of the arm. If the arm hit the taillight cover fractured, and you got abrasions, you need to be able to show that. You need to look at how the arm would actually move if it was struck by the vehicle. I've seen no peer-reviewed articles or research to demonstrate that. So what you need to do then is do testing to look at how the arm would actually move and whether it's possible to create those conditions to actually get that injury.
Did you use an ATD hybrid 3 arm for testing?
We did, yes. We used a 50th percentile male ATD hybrid 3 arm.
Is the use of that hybrid 3 arm accepted in your industry in terms of testing?
Yes, it certainly is. As I said yesterday, it's the gold standard for testing. And the arm itself is used just for that very purpose. In fact, there's a number of studies, they use the 50th percentile arm to look at airbag deployment. One of the issues with airbags for the driver is it comes out of the hub of the steering wheel. So if you're steering and you're turning your car and you hit something and the airbag goes off, what happens? It blows right into your forearm, and it can actually cause fractures. We see that quite often. So they perform testing with the 50th percentile arm to look at the forces and acceleration on the arm as airbags go off. Very similar. So if your hand was hit by the back of the arm was hit by the back of the car and propelled forward, that's very similar to having an airbag deploy. Actually, this would probably be more severe. An airbag's almost like a giant pillow enveloping the arm. And here we have an SUV actually contacting the rear of your arm.
Can we go to the next slide, please?
Sure.
This is 35.
Let's see, here's 35.
There we go.
Thank you, Sandra Martin,
What's
gifting
depicted
one
here?
justice served.
So this was testing done at
Appreciate it.
15 miles an hour. So this is with the hybrid arm. and suspended so that it was actually impacting the right rear of the Lexus as the Lexus was traveling at 15 miles an hour.
Was there acceleration that was noted on the arm, force and acceleration?
There was on both the arm as well as the hand, yes.
What was the result of the damage to the taillight based on this test?
So in this test, there was actually no damage. As you can see, it catches kind of the hand and the forearm. And if you want to describe it as kind of a glancing blow, there was not enough force at 15 miles an hour on this glancing blow to actually fracture the taillight.
Is the position of this arm relative to the SUV consistent or inconsistent with the original spot that the surrogate in the paint test was standing as it related to the SUV?
It's consistent. We lined it up so it's consistent with that original location so that it would not impact the elbow or the upper arm. So at that position, if there's impact to the arm at 15 miles an hour, it doesn't cause the taillight to fracture. And it's also important to look at the kinematics. If you look at the acceleration data below, that hand and arm is accelerated. The hand's accelerated up to the speed of the vehicle in about 2 to 4 milliseconds.
How long does it take to blink your eye?
250 milliseconds. It takes a quarter of a second to blink your eye. So this occurs if your hand's hit at 15 miles an hour by a car, it's going to be accelerated up to the speed of the car about 50 times faster than you can blink.
Can we go to the next slide, please? And what are we looking at in this?
So this is lab testing at 17 miles an hour. So the housing and the cover was basically propelled into the forearm of the dummy at 17 miles an hour.
What was the acceleration that was noted on the arm?
So when you look at the arm, its acceleration here is almost 300 Gs.
What does that mean
So-
just to us?
So, 300 Gs, if you look at weight, if you say the weight of the arm is 10 pounds, 300 Gs means there's 3,000 pounds of force acting on that arm.
Is that enough to break a bone?
It's more than enough to break a bone.
Is that enough to to tear ligaments?
Absolutely, yes.
What about the bones in the hand? Are those stronger or the same resistance as the bones in the forearm? Or are they more delicate?
No, the bones in the hand are, as you can imagine, much weaker because they're much smaller. When you look at the carpal bones, the metacarpal bones, the metacarpal interphalangeal joint, which is basically your knuckles, they are much smaller and it takes much less force to fracture your hand bones compared to your ulna or your radius.
Let's go to the next slide, please. What are we looking at in this slide?
So this is a 24-mile-an-hour impact with the arm of the dummy contacting the rear, again, tail light. And it shows you the motion, the dummy suspended, shows you the motion of the dummy and, again, the force and acceleration. Now, that right video I put in because that's real-time video. We've been showing the low speed, but look on the right. This is the actual speed at 24 miles an hour. That's what it looks like if you have your hand out and it's struck by an SUV.
Is the arm accelerated do the same physics apply? Is the arm accelerated up to the speed of the car in milliseconds?
It is, yes. It's all about weight, right? Because you have a 6,000-pound car and you have a 10-pound arm. It's whatever speed that car is going, your arm, your hand, whatever's sticking out there is immediately going to get accelerated up to the speed of that vehicle.
The video on the right is in real time. Like you said, it's sped up in milliseconds. Is that right?
That's correct.
Is the Hybrid 3 that's used in this test, is that suspended from above?
The dummy in this test is suspended from above, yes, like a pendulum, barely touching the ground.
Is the dummy connected to the ground in any way?
No, it's just its feet are barely touching.
What would happen if there were forces applied to that dummy that went perpendicular to the travel of the vehicle? What would happen to the dummy?
The dummy would swing out like a pendulum in that direction.
Based on your review of the test that was done, the 24-mile-an-hour test, were there forces on that dummy that were perpendicular to the car such that the dummy would swing out or be forced out or be propelled out away from the car?
No, there were no forces from the testing, and it's simple physics. Your center of mass of your body is basically at your umbilicus or your belly button. So in order to move the body, you have to apply a force at that part of the body. If your arm's struck, it's not going to move your body appreciably. All it's going to do, your arm's like a moment arm, it's going to spin you around. Could there be some motion forward or backward if you take a step? Possibly. But the center of mass of your body isn't going to move. You have to get struck by the vehicle to have the body actually move in a specific direction.
Can we go to the next slide,
Stephen
please?
Ford, our accident reconstruction.
What is this showing?
So this is a slow-mo of the overhead from the real time. It was a GoPro that was recording that real-time video, and this is a slow motion of that video.
I'd like to ask you a couple of questions. As you see the vehicle contact the arm, what happens to the arm as it's being contacted in those milliseconds where it's being accelerated up to 24 miles an hour?
Well, the arm's accelerated up and pushed away from the body. So whatever part of your arm or body is contacting the car, that's going to be pushed forward away from the rest of your body. So not only is it loading the arm with an impact force as it strikes the arm and the hand, but then it's actually stressing the joints too. It's like ripping imagine having a car come and 3,000 pounds of force pulling your arm forward at the elbow, at the shoulder joint. It's putting a lot of force and pressure on that appendage.
What's the G-force for the 24 mile an hour impact?
G-force, let me see
Could
exactly.
you pause that video for a second?
Sure.
Because I want to ask you a couple of questions about it as well.
Let me see exactly what that G-force was.
Do you need to refer to something
Yes, my report.
with the court's permission?
Yes.
Thank you.
So at 24 miles an hour for the arm, the acceleration is 302 Gs. And for the hand, it's about 435 Gs.
Does that translate to over 4,000 pounds of pressure?
Well, for the arm, it's close to 3,000 if you say a 10-pound weight, and for the hand, that can be anywhere from 800 to about 1,600 pounds of force acting just on the hand itself.
Understood. Can you back this up a couple of frames?
Sure.
Pause it where I ask you. One more frame back. One more back. Right there. What's happening physically to the arm, to the right arm at the point of impact?
So there is a force on the hand, on the forearm where it contacts. Now, your arm just isn't going to hit and the force be distributed evenly across the entire part of the arm. That's not how your arm is actually articulated. Even if it was, again, that's similar to an airbag deployment, where at these levels you would get fractures. But if it hits the hand, now, if Mr. Okeffe's holding a glass at the time of this impact, think about that. What happens is you're holding a glass. It exposes the knuckles. So if you're holding a glass and your arm's at a 90-degree angle and the car comes back and hits your hand, it's going to strike right on the knuckles. The force is going to be applied right at that joint. And then it's going to likely hit along the forearm back near the elbow.
What's the shape of that arm in this still photograph?
Well, it's somewhat of an abnormal shape because the arm should be level with the body. The forearm should be even with the shoulder. But you can see as it gets pushed forward, it's accelerating that forearm away from the arm and the rest of the body.
Does that abnormal shape suggest anything to you in terms of what you would expect regarding the bones in that arm?
Again, there's thousands of pounds of forces acting on the arm and also on the joint itself, not just the arm or the bones we have to consider and how much force to fracture, but think of the elbow joint and think of the shoulder joint. It takes much less force to dislocate an elbow than it does to actually fracture it.
Did you see any evidence based on your review of the medical records, including your review of the x-rays, any evidence of any dislocation?
There was no evidence or indication or diagnosis of any dislocations or fractures to the arm at all.
fractures or broken bones at all?
Correct, nothing.
Can we go forward another frame? And at this point, the arm has already been struck and accelerated, is that right?
That's correct.
Do you see the taillight material?
I do, yes.
Okay, it's basically now broken, is that correct?
That's correct. It has now been fractured, yes.
All right, let's go one more frame forward. And the taillight material, did you make note of that in this frame?
I did, yes.
What direction is that taillight material going relative to the vehicle?
It's going forward.
And where is the arm?
The arm has been pushed away. Now, you have to remember, as that arm, if it contacts and fractures the taillight, it's not exposed to the fractured pieces that still exist on the taillight itself, because those pieces that fracture haven't gone anywhere because they're against the arm itself. And then as the arm moves away, the pieces then move with the vehicle.
Are the taillight pieces upon fracture moving at the same speed as the arm upon contact?
That's correct, yes.
Is that a matter of physics?
That is a matter of physics,
Is
yes.
there any possible way for the broken pieces of taillight to out-accelerate the arm upon contact when the arm's being deflected away from the vehicle?
It is not, I don't believe it's physically possible. That was not demonstrated in our testing, and I've never seen that demonstrated in any peer-reviewed articles. Now, you can see here again also the light and the fragments are being propelled forward. So you also have to consider where Mr. Okeffe was found. He was found in the yard about 10 or 20 feet from the road. There was no exact measurements. But if you look at the motion of the taillight, it's going forward. Now, if Mr. Okeffe has to move diagonally to the top left of that corner, and if he's not hit with the center of mass, he can't get to where he ends up before the taillight fragments have already gone forward and been deposited on the ground. Average running speed is like 4 to 6 miles an hour. Even if this SUV is going 10 miles an hour, the lights fracture, they're dispersed on the ground, and then Mr. Okeffe somehow ends up to his point of rest. But you wouldn't find the fragments on him because they've already been pushed forward, come to rest before he even has a chance to get to where they find him.
Exactly
Let's go to
what
the next
Stephen
slide, please.
Plord told us. Our accident reconstructionist will try to get him back on tonight.
is
I
this
know
slide
you're
showing?
listening, Stephen.
So this is just frames taken from that actual video showing the interaction from the top left, then you go down to the bottom left, and then the top right and the bottom right. Just shows you the progression of the contact and the movement of the arm.
Is the bottom left frame the same frame that you stalled on just a second ago at my request, showing the deformation of his right arm?
That's correct, yes.
Thank you. Next slide, please. And is that just a close-up of the same?
That's just a close-up of the same, yes.
Okay, next slide. And is that a final close-up of the arm after it's been deflected out of the way?
That's correct, yes, sir.
Does this also illustrate what you just described in terms of the trajectory of the broken taillight fragments?
It does, yes, sir.
Do you see any defect at all in the right sleeve of that hoodie?
There is no defect in that right sleeve of the dummy. No,
Was the dummy's sleeve examined following this test? Closely examined up close rather than just a photograph?
It was examined and photographed, yes, sir.
Was there any defect in that right sleeve at all?
No defects at all were noted in that sleeve. No.
Next slide, please.
It's because of
What are
you,
we seeing here?
SkyStar's page. Thank you for
This
the
again,
donation
this
that we're
shows
asking,
some of the
Stephen, so
photographs
thank
taken
you.
of the sleeve and the arm to show that there's no defects whatsoever, and it shows the damage to the Lexus. And again, at 24 miles an hour, not only do you get damage to the taillight on the fender there, but you also get damage to the taillight on the liftgate.
Was there any damage on the taillight of the liftgate in the subject SUV?
There was not, no.
Next slide, please. What are we looking at in this video?
And so this was 29 miles an hour with a suspended hybrid 3-arm.
Was the arm in the relative orientation that you saw depicted in the paint transfer test by aperture?
It was, and in fact, in this one, there's actually contact. We moved it in so that you would get contact with the elbow and the upper arm as well. So it's in the position after Dr. Welcher moves his elbow in and rolls his shoulder into the taillight cover. We evaluated that position with this test.
And do you see any damage to the lift gate taillight based on this test?
There's extensive damage at this speed, yes.
What about the damage to, damage would you expect to see to the arm itself at this speed and in this orientation?
Yeah, at this speed, I mean, we're talking 4,000 pounds of force on the forearm, and with the hand, 1,400 to probably 3,000 pounds. I mean, well above levels where you would get fractures.
Next slide, please. What are we looking at in this slide, these two photos?
This was the final test that was conducted in using a dummy, and it was impacted at 29 miles an hour. And this was a center of mass impact.
Why was it important, Dr. Rentschler, why was it important to do a center of mass test?
Because if we have an auto pedestrian impact and you want to see where the pedestrian ends up, you have to evaluate how they were impacted by the car. In order to have the pedestrian move any substantial difference, it has to be hit at the center of mass. Again, it has to be hit at that belly button area to propel the body in a certain direction depending on the speed and direction. If there's no center of mass impact, how does someone get to the point of rest? You can't correlate a side swipe where the arm gets contacted and say if someone ends up 20 feet away, there's no way to correlate that arm impact caused them to somehow move 20 feet away. It wouldn't be as a result of the actual incident. It wouldn't be a result of the impact pushing their body in that direction.
From a physics standpoint, is it reasonable to believe that your arm could be struck, just your arm could be struck as it's out in front of your body, and you could be propelled backward, say 7, 8, 10, 12 feet as a result of that strike?
No, it's not reasonable. That's not physically possible. And you look at the arm itself, and we're looking at talking about the injuries and the abrasions compared to fractures. So if Mr. Okeffe's arm was hit at 24, 29 miles an hour, what this suggests, and there were only abrasions, what this would suggest is that if the taillight doesn't cover or fracture, you can have your arm hit at 24 miles an hour and you wouldn't have any injuries at all, which from a biomechanical standpoint doesn't make sense. If the claim is that the fractured taillight's the only thing.
So I'm sustaining the objection to that. I'm going to strike that portion, Mr. Jackson.
Let's go to the next slide. What are we looking at in this video?
So here's the video showing that strike at 29 miles an hour with the center of mass impact to the dummy.
Yes, science.
What's the import?
Yes, science.
Of this particular
Yes,
test?
science.
Why was this important?
Yes,
And
science.
what did you conclude following this impact test, the center of mass impact test?
There's a couple of reasons. It shows there was extensive damage to the rear of that Lexus. So if you had a center of mass hit, you would have damage to the liftgate, to the fender, to the sheet metal. You would have substantially more damage than what we had in this case. And secondly, which I believe is just as important, it shows the post-impact trajectory of the dummy. So again, if you're struck on the corner by the Lexus, the dummy goes straight back in line with the vehicle. There's no force and no direction to actually cause that dummy to move off into the side of the vehicle. So you can't be hit center of mass with the vehicle going straight back and somehow end up 10 or 20 feet to the side of where the vehicle is traveling.
So in this circumstance, would you expect the taillight material to be distributed straight back in the same center line as the vehicle is traveling?
Yes, absolutely.
Would you also expect the body to be struck and move in the same center line as the vehicle?
Sustain is
Sure. What about the body? What directionality would you expect on a center mass hit?
The body's going to move in the direction that the vehicle's moving. That main direction, that main force moving straight back, the body is going to move primarily straight back.
Did you reach an opinion or conclusion regarding whether the right arm kinematics are consistent with fracturing the taillight cover and sustaining the abrasions that you saw on John Okeffe's arm?
I did, yes.
What is that opinion?
My opinion that it is not consistent with contacting and fracturing the taillight cover.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please? And if I could have just a moment, Your Honor.
Sure.
You know, the judge is so concerned about time here. She stopped saying, phrase it a different way, phrase it a different way, phrase it a different way, phrase it a different way.
What do you base
A third of the trial
your
would have been
opinion
quicker.
that you just told the jurors?
That looking at the kinematics of the arm, it's inconsistent with the evidence we have, with the actual abrasions to the arm, the evidence on the sweatshirt, and that at these speeds, you would likely expect fractures, certainly to the hand, and likely to the ulna and the radius in the forearm, if your hand or arm was struck by the rear of the SUV.
Can we move to slide 48, please? What are we looking at in this slide?
This was a study where they used an impactor and they contacted the dorsal or top part of cadaver hands. And they looked at the force that was exerted and they looked at how many fractures were produced as a result of that.
Did you review scientific literature regarding hand injuries under this sort of impact loading? Is this representative of that?
It is, yes.
Next slide, please. What is this?
So this shows the position, and this is taken directly from the aperture paint test. You can see the position that Dr. Welcher had his hand against the tailgate right at the time of impact. And you can see that corresponds, the contact areas correspond to the areas of the hand that were actually tested in this case.
Next slide, please. What is this showing?
So this shows the forces produced during the test as well as the forces produced during our testing. And maybe the next slide here actually better. If you look at the knuckles, which are the blue middle region, and then the metacarpal bones, which are the lower one. So for the metacarpal phalangeal joint, the knuckles, on average, it took 397 pounds of force to fracture that joint. Well, the 15-mile-an-hour test produced a minimum of 483 pounds. And more realistically, that's just with the hand weight. There's going to be more weight because it's attached to the wrist. More realistically, it's twice that, so it's around 900 pounds of force. But what these tests show is that the force produced on the hand, as represented by the PowerPoint from Aperture, even at 15 miles an hour and likely below that, you would expect to get fracture of the hand bones, of the knuckles, metacarpal interphalangeal joints, and the metacarpal bones if you contacted the rear of that vehicle at that speed.
Did you see any indication in the x-rays you saw or the medical records that you reviewed that Mr. Okeffe's hand was damaged in such a way that you would expect?
There were no indications whatsoever of that, no, sir.
Next slide, please. What are we looking at in this slide?
This was a test where they actually looked at the force on the elbow. So this is a direct longitudinal force against the elbow. Now, there's no indication of exactly the paint test has the arm horizontal, but there's no indication, there's evidence of whether maybe it would be angled or if it's straight horizontal. But even if your arm's angled a little bit at the point of impact, the forces, again, on the right are what we determined from our testing, and those are minimum. Again, that's just with the forearm. If you include the entire arm, it's about twice that. So even at 10 miles an hour, you're going to have 600 to 1,200 pounds of force acting on the arm.
Is that enough to break it?
That's enough. If you strike the elbow, that's more than enough to actually fracture the different bones of the elbow.
If an arm was hit at that speed with those forces, would you expect the x-rays to show no trauma, no broken bones, no fractures, no hairline fractures?
I would not expect that, no, sir.
Next slide, please. What are we looking at in terms of this slide?
This is a great presentation.
So these are just more articles that I referenced, and they look at impact force on the forearm, so the ulna and the radius. It takes, just to have a transverse blow right against the bone, it takes about 1,100 to 1,200 pounds of force to cause a fracture. We're at that level already at a 10-mile-an-hour impact.
What about a 24-mile-an-hour impact?
24, we're at 1,400 to 2,800 pounds of force.
Did you see any trauma on John O'Keeffe's arm that was suggestive of an impact of that nature, of that size, of that force?
There was no trauma. There were no fractures. There wasn't even an indication on the arm of where it would have contacted the vehicle. So if there's fracture at the taillight, there's going to be a force at that point on the arm where it actually contacts the taillight and causes that, right? There's going to be a force riser to cause that damage. There was no bruising. There was no lacerations. There was nothing at the alleged point of contact which would indicate an impact that produces thousands of pounds of force on the arm. No evidence of it whatsoever.
You just mentioned this in your answer, but I want to ask a little bit further. We've talked a lot about bone fractures and ligament damage, et cetera. What about bruising? In any of these tests, would you expect to see bruising, at least bruising, all over the arm at the points of contact?
Absolutely. Bruising occurs when the blood vessels just below the skin are ruptured, and it causes blood to flow into the arm.
Was there any indication that John O'Keeffe suffered even a minimum amount of bruising on his arm at all?
No indication of any amount of bruising whatsoever on the forearm.
Next slide, please. And let's go to the next slide. I think we want to jump to slide 50.
You know, it just makes sense. You're hit by a 6,000-pound SUV. You're supposed to have bruising.
This is 55.
And broken bones. And all this now, the whole fractured taillight
Let's go to
makes
the next
so
slide.
much sense to me.
There we go. That's what I'm looking for. What are you looking at here?
So this again is from the paint test, and it shows, you know, even as the arm gets pushed in, the vehicle's not in line with the center of mass with Dr. Welcher here. So it's not a center of mass impact. And this is important because we've just looked at the arm, and we've looked at the kinematics and the force and whether that's consistent with what happened and the injuries. The next step is to look at what happens if the arm gets hit. How does Mr. O'Keeffe end up where he does in the yard? So that's post-impact movement or trajectory of the body. You have to evaluate that if you want to link all these events. If you want to link the head injury to contact with the car, you have to know what happened in between. You have to know the details. And so the next part was to evaluate that.
Is there any indication in any of the testing that you did or any of the review of the medical records medical records of John O'Keeffe, including the autopsy records, all of the autopsy records, the x-rays, and the hospital records, any indication that John O'Keeffe was struck center of mass?
None whatsoever. No indication at all that he was struck center of mass.
Do you have an opinion or conclusion to a reasonable degree of scientific certainty about whether he was struck center of mass?
I do.
And what is that opinion?
I don't believe that he was. The evidence indicates that he was not. If he was struck center of mass, imagine that. You're getting hit at the pelvis. You're getting hit on the thigh. You're getting hit at the knee. And then the body's being propelled forward. Your arm would get pushed into your body, into your ribs, into your torso. You would have very significant and substantial loading to your body, initially the right side of your body, as that impact occurred. And there's no evidence whatsoever that occurred.
Switching to a glancing blow, a blow of just the arm, not the center of mass, but just the arm. Do you hold an opinion and a conclusion as to whether or not a glancing blow or a blow to the arm only would propel Mr. O'Keeffe 7, 8, or 10 feet perpendicular to the line of travel of the vehicle?
I do.
What is that opinion?
It would not be possible. Our testing demonstrates that. The peer-reviewed articles demonstrate that. I've seen no evidence anywhere in this case that would suggest or even indicate that if you get a glancing blow or a sideswipe blow, that somehow would produce enough force to push you 8 to 10 feet into the yard. I don't believe it's possible. I've seen no research that would indicate that would occur.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please? And let's go to the next slide. Let's keep going. Okay. What are we looking at in this slide?
So this slide, it's a paper that describes how to evaluate vehicle pedestrian impacts and how someone moves in the projection of that body.
Did you seek to analyze a fulsome understanding of whether it was possible that Mr. Okeffe was hit on his lower extremities?
I did, yes.
Why did you do that? Why was that important?
Well, because with automobile pedestrian impacts, the lower extremity, your legs, your ankles, your knees, that's the most injured part of the body during autoped impacts. So if he's going to be impacted at that speed, especially center of mass, there's likely going to be injuries to his leg, to his knee. The bumper lines up with the knee. That's one of the most commonly injured parts, is the bumper pushes into the knee, fractures the tibia, the fibula, or damages the knee joint.
Did John Okeffe suffer any injuries to his lower extremities suggestive of a vehicle impact?
No, I believe the only injury was a 0.5 centimeter abrasion on the outside of the right knee.
Could Mr. Okeffe have suffered a 0.5 centimeter abrasion on the outside of his right knee by being struck by an SUV at 24 miles an hour?
I don't believe so. I don't see how those kinematics would work.
Sustained.
Do you have an opinion as to whether or not that injury was from being struck by an SUV at 24 miles an hour or somewhere around 24 miles an hour?
I do.
What is that opinion?
I do not believe that injury is consistent with being struck by an SUV at approximately 24 miles an hour.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes.
Did Mr. Okeffe suffer any other injuries to his legs or his lower extremities other than that small, how big was it? How many centimeters?
0.5 centimeter abrasion.
That small 0.5 centimeter abrasion. Did he suffer any other injuries to his lower extremities indicative of being struck by a vehicle?
I don't believe so, no.
Okay. Let's go to the next slide. Taking a look at the photograph on the right, concentrating on that for a second. How did that SUV get in that condition?
That was by striking the dummy at 29 miles an hour, and that was a center of mass hit with the dummy.
Were you able to review photographs of the subject SUV, Ms. Reed's SUV?
I was, yes.
Did her SUV suffer or suggest any kind of damage anywhere close to this?
No, the only real damage was to the outer taillight cover on the fender itself was fractured.
Next slide, please. We've seen this. This is the video that was the center mass impact.
That's correct, yes.
The photograph that we just saw previous, what relationship does that photograph have to this field test?
That was the condition of the SUV after it struck the dummy here at 29 miles an hour.
Can we go to the next slide, please? What are we looking at in this series of diagrams?
So this is some more recent testing that was done, and this test compared impacts between a small sedan and an SUV, and show it's looking at damage or injury to the legs as a result of this type of an impact. And these impacts are actually conducted at a speed of 24.7 miles an hour. They used cadavers, people who donated their bodies to science, set up the cadavers and struck them at just about 24 miles per hour.
Did this support your opinion and conclusion concerning the lower extremities of Mr. Okeffe and the possibility that he was hit by an SUV at speed?
It does. If I can go to the next slide, it actually.
Sure.
So this shows you for the SUV, it's the last column on the page there. The last 3 columns are the injuries associated with the SUV strikes. There's fractures to the pelvis, left knee injury to the ACL, the MCL, fracture of the tibia and fibula. There's extensive damage to the legs of all 3 of the cadaver subjects that were struck at 24 miles an hour with an SUV.
Did Mr. Okeffe show any signs of any of these injuries?
He did not, no.
Next slide, please. Is this, what are these photographs and diagrams on the right?
So this was taken from the PowerPoint from ARCCA. And so it shows that the medical diagram shows the 1.5 centimeter abrasion. And if you look at the picture on the left of the surrogate, you can see, so the bumper would line up from the knee all the way up to the pelvis. So a vehicle at speed of 24 miles an hour, if it impacts that knee or that leg, it's not going to produce only a 0.5 centimeter abrasion. It's going to get the leg, and it's going to cause significant damage to the knee and to the leg itself.
When you say from the knee to the pelvis, are you talking about the width of the, or the height of the bumper itself being from the knee to the pelvis?
I am, yes.
Would that be the contact area that you would expect if there was even a glancing blow to the knee and the hip?
That's correct. You can see on that picture there where that bumper, the rear corner of that bumper, where the bottom reflector is, it extends from the knee all the way up to the pelvis.
Can we go to the next slide, please? What are these diagrams?
Again, these are just reports, peer-reviewed articles demonstrating that auto pedestrian impacts result in lower extremity injuries and fractures.
Did you review all of these peer-reviewed articles that you've told the jurors about, these academic articles, in furtherance of coming to your opinions and conclusions?
I did, yes.
Did you see any reference in the ARCCA report that you reviewed and the PowerPoint slides that you reviewed that the concomitant peer-reviewed articles were sought in the paint transfer test?
No.
Or cited?
There was only one article that was cited in that report with respect to automobile pedestrian impacts.
Did it have anything to do with the paint transfer test?
It did not, no.
Next slide, please. And let's keep moving until we get to the, yes, there we go. What is that slide depict?
So this is the opinions that were offered in the ARCCA report. And if you look at the top, number 4, it says the totality of the evidence is consistent with the right rear corner of the Reed Lexus, again, impacting John Okeffe and Mr. Okeffe striking the rear posterior aspect of his head on the frozen ground. And when you look below that, it basically has the references or the support for that one conclusion.
I'll see you both at Sidebahhh for a minute.
Okay, here we go. It's Sidebahhh again. Okay. He's documenting that ARCCA only put in one article supposedly supporting their Blue Man Tube, as I call it, test. Oh, I probably just defamed Blue Man Tube. Their Blue Man Group Tube? No. Their Blue Tube? No. Their Blue Paint Test. Okay, we'll just leave it up, Blue Paint Test. And he wants to show that that's the only thing documented, because when you're doing your report, you're putting in the literature that documents, at least if you are a biomechanical engineer. And so he wants to go through that report that's cited is not actually supportive of the conclusions that ARCCA reached. So, she wants to see them at Sidebahhh, please. You can't hear the objections from Hank, so I'm not sure if that was an objection or not. Okay, let me just go to some questions. Mrs. R. Linda, how do you think the jury will feel about all of Hank's objections? It's obvious the Commonwealth is trying to hide the truth. I think the defense is going to hit upon that, and they're going to argue that they hid everybody from you. They're not going to get the jury charge that they're asking for, but they're going to argue that. I don't think the jury likes it. They want to hear the evidence, and Hank objects all the time. Okay.
Dr. Rentschler,
go back into court.
Can we move to slide?
Obviously, AJ lost that because now they're moving to slides. Okay.
Just a moment, Your Honor.
70, Mr. Jackson.
That's what was. I was just looking at. 7. Thank you. I wish my eyes were better.
Don't we all? Michelle James, I just can't see how else you can come back from this. How can you argue against science? I agree with you. If I were him, I wouldn't come back. But, he's an egomaniac, egotistical maniac, I think. No, here. He's probably not that. And look, he's an expert, and he's going to try to say that his opinion's right. I just think that this testimony is so powerful, so easy to understand. And I am not into physics, but boy, Dr. Rentschler has made me love
Thank you.
physics.
Okay, what are we looking at in slide? This is slide 7. Yes. What are we looking at in slide 70, Dr. Rentschler?
So this was the one article that was referenced in the ARCCA report with respect to automobile pedestrian impacts.
So he
And
did
there
win
was
it,
a
but he
chart from
wanted
there that
to
was
show
referenced in the PowerPoint
the article.
that
Okay.
indicates the head's the most commonly injured body region in pedestrian impacts.
And what significance did that reference have in your analysis?
Well, that's not accurate. This article was written in 1979. And the first modern SUV, the Jeep Cherokee, wasn't manufactured until 1984. So this is an article that's 46 years old that doesn't actually relate to this type of an impact. And that's the only peer-reviewed reference with respect to automobile pedestrian impacts that was cited in the entire ARCCA report.
Can we move to slide 71?
Boom. So what
Do
she
you recognize
objected
what's
to was
depicted in
showing
this
the whole slide,
I
not just
do,
the
yes.
article.
What is depicted here?
So this was a hybrid. This is the 50th percentile hybrid 3, the same dummy that we utilize. And Dr. Welcher performed a test where
Can I interrupt you?
Sure.
So this ATD, anthropomorphic test device,
Yes.
was not a 95th percentile test device?
It was not, no.
It's a 50%?
It was a 50th percentile, yes.
Is that the same exact, not the same exact, same exact sized ATD that ARCCA utilized in all of its testing?
It was, yes.
Okay.
And to get the forces on the head, Dr. Welcher scaled the acceleration results based on the weight, which is what I was talking about yesterday. You scale the results from the 50th percentile. That's exactly what Dr. Welcher did in this case.
Is that an appropriate way to adjust for the size of an ATD?
It absolutely is, yes.
Okay.
There
Go
goes
ahead.
Hank
So
Brennan's
this
cross.
test, what he did, he took a 50th percentile dummy, stood it up, and then let it drop backwards and strike its head on a concrete surface.
Next slide, please. By the way, Dr. Rentschler, did the last slide include a video?
I believe it did, yes.
Can we go back?
Or I'm not sure it's on this slide. That's just a screenshot.
I see.
Yeah.
I see.
Yeah.
Okay, so let's go back to that slide for just a second. I thought this might be the video of it.
Oh.
So in the lower portion of the center of the screen, you see Dr. Welcher holding the ATD. Is that correct?
That's correct.
Did you review a video of what happened next? This is not the video, but did you review the video?
I did, yes.
Describe for the jurors, since we don't have access to the video, what did you see happen from this point forward?
So Dr. Welcher releases the dummy, and the dummy just falls rigidly backwards, almost like a tree, and impacts the concrete.
Can we jump from your PowerPoint to a video that I have and ask you if you recognize it with court's permission?
Is the video in evidence?
It's in Dr. Welcher's PowerPoint.
Is it before the jury? Is it in?
It is.
Okay.
It shouldn't matter if he reviewed it to come to his conclusions, whether it's in evidence or not, if it's something Dr. Welcher relied upon. But that's just a legal technicality. We don't get into legal
Okay.
technicalities in this
Do
court.
you recognize this?
I do, yes.
Is this just look like the same screen, basically same thing that you just took a screenshot of?
It is, yes, sir.
Okay. If we could play the first couple of seconds of the video and pause it. As that video began to play, did you recognize this as being the same video that you reviewed earlier?
It is, yes, sir.
And did you utilize this in coming to your opinions
I did, yes.
and conclusions in this case?
I did, yes.
Thank you. Let's go ahead with the court's permission. Can we play the video?
Yes.
Thank you. What did you see? Describe what you saw in this video.
So this is a passive rearward fall of the ATD dummy. So just releasing and let it fall. Obviously, it's a dummy. There's no musculature. There's no response to that dummy. So this is what would happen if a rigid individual just fell backwards onto a concrete surface.
Can we see it one more time, please? I want to ask you one other question. I'm going to ask you to take note, Doctor, of the impact location. Did you see that?
I did, yes.
What kind of surface is that floor, if you can tell?
That, I believe it indicates it's a concrete surface, concrete floor.
Did you notice if the falling backward like that, the dummy slid across the floor or was propelled across the floor, anything like that?
It did not. It just dropped and angled backwards and hit directly on the floor.
Okay, let's go to the next slide. I'm sorry, if we could revert back to your PowerPoint. And if you could pull up slide, I think it's 72.
Let me, every time we do that, I have to restart the PowerPoint. Okay.
Why did you include this video one more time in your PowerPoint here?
Because again, this is the pain test, which indicates the position, at least that Dr. Welcher had himself at to get the impact with the taillight cover. And notice, again, so it's not a center of mass hit. It hits his arm and then he slides by. So if that were to occur, he would rotate or move to the left. So if Mr. Okeffe did that and somehow ends up falling backwards, rigid directly onto his head, he's going to have to rotate at least 270 degrees and then stop and then fall directly backwards onto his head. There's no explanation of the kinematics.
Sustained is to the end of that. I'll strike the end.
Do the kinematics support what you just suggested?
Objection.
Sustained is to form.
What do the kinematics support?
Objection.
I'm going to see you at Sidebahhh for just a minute.
Okay. This is why the trial's
Joyce will be
taking
taking
so
a-
long. Okay, they're going to take the break. Okay. This is the expert. He's allowed to say what his opinion is on what the kinematics on a report he's looking at will say, what they should say. Okay. All right. And one, there's an objection. There's an objection. Ask it differently. Then he asks it differently. Then the judge wants to see them in Sidebahhh. All right. If we are taking so long, and this judge is always concerned about time, it's because she keeps sustaining all these, shall we say, one objection may be okay. But then when Alan Jackson does what she wants, which is what she don't really need to do, but it's what she wants, and she's the judge, you have to follow her lead. She then sustains another objection. And then when he asks just an open-ended question, because it is a direct testimony, she wants to see them at Sidebahhh. Okay. It's mind-boggling. Okay. It's mind-boggling. And this is why there is such a rift, I believe, for people watching this case, that everyone now is really, really concerned about the unfairness that is being projected out to the world about what is happening in the United States of America. For the defense to try to get their case in, she tried to cut them off at the knees. Every single time there was a motion, it was granted. Even Dr. Russell, who she now credits was a close call. And then she says Dr. Russell testified, and then Dr. Laposata can't testify about bite marks, not for any reason, maybe cumulative, which I don't think would have been sustained objection, because you're talking, the forensic pathologist is talking about wounds on a dead body, not wounds on a live body that's seen in the ER. The same with the brain guy. He doesn't see dead people unless he ends up contributing to their death by not being able to save them. I'm not blaming him for people that die that come with tumors, but then they get they're dead. They get put in a body bag and sent to the hospital morgue. All right, so he's not dealing with that. And then we get here. We have real experts on the stand. There's no doubt, and she knows that these experts were hired by the Department of Justice and the FBI. She knows that. They are independent. They were independent when they were hired, and you can see how good they are. And I've always thought Dr. Rentschler was the key to this case, along with the forensic pathologist, but especially Rentschler, because it shows, and that's why, by the way, when all of you were concerned about the testing and why did the defense do the testing that shows the taillight could fracture at 24 miles an hour or 29 miles an hour if it was hit by an arm. It shows that if that arm was there a side swipe, or even on the leg, you would have these incredible injuries. You'd have fractures in the hands. You'd have fractures in the wrist. You'd have fractures in the forearm. You could have fractures, dislocation of the elbow. You could have dislocation of the arm. The injuries would be severe. And that the only article that Dr. Welcher, it turns out, cited for his support of the blue paint testing, which really didn't have anything to do with blue paint testing, was a 1979 article that was before the modern SUV in 1984 was invented. And if you look at your SUVs now, they're gigantic. They're big. I took a picture and posted it on my Instagram page of Tubi the poodle and I. We were walking out one day and there was a Traverse. I always thought the Traverse was small. It was huge. It was, it was taller than me. Tubi looked like he was a miniature peanut, even though he's a 50-pound standard poodle with some height to him, right? They're huge. You all know when you look at trucks, right? The old American truck was small. You see the old trucks that we see them going down the highway for shows. You look at the F-150s now, you need at least I need a step stool to get into them. They're gigantic, they're huge. And that's why if they have a pedestrian impact, you usually have a death or certainly have severe injuries, okay? Even with cars hitting one another, because the cars are ginormous, all right? Now, for her to limit in any way, this expert is wrong. And again, it just goes to the bias we've seen. So let's go back into court and let's see what we're going to do before we take the mid-morning break.
May I continue?
Yes.
Thank you. Dr. Welcher, based on your review of everything.
Rentschler.
Did I do that again? My goodness. This is Dr. Welcher in the video, correct?
Correct.
All right. I was staring at that. I apologize. Dr. Rentschler, based on your review of the video in which Dr. Welcher is positioned, as well as the drop test that you saw, as well as the discussion of the body placement, where you discussed the body placement. Do you have an opinion as to whether or not the testing that you reviewed from ARCCA is consistent or inconsistent with John Okeffe being struck by the vehicle, propelled perpendicular, backward, say 7 to 10 feet, and falling straight back onto a hard surface, as depicted in the drop test?
The testing's inconsistent with those types of kinematics or that type of scenario.
On what do you base that opinion, sir?
That's based on the testing that was performed, the evidence available in this case, and the kinematics of how somebody would move post-impact after being struck by an SUV.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes.
Can we go to the next slide, please? May I have just a moment, Your Honor?
Yes.
So now Alan asked the question just a little differently, but he gets the same answer that we just spent, 7 minutes between a sidebar and the objections to get where we were going anyhow, if the judge just allowed a little bit of leading here to know, because she knows what the answers are, okay? And quite frankly, this happens every single time. Alan, she tries to disrupt, in my opinion, and along with Hank Brennan, Alan
Finally,
Jackson's rhythm.
Dr. Rentschler,
Let's
do you
go.
have
This
an
is
opinion,
finally.
or did you reach a conclusion whether the biomechanical evidence in this matter is consistent or inconsistent with Mr. Okeffe's right arm being impacted by the subject 2021 Lexus 570, resulting in a backward fall leading to the head injuries that he suffered?
I did, yes.
And what is that opinion?
My opinion is that the evidence is inconsistent with Mr. Okeffe being struck on the right arm by the SUV and then moving laterally into the yard and falling backward onto.
And do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Thank you. That's all I have, Ron.
Okay. So now we'll take our break, folks. We'll see you in about 20 minutes.
Please rise for the jury. Jury break this way.
Okay.
You are muted.
Now we're going to take our break. So I want to see what you are all thinking, because I know what I am thinking. I haven't had a chance to post anything on X because obviously I have been answering all of your questions. But basically, we now know that there's no possible way that John O'Keeffe's injuries on his right arm were caused by a run-in with Karen Reed's SUV or any SUV for that matter, whether it be at 15 miles an hour, at 24 miles an hour, or at 29 miles an hour, right? We know that. Alan Jackson went through so many scenarios to reinforce it. And, you know, you have a thing when you're a trial lawyer, you tell the jury what you're going to tell them, you tell them what you're telling them, and then you tell them what you told them. And by going through all the different scenarios with kinematics, with the size of the dummy, with the rebutting Welcher's presentation without saying I'm rebutting Welcher's presentation, it all kept reinforcing the fact. And to me, the most important thing was, you know, if you hit, remember, Welcher tried to use the clothes of John O'Keeffe. This sweatshirt only had 9 holes in it, right? 9 defects in the right arm. The arm had, as Dr. Rentschler counted them, over 30 defects in it. So the sweatshirt did not match up to the defects on the right arm. So, you know, if you're getting a dog bite, the jury's thinking, right? If you're getting the dog bite, you know, the dog will grab onto you, move, your arm moves up, you're pushing things away, and that's more consistent with the clawing and the dog and all. So it's much more consistent with that. And in fact, matter, I expect that at the time we get to closing, what you may see that some of the punctures in the sweatshirt may actually line up with the punctate wounds in the arm. Okay. I'm thinking that, and I haven't taken the pictures and looked at that. It's kind of hard because we don't have them in real time or real measurements. By the way, Dr. Welcher also measured specifically the approximately half centimeter bruise on the right outside of the right knee. So touch your right knee, the outside of the right knee. First of all, it's inconsistent with the way the prosecution says the car strike happened. But secondly, it's only, if you convert that to inches, it's 0.1965% inches, 0.1965 of an inch, not percent, of an inch, right? If you're hitting by the SUV of that ilk, of that size, you're going to get a big bruise. And likely, if I'm the jury, I'm thinking, your knee is going to get fractured from the side. You're going to have something that happens. You're just falling down right there, right? I mean, we all don't want to be hit by a car, all right? And we've seen people even accidentally drive into their loved ones in the back of a driveway at a very low rate, and they get hit by a car, down they go, and they're dead, all right? So I think there's a lot of common sense that the jury is also going to take about this, and that's why Dr. Laposata, when being questioned by Hank Brennan about the speed, 24, 29 miles an hour, she says, it doesn't matter what the speed of the SUV, he wasn't struck by the SUV, so it is irrelevant. And we have heard the final, what I think is one of the strongest witnesses, maybe the strongest witness in the defense case right now, and a good witness to end up. And we now also see why the defense made the strategic decision to start with Dr. Wolf, who just deals with the car, right? And then it kind of lays the groundwork. Then we go to Dr. Laposata, who gives you the forensic pathologist viewpoint, which actually supports the forensic pathologist in a way of the state, right? Because she said that she did not see any injuries consistent with a motor vehicle strike. She said that on the stand. That's why she ruled it undetermined, right? She ruled it undetermined whether it was a homicide, because she didn't see any injuries consistent with the strike. So Dr. Laposata actually supported the medical examiner, Dr. Scordi-Bello. Wolf supports Rentschler. Rentschler supports Laposata, Wolf, and Dr. Scordi-Bello. Okay, so those witnesses the two witnesses that are the only people that can talk about how injuries occur and what causes death in the state of Massachusetts legally are the two doctors who are forensic pathologists. They're the ones who are board certified in dealing with people that are dead, not some gamma ray surgeon guy from Florida who only wants to talk about a contra coup injury and, I could have saved him, because he didn't have all of the information. And quite frankly, to me, again, and maybe because I'm married to a forensic pathologist, Dr. Michael Baden, who's both board certified. And as you know, he broke the Sandra Birchmore case. He practices. He's helped the Innocence Project. He just received last year the award for his 30 years of pro bono work with the Innocence Project, helping to free the guilty for failures of forensic pathologists, and testifies in a number of cases, whether you like his opinion or not. He's going to tell you how he sees it, how he calls it, just like we try to do here, tell you how we see it, and we call it as we see it. Okay. It's amazing to me that the prosecution is going after this. And what they want the jury to conclude is what they want the jury to conclude. Thank you for saying my husband is a national treasure. I think he is. I think that he's made everybody his whole life. He's trying to make everyone aware of the importance of forensic pathology. And when people say, oh, or whatever, it's no different than he's operating on somebody who's dead when he does an autopsy. Doctors go in, they do plastic surgery, which I love, by the way, don't get me wrong. Okay. They do plastic surgery. They do heart replacements. There's blood all over everything. There's not much difference of what happens in an operating room, what you see, than what you're seeing with somebody dead. And I would argue to you, it's just as important, because people are left backwards or left with their loved ones who are suffering tremendously. And the forensic pathologist can shed some light. As Dr. Laposata said, and I thought I've never heard that before, I'm the last doctor that my patient's going to have and that the family is going to talk to, right? So whatever that is so important to treat with respect. And that's why when Hank Brennan went, the brain is like, isn't it like tofu? Probably given it to him by Dr. Wolf, it would seem to me, she said, oh, gross, because people who deal with death day in and day out would never talk to a family and say, oh, the brain was like tofu. Never in a million years would that happen, ever, okay? And so now we have Dr. Rentschler come in, who does the science. So the reason why, because you're all talking, oh my God, we now know the taillight could break. But if the taillight fractures, it's going to cause a lot. First of all, the car strike is going to cause injuries. And the taillight would not be embedded in any way in the body, right? The taillight goes with the car and the momentum, okay? The body, it's not going to go with the body. And if it does go, it's going to go straight backward, separately and apart from the body. All right. So we heard the science behind all this. By the way, I do see Sky Hopper is in our chat. Hi, Sky Hopper. I hope you're doing better. I mean, we worry about you here at Justice Serve TV, because we know that apparently you broke your foot. You fell out of your wheelchair and broke your foot the other day, but now you're better and you're back. And I'm so glad that the school and people are interested in watching this, because if you listen to Dr. Rentschler, this is what you want to grow up to be. I want to grow up to be him, a gentleman, honest, educated, able to explain things. And even when Alan Jackson kept getting his name wrong, he didn't say, my name is Rentschler, and since you can't remember my name, I can't remember the answer to your question. I bring you back to Officer Dever, who said that to Alan Jackson. People mispronounce my name all the time. They say they spell it wrong. They say Kenney without the E. I was on Fox Nation. They forgot to put Kenney in, which my name is Kenney Baden, because I've practiced under Kenney for so long. Most of my opinions that you see say Linda Kenney. Married Michael, obviously, later in my life. So now, and people always pronounce Baden wrong. They say Baden, or they say Kennedy, or whatever. Do I get angry? No. I'm so glad they're speaking to me. yeah, I could care less. And I may correct them, and I may say, okay, is it possible maybe next time you could use my whole name, because that's my whole name? All right. But you don't attack people for that. I mean, so I'm hoping, and I don't know if it became as clear with Dr. Rentschler, that and I'm not sure, and I don't remember hearing it, that he was hired by a third party entity. I guess it did. I guess it did, because Alan Jackson asked him yesterday, you weren't hired by an insurance company, right? Because they learned from the first trial that the jurors thought that the third party entity that hired them was Karen Reed's insurance company. See, I think the judges made a mistake not letting them say that they were hired by the DOJ, FBI, because I think it goes to their credibility. Now, somebody may say, oh, well, maybe it doesn't. People don't like the DOJ, FBI. Well, that's one thing. But I think you have to tell the jury the truth. And this facade that we are doing in this courtroom, that we're going to hide this and we're going to, and by the way, I'm sure Judge Beverly Kenney wasn't happy with Dever so much when she blurted out, let me count it for you, FBI, 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 FBI. That was 13 times she blurted that out. So I'm sure that after that the jury, when if they put two and two together, because juries become very smart, and if they're not smart already, they even become smarter when they sit on a jury. People just want to do the right thing generally, unless they're a stealth jury and have an ulterior motive in there. They want to convict Karen Reed, or because they want to write a book, or they want to be a hero, or they want to be on Good Morning America or something like that. So I think that that jurors get it. And I think if a jury didn't put together that Jennifer McCabe lied to the FBI, or that Kerry Roberts came clean to the FBI after Dever's testimony, and that it was a third-party agency, must be the FBI or some law enforcement agency that hired them, independent of the Massachusetts State Police or the Commonwealth or what all. They have to put that together, even if it's not said. So if they're going to put that together, why not tell them and say, however, you can allow yourself to, when you're reviewing their testimony, discussing the testimony, determine whether or not there's any bias by who they were hired by, but you are to infer nothing else by the fact that they were involved in answering the question of whether or not the SUV hit John O'Keefe. And remember, that was their charge. Did Karen Reed hit John O'Keefe with her SUV? And ARCCA concluded no. They concluded no the first time. Now, the second time, they do this testing, and the reason why they do this testing is not only they concluded no, because in response to the testing that Judson Welcher did with his blue arm and just pushing the elbow into and rolling, right? They did actually lab tests, and they did dynamic tests to show and not hide anything to the jury. This is what can happen. But if indeed the taillight does get fractured, there's going to be an awful lot of damage to the arm, not through the taillight, not because of any taillight breaking, but just because of impact to the body of John O'Keefe. And he's not going to be found at the flagpole, because that's not how the physics works. So I think it's a slam dunk here for the defense. Although when you're speaking about a jury, nothing's a slam dunk, because the danger here is that once one or more jurors could say, as apparently they did in the first trial, she was driving, having had a lot of vodkas, although it seems to be that's what everyone does in that town. She wasn't in complete control of her emotions, because she was pretty pissed off, angry that John O'Keefe went inside and left her and never came out of the house, and that therefore she sped away with reckless disregard of not realizing that she actually had hit him, and then he died in the snow. Not left to die, but he died in the snow from the impact. And that's, if the jurors want to do that, they will ignore all the other things that suggest that that didn't happen. Now, Let's go to the top of the charge. You know, this case was overcharged. This case was charged as a murder. The fact that she made like 50 calls to him shows that it's not a murder because she thought he was alive. And the fact that she was pissed at him for not coming afterwards, so what? Okay, we know the relationship was on and out, but it wasn't that she was going to kill him. She was going to sell her house in Braintree. She was going to look for a place in Tiverton, Rhode Island to live because she always wanted to live on the water. And then she was pursuing possible relationship with Higgins, but apparently that didn't go anywhere. But that doesn't mean that John Okeffe wasn't pretty annoyed at her and Higgins. And it doesn't mean that Higgins wasn't annoyed at John Okeffe because, you know, they were both drinking also. You heard how many whiskeys. And, you know, we saw that there was a little bit of something or other going on at that bar, all right, the Waterfall. And then they go back to Fairview, all right? So you still have to have, and I said this in the first trial, I thought the defense had made a mistake in the first trial by not saying that there was no collision. And in this case, they're going, no collision, no collision, no collision. So it does not matter what happened. The rest of it is all irrelevant if you take the science. The science shows there is no collision. And the prosecution has no answer for the dog bites, right? They had no answer for the dog bites. The closest they got was improperly asking, and the judge allowed it, that there's a report from some forensic pathologist from the Armed Forces Institute that says that he doesn't see that those are consistent with dog bites. But the prosecution didn't bring him in to testify. It was absolutely wrong that the judge allowed that in, just like it was wrong that she allowed the DNA in on the recross of Dr. Marie Russell, okay? It was so wrong. And that, quite frankly, also, I think all of these things put together are reversible error if you get to that point. But you don't want that because you don't want to spend 10 years in jail waiting for an appellate court to possibly say the trial court made an opinion there, right? Or made a wrongdoing, especially since it appears as if this judge may be going upward to the appeals court or upward to the top court in Massachusetts, since she's considered a player, right? Since she's considered a player. Now, you know that to get to, we're not stupid, that to get anywhere in life when there's a political situation, when there's an appointment, you have to be good with the pals. You need the support of the police and the police unions. You need the support of the politicians. You're not getting a big job on an appointment unless you have that support, all right? So that's another thing that gets in the crawl, I think, of everybody, because we now have, although when I go to cases, and we all go to cases, we all assume the judges, if we have a civil case as a plaintiff, are going to be against us, and we assume when we're trying a criminal defense case, they're going to be against us. Now, we saw some change in that and the view of defense attorneys in 3 trials that we have covered since we have been on the air, okay? One is actually, we weren't actually on the air. We were still at Law & Crime hosting, a couple hours a week, Michael, Bryant, and I. Alec Baldwin case, when the judge found out that there had been a Brady violation, that the prosecution had kept some of the bullets and marked them under a different evidence marking so the defense wouldn't know about them, it looked like a different case, she dismissed that case. It was irrelevant whether or not they would have had effect on the verdict or not. It was a Brady violation in terms of giving over what you have that may be exculpatory to the defense. And she dismissed it. And apparently the special prosecutor there got herself into deep doo-doo, as we say, all right? And some charges, if I recall, about whether or not she had acted ethically and responsibly. And then that was great. And then we saw Joe Tacopino, and we broke a number of exclusives with Joe Tacopino. We should get him on the Weinstein case, by the way. It looks like that jury's hung the last time I looked. Joe Tacopino with the ASAP Rocky And the judge there, he was great. He was in the background when they're taking pictures after not guilty, just smiling. He ruled fairly all the time. He was terrific. And so we're like, wow, maybe things are changing. People are respecting defense attorneys, and the judges seem to be, these judges are great. And of course, then we had YSL for almost 2 years, had Judge Glanville and Adrian Love. And Judge Glanville was terrible to the defense. Threatened to put threatened to put Brian Steele in jail because he wouldn't reveal a source for the judge's misconduct of having a witness in chambers alone with the prosecutor. And as I said, you have to be willing to take that jail sentence if you're going to represent your client, right? And that went up to the Georgia court with our friend Adrian. Our friend Ashley Merchant representing Brian Steele, along with Brian Steele's wife, and the court reversed. And soon after that, of course, Glanville was replaced by Judge Paige Whitaker, who considered, and people were, you heard Young Thug say, thank you. So, and you heard Doug Weinstein, everybody loves him. He wouldn't take even the deal, and he got the whole not guilty on that with it. He was so sure that his client had not done anything wrong, and he and the client were right, and the jury was great. So we saw 3 terrific judges. By the way, let me just interrupt this for a moment of shopping, a breaking news of shopping. Joanna got us. Thank you, Joanna, for the donation. I got my hoodie just now, and I love it. Which coloration did you get? Did you get the one I was wearing last week, which I'll probably wear Thursday or Friday? Did you get that one with the pink and the green? Or did you get the camel, which is the next one I'm going to order? Or the green stripe, which is the third one I'm going to order? Which one did you get? I also had the white one, but I gave it as a gift to somebody who had been on our show and donated his time for our show in the animal. I gave it to Donnie Moss as a gift for the, remember we did the show for all the animals hurt in the fires, and he donated a lot of his time as an animal rights activist. And by the way, I just want to tell you something about Donnie. I know I'm digressing, but Donnie's as a vegan. He's an animal rights activist, has his own group called Their Turn, and he actually like a 2 to 5 year campaign got Adidas to not use kangaroo skins in their shoes, causing another giant soccer company not to use kangaroo skins, and then the third one. So single-handedly, with all the help of his backers and people that are with him, who work with him, Bonnie Clapper and all, who was also on our show, basically got that the young Joeys are not going to be ripped from the mothers and everybody clubbed to death for sneakers, okay? And my heart goes out to Donnie. So as a thank you, I bought him the white sweatshirt, the white hoodie with the green patch, and he absolutely adores it. So Joanna, let us know. Send us a picture in Justice Serve TV with you and your hoodie on, or do a little video of it. So maybe we can post it on our X page. Thank you so much, Joanna. So let me go back, because you know me in shopping. I digress as soon as I see shopping. And today isn't Forensic Friday. Is not Forensic Friday or Fashion Friday. It's actually only Wednesday, June 11th. But thank you very much. By the way, there's other trials that are going on. Just so you know, you have Lori Daybill going on. You have Weinstein going on. Last time I checked last night, we had texted Imran to come on the show, but they were still in court because apparently 2 jurors snitched on other jurors, saying they were discussing things they shouldn't be discussing. Then the jurors wanted coffee, and then the jurors appeared to be hung. And so I don't know what's happening this morning. So that case is going on, but it doesn't look like they're going to convict Harvey Weinstein in this time. And then on this case, and that's going to be interesting for the California case, because they used the conviction in the New York case to suggest his guilt in the California case. And then, of course, we have going on the P. Diddy case. Hopefully we'll get an update at the end of this week as to what's happening there. Let me put it this way. If you go to Catholic school, you shouldn't be necessarily watching the P. Diddy case, or if you are in high school, with all of the explicit references to certain acts that we're talking that has been talked about through the trial. I mean, I don't have, I've been around for a while dealing with cases but this case is beyond a soap opera of what is going into it, okay? Absolutely beyond a soap opera. But the point is that there's other cases going on here that we haven't really had time to get into. Once Karen Read ends, we'll probably pick, a number of cases to talk about it. Yes, the same one I had on the other day, Joanna. Thank you. That was what Dizzy designed, and it's just fabulous. It's fabulous. I'm hoping they make pants in that color and that colorways, and have our pants with all of our little logos on it and all. So Dizzy and I have to talk. I have some fashion ideas. Mara, oh my gosh, thank you, Mara, super sticker. You've been here a lot, donating, and let me tell you, Michael Bryant has, because we don't think closings are going to be tomorrow now. It'd be beyond pushing it if they're tomorrow. Okay, it'll just be beyond pushing it. But you never know with this judge. So we actually canceled our hotel reservation we had for Michael for tomorrow. If the closings are Friday, he will just drive up very early Friday morning and drive back very late Friday night. If not, we have made a hotel reservation for him to go up there in Dedham on Monday, where he will stay the whole time through closings and through the verdict. Okay, we are hoping for personal reasons that the closings don't occur Monday. I think the judge would be ridiculous to push these attorneys after the way she's been pushing them. They've been in court every single day, well before the start of this trial. It's almost like the beginning of the year. And the jury has also been there. And quite frankly, the jury should be rested before they hear the closings and begin their work. They should get. Did we hit 15,000? Oh my gosh, I missed it. 15. Thank you all. 15,000 on our small time being in front of you. As we said, we started as a lark last year. We did like 7 minutes. So this will be fun. A few things. We'll do some politics. We'll do some crime. We'll do anything we want to talk about, fashion. And then some interviews. But then we really started this channel in September, and we were still floundering a little bit to October. So we are a little over 6 months old, obviously. We're going to get to our year anniversary next September. And 15,000, quite frankly, I'm told, in that short period of time is truly an achievement. Of course, we're hungry. Now we want to go to 20,000. Somebody said, did a comment to one of our streams. And by the way, speaking about our streams, if you are joining us from Twitter, please go to our YouTube page at Justice Serve TV and hit the like and hit the subscribe there. It doesn't cost you anything. You just got to make a little transition over, and then you can come back and watch on Twitter so you can see what's happening. But if we try to bring you a lot of interviews with people that donate their time, like Stephen Plord, we've had Joe Tacopino, like we've had Ashley Merchant. We try to bring you a lot of different interviews with people that are relevant, that are real experts, that are real people in the crime area. We've had Cheryl McCollum on, who, by the way, thinks this case should never have been bought. You know, if you're into crime, you know who Mac is, right? She's wonderful. I still have to pick up my framed patch of hers that actually came off her uniform that she gave to Michael and I when we had dinner a couple months ago. I'm just so honored by that. I can't even tell you. So we had Sergeant Joe Jockalone on. I'm telling you what we're going to try to do. I've asked our producers to try to reach out to 50 Cent and have Joe and 50 Cent and actually my husband on about the Long Island killer, Rex Heuermann, on, because Peacock is running a 3-part series produced by 50 Cent. And my husband actually worked for 50 Cent on a case once. So I thought it'd be interesting to have them on. I don't know if we can do it because, again, we need to have that viewership for people to want to come see us. And so just keep hitting that like and subscribe, because I remember when we just did during this case, the 10,000, we had a big celebration for 10,000, and you guys got us to, and I use guys generically, okay, 15,000 very quickly. Of course, now we're hungry. We want to go to 20,000, but yay. Can we tell who the 15,000 subscriber is? The one who hit 15,000, and maybe remember at 10,000, we gave the person, we paid for a mug that they can go and they could get a free mug off our site. I'd love to have that happen again. Thank you, Connemara. I had my brother subscribe to your channel. I'll pass it along. Yes, keep passing. passing shadow from the sky tops. Okay. You all agree with me. The jury should start, friends. Oh, Dizzy says she's going to design yoga pants and also some not so figure hugging. Yeah. By the way, I have again, we're going back to fashion. I have the loose fitting pants. They're terrific also, by the way. Very comfortable, very terrific. Also, yes, Rex Huberman. Okay. My husband did the second autopsy on Shannon Gilbert's remains, and it's the only one that the police have not caused a homicide, and that's the one that caused a whole investigation. So be an interesting discussion. Okay, so I see the fan of injustice, and it's going to remain the fan of injustice to me until I see what this jury does. But they are coming back, and now we're going to hear, I know you're so excited about this, Hank Brennan's cross-examination of Dr. Rentschler. Okay, so, I have some starred questions. Amara, thank you again, and
All right,
Joanna,
Mr.
thank you
Brennan.
again. Okay, here you go. I'm going to be behind
Dr.
the TV
Rentschler,
avatar, but I'm
facts
here.
matter, don't they?
They do, yes, sir.
You said it many, many times. Facts matter. Isn't that correct?
I think it was details, but facts matter too.
Do details matter, doctor?
They do.
They're critical, aren't they?
If you want to prove that something happened a certain way, they're critical, yes, sir.
When you were talking to the jury and giving opinions about where Mr. Okeffe might have fell or not fell, you were discussing where Mr. Okeffe was lying on the side of the yard, weren't you?
Where he came to rest?
Came to rest.
Well, approximately, we don't know the exact position, but yes.
You said 10 to 20 feet, didn't you?
I believe so, yes.
You said that 3 times, 10 to 20 feet. Do you think Mr. Okeffe was 20 feet from the roadway?
Well, I think he's maybe 10 feet, but 20 feet is from, if you're hit by the car, you need some distance to travel. He couldn't travel just horizontally, or perpendicularly. So it would be at least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm asking you, not nobody.
Yeah,
Excuse me.
So go ahead and ask the question.
Dr. Rentschler, before this jury, have no idea where the point of impact was of this collision, do you?
That's correct. There's no evidence.
Play exhibit 2, please. When you were giving your estimate 10 to 20 feet, Dr. Rentschler, did you ever see this photograph before or part of this video?
I'm sure I have.
Well, when you say you're sure you have, are you guessing or have you seen it or not seen it?
I'm sure I've seen this before, yes.
So you've seen this before?
Yes.
And when you look at this video, did you look at the street and look at the area where Mr. Okeffe was?
Sure, yes.
Sure?
Yes.
20 feet, Dr. Rentschler?
The way I explained it to you, yes, sir. 10 to 20 feet.
Details matter, don't they?
They certainly do, yes, sir.
Take that down, please. Did you speak to anybody today before you testify about Dr. Welcher's testimony in court?
I did not today, no, sir.
Before today, did you speak to anybody about Dr. Welcher's testimony?
I did not, no, sir.
At any point, did anybody discuss certain issues with you today that they said would be particularly important?
I don't believe so, no, sir.
When you began your testimony yesterday, before you even finished your credentials, you began talking about your work with the NHL and how important it was to use a 50% hybrid-free dummy. Do you remember that testimony?
I did, yes, sir.
And you hadn't even finished your credentials yet. Was it brought to your attention that there was an issue in the testing because you or Dr. Wolf or you and Dr. Wolf chose to use a 50% dummy?
Not at all, no, sir.
In your preparation for your testimony, was it discussed at all that at the beginning you should get ahead of the issue and talk about the 50% dummy?
I didn't know it was an issue, no, sir.
Well, you know that the 50% dummy represents somebody who's 5'9", correct?
Approximately, yes, sir.
Approximately 173 pounds.
171, 172, somewhere around there.
And Mr. Okeffe, how much did he weigh?
216, I believe.
How tall was he?
He was 73 inches, I believe.
So that is not a representative height and weight from Mr. O'Keefe, is it?
That height and weight, no, sir.
And so if you were making projections or analysis based on limb weights, they would be inaccurate if you didn't make adjustments, correct?
Well, they would certainly, the force on the limb would be less if you use a lighter limb. So if Mr. O'Keefe is heavier than the hybrid 3, and I use a hybrid 3, the forces I calculate would be an underestimate of the actual force acting on his body.
If you didn't make an adjustment, but you relied on the numbers from the test 3, the hybrid 3 dummy, ultimately the conclusions would be off, wouldn't they?
They would be an underestimate. Yes, the actual forces would be higher.
And so did you make any conclusions, or did you know that when Dr. Wolf did his tests using the hybrid 3 dummy, he didn't make any adjustments?
What do you mean? What adjustments would he make? You get the acceleration, but the acceleration's not going to change, and that's what we utilize. Then you can scale the weight of the body, but I'm not sure what he would have made adjustments for.
When you looked at the ratio of force and mass, if you use a lighter weight, the mass changes, doesn't it?
If you use a light, sure, yes.
And that changes the force equation, doesn't it?
That can, yes.
And so when you were discussing yesterday at the beginning of your testimony about the 50% dummy, had that issue been raised with you?
No, sir, it had not.
You had testified before, hadn't you?
In this case?
Yes.
Yes, sir.
And you knew there was a sequestration order?
Prior?
Yes.
Yeah, I didn't discuss the case with anyone, no, sir.
Well, you didn't discuss with anybody, you said?
I did not, no.
Before you testified last year, you were receiving information from your employer about issues and testimony in the case.
The party that retained us told us things. I didn't break any sequestration. They were the ones in contact with the court. So it was my assumption that whatever they were telling me was allowed by the court. They were the client. I didn't discuss anything with them or tell them anything, but yes, they told us certain things.
Before you testified under oath last year, you were getting updates from your employer about details of this case, weren't you?
Session on
Maybe we can approach briefly.
Okay. I mean, if I'm Alan Jackson, I want the judge to tell the jury that this was the FBI, because Hank Brennan is broaching this as if there's something wrong with it, that his employer was telling something, that there's some violation. Okay. And so it looks like Rentschler's being kind of like withholding information, but he's not. It's because of a court order. So she should at least tell them, I have not allowed you, ladies and gentlemen, for at least the employer to be noticed by you because of no consideration, no concern, something like that. It's outrageous. And I'm sure that Alan Jackson is talking about this right now. You can't have a sword and a shield. You can't take what the judge's ruling is, which is wrong, wrong. And I say that how many times can I say? And then use it to badger this witness. I think that Brennan already appears to me, if I'm sitting on the jury, like he's losing, because he came at Rentschler. You know, when you have a witness, you have to let them be arrogant towards you before you can be kind of arrogant towards them back, if you even want to be, or just highlight it. Rentschler is such a gentleman, right? He's such a gentleman. He's answering the question, right? I pursue. Objection Jackson asked for a sidebar unless he is aggravated. I'm sure he is. I'm aggravated, and I'm not even sitting in that courtroom. I'm aggravated because this is unfair. I'm aggravated because the judge has caused this. I'm aggravated because I know the judge is not going to do anything about it. I'm aggravated because Brennan is harassing a witness on an area that he knows that the witness then can't blurt out FBI, because then the judge would sanction him, or Department of Justice. So I'm aggravated. So I can imagine that Bob Alessi, who apparently shares my passion, obviously, having tried the case, Spectre 1 against Alan Jackson, got in the hung jury, I know that he and I are just as passionate. And when Alessi first came into this case, I wasn't quite sure, he was new, but once he got his sea legs, he's terrific. And of course he is a passionate. Linda, what sort of sanction could there be? That's a really great question, right? What sort of sanction could there be? They could throw his testimony as a witness. She could say, I'm striking him as a witness. The jury's to disregard all of his testimony. That's what she could do. All right. That's exactly what she could do. By the way, thank you, Brenda, gifting 5 Justice Serve TV memberships. Everyone who gets these so appreciates this. We appreciate the donation and the costs that you incur to get them for Justice Serve TV. All right, let's go back into court and listen.
Before you testified last year, you were receiving information, not from the defense, from your employer, about other witnesses' testimony during.
Not from the defense. That's what got inserted there.
I don't know if
time.
they told us about witness testimony. They told us about certain evidence. I had no contact with the court, with the prosecution, with the defense. I had no idea what was going on. We were retained by a certain organization, and they contacted the court. They were in talks with the court about, I guess, what we could or couldn't do. Anything I got was from that organization.
I love the way he says organization. I love him. He's so cute. And did you hear that? I think Alan Jackson said you had to make it clear that it wasn't the defense that hired him. And so that when Brennan asked the question again, words matter. He said, you were not contacted, not by the defense, okay?
Voir dire 2, 118, line 15.
So that actually, I think, went against Brennan.
Did you testify under oath that they did inform me, yes, about testimony and situations and events that came forth in the event that I was not aware of?
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
What I just said to you, are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
Would you agree it certainly helped you prepare?
It helped me prepare.
Yes.
It didn't make a difference to my analysis or conclusions.
Made no difference at all?
It did not, no, sir.
Would you agree it helped you understand what was going on during the trial?
I don't think it made a difference at all. No, it doesn't change the facts that I evaluated or the analysis I conducted or the conclusions I came to.
And so as you sit here today, you are denying that that information certainly helped you prepare.
How did it help me prepare? It didn't change the opinions I offered. It didn't change what was in my report or what I'm opining to or testifying to today. It hasn't changed anything I've ever testified to.
I'm going to ask you a very specific question. I want you to give me a very specific answer.
So just go ahead and ask the question.
Are you
Argumentative.
denying that receiving that information certainly helped you prepare?
Honestly, I can't remember. It didn't change my opinion. I don't see how it would help me prepare. I remember there was evidence about trace DNA found that we didn't know before. That didn't change my opinion then. It doesn't change my opinion now. It doesn't have anything to do with my opinion.
Details matter, right, sir?
Details can matter.
Details matter. So let's talk about detail.
Sure.
Are you denying that receiving that information certainly helped you prepare? You denying it?
Just ask that 10 times.
I'm going to allow it.
Oh,
I don't think that it did. It's been a year, but certainly it didn't change any of my opinions or what I opined to. It didn't change anything with my testimony.
Answer for the
I'm gonna
10th
ask you
time.
One more time, I'll ask you a different question.
Objection.
Receiving that information from your employer, are you denying it helped you understand what was going on during the trial?
I'm going to allow that.
Of course she is.
I don't even think that it did. I don't understand that. I understood what was happening. I understood what the theory was. So saying that there's trace DNA doesn't change anything. It doesn't affect what my understanding of the trial was or what was happening or what allegedly occurred.
When you were traveling out to testify last year, you had phone conversations with the defense, didn't you?
I think I had like 2 phone conversations, 2 or 3.
So that sounds like a yes, you did.
Yeah, there was one right before my qualifications, my voir dire, where I talked to Mr. Jackson, and that was it. Other than that, I think it was just planning and scheduling.
Mhm. Was there any discussion on how you could portray yourself as independent?
Ah,
I don't believe there was.
So you don't believe?
Yeah, there was no need to.
That's not the question.
yes, it is the question.
Details matter. Was there
He's
any
done.
attempt?
So the objection's sustained. I'm going to strike that. folks.
Put a skewer into Hank.
Questions, Mr. Brennan?
Was there any attempt in your conversations to portray yourself as independent as far as your arrangements were concerned and coming out here?
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense,
It was
they
independent.
offered to give you transportation assistance getting here.
They provided a ride to and from the airport, yes.
Did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No, because I didn't take an Uber. I took their ride. If I wanted to appear independent, then I would have taken an Uber.
You have a conversation about that you were thinking about taking an Uber.
It didn't even cross my mind, sir.
And then after you testified, did you stay independent?
What do you mean independent?
Well, did you have any bias warrant in you?
Any bias?
Bias, yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
Well, I was waiting for my ride, and to get back to the airport, they had to take other people. And so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went, and I had a ham sandwich.
You had a ham sandwich. Did you testify at some point that after you had something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich, or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Well, certainly, I'm sure I did, sir.
Did you laugh along?
I assume if something funny was said, I probably laughed.
Did you talk about your testimony?
I don't, at this point, I don't even remember.
Let me alert you to something. When you were there at the luncheon, did you see a camera crew
I believe I did, yes, sir.
filming and?
I can't hear Hank as well.
There were a lot of cameras, yes.
You know that you might have been on some of that footage?
That's fine. I could care less.
Okay. So do you think maybe you were talking about the case and their answers and laughing it up a little bit?
I have no idea, possibly.
You were involved in conversations with the defense attorneys, were you?
What do you mean conversation, sir? I had just gotten done testifying. I was having lunch. Whatever was spoken about at the table, I'm sure I heard.
You know what a conversation is when someone speaks to you and you answer.
Sure.
Did you have conversations with some of these folks?
Sir, I can't remember conversations I had last week, let alone a year ago. So I probably did, but I have no clue
Do you remember
what we would have talked about.
Do you remember accolades you might have been receiving because you had given certain answers to the then prosecutor?
He has
on
no
the case?
basis for this question. AJ, I wish object.
I have
But
no idea.
I think AJ wants to make Hank
I
look
can't
like
remember
an
last
asshole.
week what I
Excuse
had
me.
for lunch last Tuesday.
Yes.
How would I remember a conversation
Exactly.
from over a year ago?
Do you remember when you were having conversations with some of these folks and
Apologize to our
the
class.
prosecutor asked you about other evidence
Don't
like
use my
DNA?
words.
You had a response, well, the physics doesn't change. You remember?
I don't specifically remember that, no, sir.
How long were you at the table eating your ham sandwich with the folks there enjoying the event? How long do you think that went on for?
I honestly don't know. 10 minutes? How long does it take you to eat a ham sandwich? 10 minutes?
And after you finished your ham sandwich and then you told us you stood in the corner, you got a ride back to the airport?
I did, yes, sir.
Yeah. After you got back to the airport, ultimately your company billed the defense for your time preparing and traveling and testifying?
I believe they did.
Well, you wrote your bills down, didn't you? You wrote your time down?
Well, I don't know who gets billed to it. I think it was actually, I wrote my time down and it was the same time code for the original employer that we had. I'm not involved in billing. I don't know who the bill goes out to. I just put my time in and do my work.
Do you know that the defense paid that bill?
I have no idea if they paid it or not.
And then now you have a new contract with the defense. Or I should say you have a contract with the defense, don't you?
I assume ARCCA does. Again, I'm not involved in that. I don't do any part of the financials. I just do my job.
Do you keep your billing?
I enter my billing every week, yes.
Do you know how much you've been paid so far in this case?
I haven't been paid anything. I'm a salaried employee for ARCCA. I have no idea how much ARCCA's been paid.
How much has ARCCA been paid because of your work so far?
I have no idea. I'm not involved in the financials, sir.
You have no idea how much time, how much compensation your company's going to get for the work that you've done and continue to do on this case? You have no idea.
Yeah, it's not my concern. It's not my department, so I don't.
Is that that's a no?
That's the no, sir.
Now, when you communicated with the defense, you texted, didn't you?
When?
At any point?
There were some texts, yes.
And at some point, there was a court order for you to bring a copy of your text?
I believe so, yes.
But when you say you believe so, details matter.
Yeah.
Do you know whether there was a court
Argumentative.
order for you to bring your
Argumentative.
text?
I believe there was, yes.
Did you comply with that court order?
I complied with, yes, with whatever I had.
Did
Yes.
you have any of the text messages?
I don't believe so.
What happened?
Well, there were like 2 text messages about where I could get my ride and what time. And so after that day, like I do many times, I'd probably erase those texts.
When you say probably, did you delete the text that you had with the defense last year during the trial?
Again, I had like 2 texts about scheduling, and I'm sure I deleted them like sometime around that time, like I do with most texts.
Did you ever use Signal?
I did not, no, sir.
Why not?
I have no need to.
Why would you have a need to?
I'm going to allow it.
I wouldn't have a need to. That's why I said I don't use it.
What's Signal for?
It's for, I think, for encrypted messages.
Do any of your colleagues use Signal to have conversations with their clients?
I'm going to allow that you're
Of
aware.
course, she is.
I have no idea what my fellow employees or cohorts do.
One of your fellow employees is a gentleman by the name of Dr. Wolf. Yeah,
Yep.
you worked very closely with him on this case, didn't you?
I've worked with him on this case, yes, sir.
And working with him on this case, were you aware of his habits, of whether or not he used encrypted apps like Signal?
Objection, nobody answered
I'm
that.
going to allow it.
I'm
Of
not
course she
aware
is.
of
This is
Dr. Wolf's
ridiculous.
habits, no, sir.
I
When you
think
worked
this is
on this
ridiculous.
case when you began, you worked with a gentleman by the name of Mr. Klein.
But Scott Klein is another engineer at ARCCA that worked on the case, correct?
And you worked with Dr. Wolf.
That's correct, yes.
You worked as a group?
Well, I mean, we all worked on the project together. I'm located in the Pittsburgh office, and Mr. Klein and Dr. Wolf were in the Philadelphia office. So we didn't physically work together, but we worked on the same project, obviously.
When you first began your testimony yesterday, you said that you were restrained in what you could do. Do you remember that testimony?
I do, yes.
And when you said you were restrained, were you attempting like a preemptive strike because of certain things you didn't do to try to ward off any questions about that? Objection.
Sustain.
Let me ask it this way. Were the rules different regarding your initial investigation for you as opposed to Dr. Wolf?
I don't
I
understand
don't
your
know that
name.
they were. I don't believe they were.
Did Dr. Wolf have free reign to do whatever he wanted?
Sustain.
Were you given free reign to do whatever testing you wanted?
I don't believe we were, no.
You though, were you?
Was I?
Yes, were you given free reign to do whatever testing you wanted?
I mean, there was budgets and we had to stay within certain values. So I wouldn't say I was given free reign because I couldn't do whatever I wanted.
Did anybody tell you what tests you could or couldn't do?
I don't think there was a list of specific tests or not, but you would discuss what would be done or what we could do and what the cost of those tests would be.
Were you free to suggest any tests that you wanted to?
I'm assuming I could suggest whatever I wanted to. Sure.
Were any of your suggestions denied?
Can't remember. I don't know that they were. I mean, what we were constrained is what the client wanted to know. And so we tailored our tests to do that and tried to keep the budget and the cost of what we did in our analysis down for that very purpose.
Could you have suggested crash tests?
Probably could have suggested whatever I want.
Did you suggest crash tests?
Honestly, I don't know. I mean, it might have been brought up, but pretty sure that would not have been within the budget. So
I want you to be detailed. I don't want you to guess.
So without that preamp, go ahead and just ask the question, please.
Did you suggest doing crash tests last year?
I can't remember. We obviously didn't, but I don't know if that was brought up or not.
Since your memory is difficult,
Oh, here we go with the memory again.
Sustained. Okay.
Here we go with the memory again, okay? I think Hank is actually embarrassing himself with this because, he is constrained, and Hank knows that. He can't say FBI. He said agency and budget and all. And we all know the crash test dummies are $100,000, $150,000. Stephen Plord talked about that on our show last night and previously, that people don't really use those because you can, you take your whole budget and you can do it with a static dummy, what they're looking for. You don't need that unless you're the highway safety and transportation and you're trying to do sensors if a car crashes to see how a car's crash worthiness among all fleets. But they have, they're funded by the United States government for a whole big deal. This was very limited. The only thing the FBI wanted to know is, did Karen Reed's vehicle strike John Okeffe and cause the injuries to John Okeffe? That was it. And that's the issue in this case. The reason why they wanted to know that is because that's the whole issue, okay? So whether he suggests something or something else or had a ham sandwich, some of you guys said, yeah, did he have it with mustard or mayonnaise? What kind of mustard or mayonnaise? Did he use the Japanese mayonnaise, or did he use Duke's, or did he use Hellman's? Did he use Grey Poupon? I mean, why don't we go through that? I mean, let's, I just think it's so ridiculous. I think this makes him look bad, but I'm concerned that Sue in the courtroom said the jury is writing all this down and is very attentive to all this. All right. How could they be attentive? I mean, if Hank Brennan starts out with the way he starts out, nasty, with that voice being nasty to a man who just spent on the stand and went through scientific testing, it tells me that Hank Brennan knows that Rentschler is a threat to their case. That's what it tells me, okay? It tells me that he feels he needs to destroy Rentschler and then try to bring in Welcher to pick up their case, because that's what I think is going on here, okay? All right, let's go. Obviously, they're coming back, and he's asking questions about what other people did, and I'll allow it. The defense did that to be sustained. What a unfair proceeding.
to remember things, do you write them down?
That's one of the ways you can do it, sure.
Do you do it? Do you write down things so you don't forget?
Depends what it is.
Like grocery lists.
You provided a CV, which is a resume.
That's correct, yes.
Resume outlines your education,
Yes, sir.
areas of specialty,
Correct.
and then it highlights your accomplishments as far as the focus of your specialty or the focus of your profession, what you like or what you do a lot, right?
Some of it, yes, sir.
So, for example, you have a number of publications that are peer reviewed.
Correct.
And peer review publications mean that you've written something that's been evaluated and considered by other experts in the industry and have been adopted or recognized, correct?
Well, that it's been published, yes, sir.
You have a long list of peer-reviewed articles dating back to 2003. Is that correct?
Yeah, as I said yesterday, most of my peer-reviewed articles are all written when I was in graduate school, correct?
Have you had any peer-review articles since 2003?
Probably not, no.
And your peer-review articles, 2003, deal with the evaluation of selected electric-powered wheelchairs.
That was one of them, yes, sir.
The next one, intelligent walkers for the elderly.
Correct.
Comparison of fatigue life for 3 types of manual wheelchairs.
Yes, sir.
Evaluation of a pushroom activated power assisted wheelchair.
Correct.
Displacement between the seating surface and hybrid testing dummy during transitions with the variable configuration wheelchair.
The hybrid 3, yes, sir.
Assessment of manual wheelchair ride.
Correct. I was looking at forces and accelerations on the body. Yeah.
Fatigue life of 2 manual wheelchair cross brace designs.
Yes, sir.
Evaluation of selected ultralight manual wheelchairs.
Yes, sir.
Augmentation of 100 key ISO wheelchair test dummy to accommodate higher mass.
Yes, sir.
And so you would agree that all of your peer review articles deal with wheelchairs?
Well, wheelchairs and the kinematics and kinetics forces associated with propelling wheelchairs and injuries associated with that. Yes, sir.
Do any of them deal with pedestrian collisions?
No, they don't.
You've written a book chapter,
Yes, sir.
Smart Technology for Aging,
Yes, sir.
and again, nothing on pedestrian accidents.
That's correct.
Expanded abstracts, you've written a few.
I have, yes, sir.
Suffice to say, dealing with wheelchairs.
And assistive technology, that's correct, yes, sir.
Any have to do with pedestrian collisions?
I don't believe so, no.
Looking at your CV, you can note any area of specialty you'd like, correct?
You can put down whatever you like, I suppose, sure.
Sure. Have you listed any specialty as pedestrian collisions?
Well, not specifically. That actually falls under impact biomechanics, biomechanical injury causation. So I didn't list it specifically, but it certainly falls under the actual expertise that I perform.
Now, doctor, when you worked with Dr. Wolf, did you have a chance to look at his report?
I did, yes.
If you saw anything in the report that was off or mistaken, would you have an opportunity to discuss that with him?
I'm sure I would, yes, sir.
Did you find anything about his report that was wrong as far as data?
I don't recall. If I did, I probably would have talked to him, but I don't recall.
You and Dr. Wolf were collaborating together, weren't you?
Yes, sir.
And when you collaborate, you relied on each other's data at the time, didn't you?
To some extent, yes.
Some things Dr. Wolf did, you relied on ultimately for your interpretation and your conclusions.
I did, yes.
Did you write a report and talked about the acceleration of the ATD, the test dummies, regarding its hands and arms?
I did, yes.
When you wrote your report talking about this very specific data, do you remember what you determined was the acceleration for the ADT right hand at 29 miles per hour? How many G's that was?
Let's see. Accelerations for the right hand.
Page 6.
Yeah, it looks like 863 Gs.
And when you were comparing data with Dr. Wolf, if something was different or off, would you correct it?
Oh, I'd talk to him about it, sure.
Okay. Did you ever talk to him about his collection of data regarding peak acceleration
that the arm and hand experienced at a 29-mile-per-hour collision?
Well, when I think that 863 is from 1,000, the CFC 1,000 hertz low pass filter. And in his report, he used a lower number from a 180 hertz. So they're both accurate numbers. It's just how you actually filter the data.
So you know what I'm talking about, right?
I do, yeah.
Yeah.
And I ended up using a lower number than when I did my calculations.
Could we have Exhibit 1, please? You've talked a lot about this photograph. Do you see it?
I do, sir, yes.
And you described, well, you didn't describe, you read that these were superficial abrasions, correct?
That's the diagnosis, yes, sir.
Any of those wounds a puncture in your mind?
I don't make medical diagnoses, so I'm not going to comment on that, sir.
Well, you talked about x-rays and injury. I know you don't make medical diagnosis, but you were very careful to be detailed about what this was. Not a laceration, right? It is a superficial abrasion.
That was what was diagnosed by the medical records, yes, sir.
And you were very careful to make that distinction when you were critiquing Dr. Welcher, weren't you?
Sustained in that.
And so you also looked at x-rays, didn't you?
Yes, sir.
And when you looked at them, did you try to give the impression that you've read them, even though you're not a doctor and you can interpret them?
Sustained.
Were you trying to interpret them for us?
No, it was actually interpreted by the medical examiner that there were no acute injuries.
So when you were giving all that information to the jury about the x-rays, was that your personal opinion or were you just regurgitating something you had read?
That was the medical examiner's opinion, but certainly you can look at the x-rays and see that there are no actual fracture lines or space displacement between the joints. But it's the medical examiner and his diagnoses that I rely upon.
So when you were going through an explanation of all these different photographs and x-rays, you weren't trying to portray that you were giving your own personal opinion about it?
I don't give diagnoses, but if there's no fractures on an x-ray is diagnosed by an MD or physician, you can look at the x-ray and then you can see why there are no fractures. You can look at the x-ray and see where the fractures are if there's a diagnosis. So the diagnosis was no fracture, no acute injury, and that's certainly consistent with looking at the x-ray itself.
So when you were looking up the x-ray and holding it up, was that just a prop? I mean, were you simply just regurgitating what you read in the report? Or were you doing a certain kind of, were you doing any kind of analysis yourself when you were sharing with us what those x-rays showed or didn't show?
The analysis is that there's no fracture or acute injury. And that's what the medical diagnosis is, and that's what the x-rays showed.
Are you giving us your opinion, or are you regurgitating what you read in a report?
That is what the medical diagnosis is, that there's no fractures and no acute injuries. That's what the medical opinion is.
So you're regurgitating what's in the report.
Sustained in that.
Did you see any MRIs?
I don't believe any MRIs were taken or performed.
In
no.
x-rays, does it depict deep soft tissue damage?
Normally, it does not depict soft tissue damage, no.
How about muscle tears?
No, it does not.
How about tendon tears?
Not normally, except you can see laxity in the joints if there is tendon or ligament tears. Normally, you can see laxity in the joints, but it doesn't show the ligament or the tendon itself.
Nerve injuries?
No, sir.
Avulsion fractures?
Yes, sir.
People sometimes get MRIs to see if there's a fracture that doesn't appear in an x-ray. Yes?
Sometimes x-rays are the best for looking at bony fractures. MRI is looking at soft tissue injuries.
Speaking of wounds, you've cited a number of references, a number of materials in your reports, haven't you?
I have, yes, sir.
And one of them that you've cited is forensic pathology.
Yes, sir.
This is a legitimate source to you, correct?
Yes, sir.
And you've relied on it for at least part of the basis of your study or opinions.
Well, I relied on it because it speaks and looks at the difference between, for instance, a laceration and an abrasion.
A person could be struck by a motor vehicle and not indicate any bruising to that area, wouldn't you say?
at what speed, what part of the vehicle were they contacted, what part of the body were they contacted. It depends on the amount of force associated with that. There's a number of variables involved.
Okay. Does the absence of a bruise indicate that there was no blunt force trauma to the area?
I'm going to allow it. Can you answer that?
Well, the absence of a bruise, can you repeat that again?
You were talking about bruising.
Yes.
Does the absence of a bruise necessarily indicate there was no blunt force trauma to an area?
No, you have to look at all the evidence and you have to look at the force. If there's 4,000 pounds of force applied to the body or to the arm, then certainly you would expect a bruise. And if there's no bruise, then you would have to question if that impact or contact actually occurred. You don't just look at that by itself in isolation. You look at all the variables and facts involved with the case to determine if an injury occurred.
Have you ever seen collisions where more than one person was hit or struck by the vehicle?
Multiple pedestrians, you mean?
Yes.
Yes, sir.
And have you ever seen in a collision where the vehicle's going the same speed when it hits multiple different people, there can be multiple different injuries?
That is so vague, and you'd have to go back and look at a specific case, look at the injuries, look at the vehicle, look at the people. You can't just say, is it possible this could occur? You have to look at a specific case and demonstrate that that could actually happen.
Well, I'm not asking if it's possible. I'm asking your experience.
I'm going to allow that.
Have you ever been involved in evaluating multiple pedestrian crash where there are multiple pedestrians hit by one vehicle and they sustain different or in some cases no injuries? Has that ever happened in your study?
Sure, because it depends where they're hit, what part of the body they're hit on, what the force is for that hit. The people aren't going to be hit the same multiply by one vehicle. You can certainly have multiple people in different types of injuries.
Have you seen people hit by a vehicle at a particular speed and have certain injuries, and then you've seen other cases where people are hit by a vehicle similar speed but have no injuries? Have you ever seen that?
I'm going to allow it.
So what do you mean by injuries?
Have you ever seen in any of your cases a pedestrian hit at a certain speed and have injuries, and another case where you look at where there is a similar type of collision with different injuries?
So again, do you mean abrasions, cut, laceration, fracture? Do you mean same cars? It's not something that you look for and compare between cases. You'd have to go back and actually study the cases and look at the details.
Having experience in pedestrian collisions, you can't think of a similarity between cases as far as vehicles and speeds and totally different injuries occurring.
I'm going to allow that. Can you?
Do you mean hit the same way with the same type of car at the same speed with the same force?
I'm going to allow it. Can you answer it?
I don't believe I've ever seen a case where two people were hit with the same car at the same speed with the same force with different injuries. I don't even know if you can correlate that.
Looking at Exhibit 1, have you done any study about the directionality of glass or broken plastic?
What do you mean by directionality?
About when something shatters, how it shatters. Does it shatter the same every time, or when plastic shatters, does it shatter differently?
It certainly depends on the impact.
Do you have any studies where plastic shatters exactly the same way on different impacts?
I doubt that it shatters exactly the same way.
It has a lot of different variables, doesn't it?
It could.
Depends on a number of different equations, doesn't it?
Well, it depends on the testing you do. If you want to see how it shatters, and if you're claiming that it shattered in a certain way to cause a certain injury, if you don't have any peer-reviewed evidence, if you don't have any research, then you have to do the testing, because you can't just say, well, it's possible it could shatter this way and cause that injury. That's not conclusive. You can't use that to come to an opinion about what happened.
Oh, that wasn't what I was asking you. I was asking you if you have seen in cases that when plastic breaks, it breaks differently.
Yeah. Well, sure. The testing we've done here, the taillights covers fractured differently, and we didn't get any contact. So I have personal experience just with this case alone.
We'll get to the contact. When you looked at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
Well, I didn't ask you that. Is that funny?
It's not funny.
Okay.
So I'm going to strike the comment. Next question. Next question, Mr. Brennan. No more comments.
When you did your experiments, the sizes of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
The angles of the break changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
Did you watch the videos and watch the damage and take a look and count how many pieces broke in each experiment?
I didn't specifically count, no. We looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not a matter if there's a need, did you?
I did not, no, sir.
Okay. You had talked quite a bit about Dr. Welcher's test with the paint, so I want to ask you some questions about that. Were you ever under the impression that Mr. Welcher, you can take that down, please. Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
I'm going to allow it.
Well, that was the only test he performed, and he referenced that test for his opinion that the position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
Sustained. So, Mr. Jackson, Mr. Brent, I'm going to see counsel at Sidebahhh.
All right, I'm right here. Hold on. I'm coming. I'm right here. I'm right here. I'm listening. Okay. I am being a little in the sense, and I think, yes, at some point you got to start sanctioning Brennan. All right. Yeah, she's sustaining the objections, and I think it's not going over well with the jury. And Dr. Rentschler just answered the question. He got himself into it. Then he doesn't like the answer. And then he wants to be rude to Dr. Rentschler. And AJ has had enough. He's really, thank you. I see this, Harley. AJ's had enough. You and I think alike. AJ's had enough. Absolutely. With the comments and the nastiness. And at some point, you got to tell him to stop. And you got to say to him, if you do it one more time, Mr. Brennan, I am going to hold you in contempt. Okay, is that so hard to do? Let me do it again. Let me try to explain to the judge. If you do it again, Mr. Brennan, I'm going to hold you in contempt. All right, that's where we go. And you don't yell at AJ for making that objection, because this is Hank Brennan can't get what he wants to get. He knows Welcher's done. And this witness is very nice. Now, I tweeted something facetiously out. I said, with the ham sandwich, obviously, with the ham sandwich, you didn't go far enough, Hank. You didn't ask him whether it was Kewpie mustard, Duke's mustard, or Hellman's. I'm sorry, Kewpie mayonnaise, Duke's mayonnaise, or Hellman's mayonnaise. You forgot to ask him, is it Grey Poupon or is it French's? Did he have it on white bread? Did he have it on wheat bread? Did he have it on sourdough bread? Did he have it on rye bread? Did he have it on gluten-free bread? Gosh, I want to know the answer to that, because that is so important to this case, isn't it? Okay? All right. So, yes, facts are important. I want to know those facts, because those are important. The poor guy, right? You didn't take an Uber. You didn't do this. You didn't do that. You know, it was very interesting because Crash Daddy 1 actually drove himself on Monday to with his American truck and big truck and parked it. And Hank Brennan must have known that, so he didn't ask him how he got there today. So it's ridiculous. I mean, I'm hoping that AJ does it. I'm hoping that AJ does exactly what I said, because it shows how ridiculous it is. And quite honestly, quite frankly, I think that Hank has opened the door to let him show how ridiculous. But you know the judge won't allow that to happen. All right. Are you going to get to the substance, right? He just said, well, there has to be. How do you know it's related that the blue tube, the blue test is related to that? It has to be related to that because that's the only thing it could be related to. And it doesn't make any sense. And if you don't even do that test, you've done nothing related to the accident and charged $435,000, if I recall, including as opposed to what we know that Dr. Wolf did have the numbers of $50,000 that they charged. That included
So it will be
probably
the lunch
running
and
an
recess and
exemplar.
we'll take an hour.
Okay, so here we are. We're going to the lunch and recess. We'll be at 12:45 to 1:45. I am not sure whether or not they're going to have any more discussion. Let's see if they're going to have any more discussion with regard to this. All right. When Michael Bryant gets on, we're going to talk for a little bit, and then I'm going to have to leave you for a little bit because I have a 3 o'clock appointment I have to go to, but I will be listening. Matter of fact, I cannot not listen. And Stephen Plord has confirmed for tonight. He had a meeting at 6. He said it's canceled. I said, look, would it help you if you come on at 6:30? But I think that exactly, exactly. He's going to be on tonight. We have so much to talk about. So, yeah, I'm sorry. I'm just answering him right now, as a matter of fact. Does he hear that? So he texted me. He says, by the way, I'll let you in my text. He said this was great testimony from Rentschler. Okay. So you're going to get a preview that it's great testimony from Rentschler that he's hearing on. But what are your thoughts on this? Okay. A lot of you are on here. We have 1,850 of you. Please hit, by the way, please subscribe. Even if you're coming and watching from Twitter, which I know a lot of you are, just come on over to our YouTube page for a second, hit the like and subscribe, and then you can go back to watching it from Twitter because you got us to 15,000 today. By the way, we understand that YouTube is 2 days behind, so I won't know who the 15,000 person is for a couple of days, maybe when they start summing up. I don't know. But if this is all Hank Brennan has, he wants to try to say, well, you did something on wheelchairs. Yeah, I'm proud of it. I'm very happy. I'm very proud of his work helping people. As a matter of fact, the medical examiner said a lot of their work is to find out when people die, what kind of things could be done to help so that they don't die. And that's true. All right. Yeah. Oh, he forgot to ask the price of the ham sandwich. He forgot to ask who paid for the ham sandwich. If you want to talk about bias, my God, maybe Rentschler can easily be bought. I think, quite frankly, if I'm a juror, this to me is just garbage. Now, you may have made up your mind in which way you're going to vote, even though you're supposed to keep an open mind. But let's see. Oasis Cat says, let me just see. Hold on a second. Let's read this together. Pursued, jurors are taken out. She looked like she was going to faint. She looked very, very still to me this morning. Early lunch to accommodate the juror. Early lunch. So there's a juror who's sick. Oasis Cat, is that what it is, according to Sue? That there's a juror who is not feeling very well. That may be an early lunch, but I think it was also a good time to take lunch, by the way, because, Hank Brennan was just out. He's out of control. He is out of control. Now, I defended you, Mr. Brennan, saying you were a good attorney. And I know technically you are. And I know this is what defense attorneys for mob lawyers do. I how to deal with Bruce Cutler. I understand that. But, you're not trying a mob case, all right? You're not trying a Whitey Bulger case. And we know that you were hired because they think that you're a killer. We know you were hired because they needed someone they thought who can combat Alan Jackson and his team of lawyers. We know why you were hired. But because you were hired that way does not mean that as a prosecutor, you don't have an ethical duty to bring the truth out in court and look for the truth, not look for to be a garbage player, not look to be a snake, not look to be annoying, not look to ask questions that you get away with asking because the judge will protect you. So you get to ask the question 7 or 8 times. And then, of course, you get so empowered that you go beyond that. Even she has to say, strike the last, the last question or strike the last answer. Although the jury is told that it's supposed to be disregarded, but they hear it. But quite frankly, I think Alan Jackson let Hank Brennan go on because, when you have a witness who's handling somebody so well, you do that. You actually do that, okay? And then when you have the witness who's handling so well, but at some point you have to intervene. At some point you have to intervene, all right? And I think that AJ intervened at the right point. He showed the right amount of disdain, disregard, and all. By the way, we're waiting for Michael Bryant, who I think should be hearing this and getting on pretty soon to get on the air, because I know and I hear something in my ear. I say Michael Bryant, and there he is. Like, there he is.
I had to order my ham sandwich. For some reason I was hungry. I don't know. Just kind of.
I don't know, but can I ask you what kind of what did you use? Mayonnaise, mustard?
Yeah, I'm a mayo guy. I'm not big on mustard.
What kind of mayo?
That's I'm not picky. Whatever they throw in front of me.
What was the bread? What was the bread?
I do like a nice pumpernickel swirl. Are you familiar with that?
Yes. I toasted or not toasted?
Toasted one side only, though.
Toasted one side only. Anything else on the plate? Did it come with potato chips? You getting?
No, because I made it myself, so that was the order. Yeah. So
all right. Anyhow, this
I did learn though. Now you can more than indict a ham sandwich. You can actually make it the focus of your cross-examination. So that's amazing.
So yeah, I don't know if anyone's hungry. Yesterday we had the tofu brain, which the medical examiner said gross, rightly so. And today we have a ham sandwich. I think if all this is if this is all he's got,
he's so desperate. It is so obvious that he is drowning, and he can't control himself. I mean, he's off the rails. I mean, this is a guy who's normally, even though irritating and full of assholery, he's normally
you can't say that. We have a class here.
I think I can. Like I'm talking about a mule.
Okay, all right, good. Because I accidentally stepped up, so we have a donkey.
Yes.
Here, but no, we're trying to teach you. This is not what you see. I'm trying to explain to people who's watching, like our class. This is not what you're supposed to see in a trial, right, Michael?
No, not unless it's a movie or a TV show, because it's so unbelievably bad and so unbelievably obvious that he is being coddled by the court up to a certain point. And I'm surprised that AJ waited as long as he did to say enough of this, enough.
Yeah, well, Tubi's had enough of it. That's
he has to make a point like that. I don't care if it's in front of the jury or not. You can't sit there and be the whipping boy for this Commonwealth attorney. And when things are going so in his direction, and you just sit there because you're going to be punished, you sit in the corner with a dunce cap if you say anything. Too bad. Not only do you have a client to protect, you have the process to protect. And this guy is abusing the process. So good for AJ for finally stepping up and saying something.
Hold on a second. I have to actually put you on. Yes. No, I don't have to put you on mute. Okay. Hold on a second. I needed to deal with Tubi, but he's fine. He's fine. Tubi is doing what Chloe, if she were in the house, would be doing that night, Chloe. Barking. Okay. Barking. But apparently Chloe wasn't there because I was trying to make that distinction this morning. I really think that with this little charade that he just did, and now, and there were so many things, I'll allow it. She said that like 7 or 8 times. Then finally,
over ridiculous questions that were totally speculative, totally inappropriate, and she just says, I'll allow it, like that's just going to go over just fine. And it didn't ultimately. Yeah. It didn't. But it was the snarkiness that that ultimately got Jackson to stand up. It wasn't the fact that she was allowing improper questions, because she's been doing that for 8 weeks. It was the personal attacks, the commentary. I mean, you just can't he's commenting more than he's questioning.
Right.
Everything is snide and snarky and dismissive and disrespectful of the witness. And if he's so stupid that he thinks the jury doesn't see what's happening, he deserves what he gets. If he thinks this is the cool way to go, this is, the jury's going to side with me. They're going to see that I have to be this way to get to the truth. If he thinks that, he's dumber than I thought. Because
unless he thinks the jury is with him, unless he thinks the jury's on his side for some inside information.
I'm not naive enough to think there won't be somebody on the jury that likes it. Nope. I think you're right. Could be one of 18 people. Which again, I'm shocked we still have 18 people. It could be, yeah, you're right. Somebody on the jury could also be an a-hole, and they kind of like it. It's possible. I can't say it's not possible. But we try to look at it from a common sense standpoint and just regular folks. How would you interpret what you see happening in front of you? It's not good. All right. It's not good. Hey, I just got a note that, Aiden Carney's trial is underway today. It's trial day number 2. And I got the Zoom meeting feed from
Me.
did you send that
I
to me?
sent it to you, right?
You got it from where? Where did
I
you
got
get
it from Aiden. Aiden's
Oh,
Twitter
okay.
page while I was on the air with talking to everybody.
When he was driving in this morning, he was hoping that somebody could do it and share it. And he said Law and Crime was shooting it, but he didn't think it was live. So he thinks that
apparently it is.
they're rolling out it he thought just for later use. But anyway, we'll explore that a little bit further to see where that is. I'm assuming they are at or near lunch as well. So if anybody knows the Aiden Carney trial, if they're on the same break, it wouldn't help us. It'd be nice to be able to flip over there and see what's happening if we can work it out. So
Okay. Apparently, by the way, one of the female jurors it was weak and is sick, and that's why supposedly the judge took an early break. I thought she
I'm
took the
sick.
break.
I'm
'cause she had
sick
a calm-
too.
Yeah, she had a calm hang down. By the way, yeah, now that you've had your ham sandwich, and I guess you've eaten it all because I don't know, it's time for you to go stand in the corner and wait for your Uber ride, your ride back to the airport.
I was waiting. Where's the videos? Because Hank is so full of crap. You never know when he's lying or not, right? He said, "Did you notice there was a camera crew there?" And now when somebody asks you that question, you're a little bit on defensive. Just because you don't remember maybe second for second what was going on, what you did, how it looked, right? Now you're starting to think, okay, did I tell him something that is going to be now contradicted by somebody who videotaped me, recorded me? But we never saw any video. So I don't know if Brennan was lying about that or not, but it definitely put Dr. Rentschler a little bit on the defensive, unfortunately for him.
Yeah, but so what? I mean, the whole point is that he's finished his testimony, hired by a third-party entity, agency. He said something else. He said something else.
Organization.
Right, he's with the I love it.
Yeah,
organization, right? Hired by a third-party organization. I mean, the jury's got to be, unless they're dumb, they've put it together that it's the FBI.
Thanks, Oasis Cat. She does Aiden's trial also on lunch.
Yeah.
Okay.
It's too bad we don't have 2 channels to cover both, but if it's taped, obviously we'll be able to see it and maybe run it. And by the way, Stephen Plord is changing his meeting that he had tonight. It's been requested by our viewers for him to come back on. He texted me that this was great testimony from Dr. Rentschler. He's probably going to laugh at the, one from the cross-examination. I'm not laughing because I think it's
serious business. Yes. It's just that sometimes as a defense mechanism, you have to laugh. Otherwise you're going to start grabbing people by the throat. You have to put it in perspective. It is wrong. It is dead wrong. And we can't do a damn thing about it because we're here just reporting on it. Right. But man, as those that work within the system, as officers of the court, it's an embarrassment. It's just embarrassing.
I wonder how Lowley is doing sitting there now.
Well, I'll tell you what, he's probably in a weird position where as a Commonwealth representative, he's probably not happy. But as the guy who got booted, I can't help but believe that somewhere down deep, he's like, you like this guy, do you? Booted me for him, did you? I think there's a little bit of self-satisfaction somewhere. If he were to admit it, I think he would feel that just a little bit.
Yeah. This case, man, I tell you, this case, it sucks you in, and it sucks you in not for a good reason.
No,
it's not sucking you in like we would have the horrendous case of Brian Kohberger, where you had all these innocent people slaughtered, right? And you want to know, what happened and how we got there and whether justice is going to be done. And you have strong feelings about it. It's affected us all in one way or another. But this case, man, just really sucks you in. I mean, it just really sucks you in. I was thinking back to the whole history of justice in the United States. In World War II, there was the Nuremberg trials, and there was the whole issue that when did you do it, right? And you covered it. Oh, you're not that old. All right. You covered, although there was something about a 1979 officer. This was really interesting. I'll get back to it. But I just want to say that the United States said we had to have a fair trial in front of cameras, and things had to be fair in front of the world so we could show that we can give people a fair trial. And so it was broadcast, and it was pretty fair. And I think there was a couple people that were acquitted in the trial. Here, this is the showcase for what the best the United States of America has in regard to trials, well, Massachusetts, you have failed bigly. Okay. Now, I will say, when we were in Hernandez, the judge gave us pretty much a fair. We fought for some things, and some things he didn't but basically let us do our trial. As more we knew that we showed that we were strong and knew, and a couple times, as I said, we had to go to bat against him. He kind of let us do our trial fairly. And that was a good case to watch for the Commonwealth of Massachusetts, because we got a fair trial. This is not. Now, people are worried, and I know even my sister was on last night. People are on the show yesterday are worried that the Commonwealth, because they have Brennan, who's representing the mob, would be paying off jurors. Any concerns about that?
No,
Because that's
my
a pretty
gosh.
well,
I
that's
mean,
a pretty big allegation, given what's
yeah,
happening.
of course it is. We hear all that kind of stuff. People, spin tales. I would be shocked to hear something like that. To see it proven. I'm not surprised it's being talked about. People like to throw all kinds of wild stories out there. That would surprise even me at this point in this trial with the characters we're talking about. I just think that that is not happening. It just can't be.
Yeah.
Well, what did we hear? We heard that there were some supporters, though, that might be getting paid by one side or the other. That's 1 or 2 degrees less that I might believe. That the Commonwealth might be paying supporters. That's less egregious than jury members. It's wrong, obviously, but marketing is not illegal. It's just for the state to do their own marketing. That's unusual. We just haven't seen it.
I don't know, but you look at I don't know. You look at some of the commenters. I mean, I did a rant this morning. I know you haven't had time. Oh, yeah, look at those eyebrows going up. You haven't had time to listen to it. And it was about the disrespect I am seeing. And I mentioned your viewpoint about the microphone being close. But it doesn't matter, because the whole point is that people thought that there's something wrong with her. And then maybe she may have CPOT, she may have emphysema, she may have some heart valve issues, she may have anything in terms of breathing, if that was a problem with breathing. But the fact that people thought to comment on the breathing, including one person who's on another network all the time, I think it's so disrespectful to comment on people's physical abilities. You have a woman who is working for a living, who's coming,
of course,
and telling her
opinion. And you're not talking about commenting as a concern or as an observation. You're saying making fun of. And how I can't listen to her with her breathing, and it's just she's disgusting with that breathing, and we think it's put on because her breathing is better on one. And sounds like she's making an obscene phone call with some of the comments. And I just said, when you comment on anybody's ailments, whether it be any disability, whether it be a physical ailment, whether it be a medical ailment, whether it be a dependency ailment, whether it be looks, whether it be I don't like the color of her hair. And I told them about the story about the split ends when I came out of Spectre after I had pneumonia for 3 weeks, and instead of talking about my legal ability, somebody wanted a big magazine in LA wanted to comment about I came back with my split ends. All right. Well, yeah, you're talking about LA, so superficiality is what they sell.
Its superficiality is here, and people are
of course, and it's
people.
a sign of a weak mind, because they've got nothing good to say, nothing substantive to say. And so that's what they resort to, is those kinds of personal attacks. And there's also, unfortunately, for the social media animal that it is, it gives people anonymity, and so they feel brave, they feel bold. It's kind of like back in the day before social media. That's the mob mentality, right? That's when 30 people attack somebody physically because they figure between all of them they have the anonymity, they'll never be caught. Now it's just multiplied by billions, because anybody with a keyboard thinks they're hot shit, and they can say whatever they want, and it doesn't matter. And
we've had some of those people on our feed last night.
Of course, that's the nature of the beast. You just got to take it for what it's worth, consider the source, and move on.
Yeah, as I said, McRamble says they also doxed the crash daddy's wife, kids all weekend. It's disgusting. It is so disgusting what this is, and
it's sad.
It's sad. And I think the fact that the judge is allowing this spectacle, it's helping it. she's allowing this spectacle. She's allowing
Sure.
this hate to go forward. Once she started with those grave concerns, and I love, quite frankly, the way we didn't play that clip last
He
night.
did
I
that
love, quite
yesterday.
frankly,
Yeah, we actually, I think, played part of it. It was the
I
very
don't-
setup
but we didn't
to
play the
his
grave
argument.
concern, right? But we didn't play the grave concerns
I
part,
can't remember where
where
we
where
picked it up.
Alan Jackson said, to use a phrase that's been thrown around here, I have grave concerns, Your Honor, and I was thrilled that he went back at her, and he and all, and
I think it's taken too long. He maybe should have. This is a difficult position for any attorney where you're getting run over by the judge, and it happens. Maybe not to the degree we're seeing with Judge Bev, but it happens, right? Where you're being treated unfairly, and you have to weigh the consequences of your pride and representing your client properly.
Right.
If I'm going to get back in the judge's face and it's going to come back and hurt my client, am I doing the job I need to do for my client? No. Sometimes you got to suck it up. But at a certain point,
sometimes you got to
right is right and wrong is wrong. Of course,
like Brian Steele did in YSL. Sometimes you got to be willing to take that contempt and go to jail. You have to, because the judge is wrong. I mean, and we saw that with Judge Glanville.
Yeah, and he got the ultimate. I mean, he was replaced.
Yeah,
so it can happen, but it's got to be so egregious. I think the stuff we're fighting about in terms of the judge's decision making, I don't think it rises to the level it did in the Glanville YSL case, because that was so overt against one attorney. It was like, when you're going to put an attorney in jail, that's a little above and beyond. We've seen this cumulative effect in this case where Judge Bev seems to be totally out of control, perhaps to the level of a Glanville, but her independent actions have not been as outrageous as Glanville's was, which led to his recusal from that case. So I guess if she keeps escalating, it could happen.
Except, and Glanville was the head judge, right? He was well thought of. As I mentioned, said he was very
he's
well
still
thought
on the
of.
job. He's still there.
Yeah, I thought they would be disrobed at that point, and he wasn't. So there's simply no consequences, right, for the judges if they do something like that. And if you complain, you're absolutely right. Just like they moved to recuse her early on, and I'm sure she held that against them. As a judge, you should expect a motion for recusal. Yeah, it's part of the business, part of the beast.
Yeah.
Right?
Yeah. Well, yeah. And that happened, what was it, 2023 that
Right,
happened.
right.
Get over it. If you don't have the demeanor to be a judge, then don't be a judge. Go be a bartender, which is a great job, fine. But you just don't be a judge. You don't have the right personality for it.
Yeah. Now, someone did point out that you may be right about the microphone with Dr. Laposata, that in the courtroom she didn't sound that way. However, my point in the rant was it's irrelevant. If that's what you thought, that it's a medical condition and you're hating on her because of that medical condition, it's irrelevant. You make you're an embarrassment to yourself, to your parents, to your kids, to everybody. Come at me.
In full disclosure, yesterday when I was commenting on it, I did say, as I was asking, I hope it's not a health problem. I hope that it's just because she's eating the mic. I said, she does kind of sound like Darth Vader at times. Yeah, I admit that. I did say that as I was explaining what I thought it was and what I hoped it wasn't. So if that's a ding against me, mea culpa. But that was not a mean thing to say about her. That was just a way to get into the subject and talk about what I thought it might be. And I still think it was 90% having to eat the microphone. And I mentioned at the time, those in the courtroom, I don't think are hearing what we're hearing.
And that's confirmed by Aiden, apparently, that in the courtroom, that was not the situation. So, okay, so we have a disagreement with you. Let's engage in this, because this is a good comment. With all due respect, Michael, I respectfully disagree with you. This is the worst judge I've seen in my 54 years on the planet.
Well, harumph. I don't know how many cases you've tried or how many judges you've seen, but I've seen as bad. It just hasn't been showcased. This is pretty front row stuff, and everybody is seeing it. So even those who have not tried cases are seeing this judge in action. I just think, in my experience, I have not. She doesn't reach the top of the pinnacle. She's not the worst I've seen. She's not.
She's pretty bad, though.
She's bad. Of course, she's bad. She's horrible.
Pretty bad. But I think that's exactly. We are showcased. This is being showcased. This is being. And you know what? Usually, judges are on their best behavior when there's cameras, all right? They want to be liked. They want to be, Now, what I think here, as many judges, and we try cases, and I'm sure that when I got the hung jury, the judge in California, who I thought was also extremely unfair to us, okay, although he did let me do a lot of what I wanted to do because he knew I knew my stuff. All right. And I think he was happy when I was out for pneumonia because he knew I knew my stuff, right? And but you do think that judges are unfair to you in certain rulings. Okay. All right. So
was that the same case? Did you have the eye problem in the same case where you had the ultimate pneumonia?
No, the eye problem was the emergency room, having to go to the emergency room and get operated on.
Here.
What was in Hernandez? Yeah, you know what? You get so run down and things happen.
The stress is unbelievable.
Yeah, Linda, I have a question. If you are trying to case your husband was called to testify, would you have to recuse yourself? No. Because if he's on the same side as me and the client wants my husband to testify and I'm the lawyer, no, there's no conflict of interest. Alan Jackson tried that with my husband in the Specter case, right? My husband had been hired by a previous attorney, right, to go watch the autopsy. I'm like 3 turn years later. Phil gets my name because I had been responsible for doing all the forensics when we had Jason Williams, where he was acquitted in the gun going off case. And so he called somebody in New York to find out who the attorney was that did that. And that was, of course, me. And, and so I ended up flying out to meet with him from a American Academy of Forensic Science conference, and he wanted to hire me. And then we had discussed the whole issue of my husband, but there was no conflict because he wanted my husband and he wanted me. All right, as simple as that. Same side, no conflict. Okay, but AJ tried that, but there is no conflict. If your client wants you, that's it. And I don't give up my career. I mean, if we're on opposite sides. I'd love to cross-examine my husband.
That would I would watch that.
I could probably be the only one in the world.
I would watch that.
Yeah, I could be the only one in the world. But there was a movie about this.
I think you would melt. You would melt. But it would be fun to watch. Yeah. So, and for those who might wonder, these kind of conflicts are not, that's rare, husband-wife, but having some sort of connection, it can be brought up as just part of the cross-examination to suggest some sort of bias. And, it's really just a further investigation into the connection between the expert and the defense team, or in the prosecution, whomever's representing or hired that person to represent their side. That's something you'd explore. What's the relationship? You dated this person, they dumped you, I mean, whatever. You could do that, and the jury gets to decide whether they care if that matters or not.
Yeah. Now, wasn't there a movie with Spencer Tracy and Katharine Hepburn? Yes, there was. Tell me the name of the movie, everybody. Tell me the name of the movie. All right. Adam's Apple, Adam's Eve,
Adam's Rib.
Adam's Rib. There you go.
I just made that up. I don't know.
Yeah. Adam's Rib. Okay. Colin Success says at least we're seeing him being disrespectful, not to just women. Yeah. My point was that he was really disrespectful to women. He was like targeting the medical examiner and all. He's been disrespectful against ARCCA because they hurt his case.
Of course,
okay?
they sink his case, and that one little win that he had seems to have melted away. Remember, there was an objection early on, a sidebar about continuing to reference Welcher, because that's who did everything, right? And so after that, there was a long period of time where it was the Aperture report. Aperture did this, Aperture did. Okay, so that was a small win for Mr. Brennan. But more recently, Welcher's being identified again.
Right.
Not just because he's the blue man in the video, but because he is synonymous with what was done. Whereas ARCCA, it's not really a one-person thing. It's at least 3, really.
Yeah,
right?
and for the first time, I learned that Rentschler is in a different office. He's in Pittsburgh.
Yeah, he's in Pittsburgh. Yeah, I'm going to have to reach out to him when I go see my son there, who's now working for Pittsburgh Pirates.
He's in Pittsburgh. And I've always thought, by the way, that of the 2 crash daddies, even though I know that people were running after Dr. Wolf in front of the courthouse.
Falling down over him.
I hope she was okay after she fell down.
I think she was. I heard she was okay.
Falling down. But I always thought that Rentschler was the most important person. And I think the way the defense has sandwiched him in between Wolf, and then we go to Laposata, and then we go here, is extremely important, because even if they didn't call these other people and didn't prove some of this other stuff. By the way, we went back through, Disney went back through the opening of Jackson, and Jackson never talked about a depressed skull fracture. He was talking about the same depressed imprint caused by an object of some sort. So, so I didn't think he would make that mistake. You have a question. Okay.
Yes, I see that. And it's gone. McRamble on.
No?
I think
Oh, did I grab it? Oh, I'm
yeah,
sorry.
you did. There, now it's back.
McRamble on. Did Hank, I'll read it for you. Did Hank have a bit of a conflict questioning Dr. Laposata, or should he have had Lally cross her, given he knows privileged information about her he could use against her? Interesting question, Michael. As I set this up for you, remember, he's hired her, 2 times here, so that he's been his witness 2 times. Also, in terms of the Commonwealth, she just testified in Dr. Turk case, I think it is, where they got a conviction about a month ago, and it's going to go up in appeal. And our friend Priya Banerjee, it was a forensic pathologist, so that the Commonwealth has an interest in her, he has an interest in her. So, did he have a conflict in questioning her?
I would say no, only because as long as there's not information that was common to both cases. But as we could see, it's fair game to point out that, you know, you're criticizing this person you've hired before. That's fair. And I think if they'd used Lally, if the witness wasn't so important, obviously Dr. Laposata is very important, they would have had Lally do it, and then you avoid even that kind of, you know, I'll use the phrase cross-contamination. But it's not improper, and there's no real conflict unless there's a direct connection between the 2 cases in terms of the evidence or the witnesses or any of the facts. So not a big deal, but it does look weird when you're criticizing somebody you've hired.
Right. So does he then go easier on her? I mean, I guess that's the issue. Does he go easier on her because she is a Commonwealth witness?
Did it look like he did?
Well, I don't know. I thought that there was a little bit of that he handled her a little bit more with kid gloves. I think that even with the when she answered him on the issue of the nightclub and the report, I thought he went a lot easier on her.
Well, they got past that. Remember, there was a sidebar, and there was a big fight about it because he was misrepresenting, 1,500 bodies left in the morgue, that whole thing. And I think that got cut off short during a sidebar because they never went back to it.
Except for one of the commenters, again, one of the posters on Twitter says, she left 1,500 dead people in the morgue. I mean, that was simply untrue.
That was your friend. I think that was your friend, John DePepe. I think that was him. But yeah, I mean, people want to hear and report what they want to hear and report. I mean, that was ridiculous. And I think she did such a good job of explaining what happened and the disgruntled nature of the professional relationship. Anybody who's worked in the corporate world gets it. And I think that helped her, as we talked about yesterday, because she had the principle to say, I'm not going to do this. I'm not going to rush through this important work just to meet budgetary guidelines or new rules. So I'm out of here. I would respect that because I've been in that position, where you've had to walk away from something you might be, paid for, happy to do. But he said, I can't do it this way. I'm not going to do it this way.
That's why I won't work for anyone but myself and my clients, because I want to be able to call the shots, and I want to be able to call the shots morally and ethically. My husband feels the same way. I mean, that's why he had to fight with the city medical examiner's office. And of course, that led to his whole having independence. If you ever read his books about it, because he insisted upon independence as a medical examiner. I think your independence, your morality, your ethics are a lot more important than doing what somebody is telling you to do.
That's, I think we both are in this box, but, there's folks who have the entrepreneurial spirit, that kind of, I'm going to do for myself as I need to do, and nobody's going to tell me. Hopefully I do the right thing most of the time. And some people are not comfortable with that. And so that's what makes the world go round. That's beautiful. But think of this, as I was listening to the testimony about money, and this is going to really come back to bite the Commonwealth in the butt when Welcher gets back on there. He's going on and on about, well, didn't you keep track of your hours? Ed? Where it's like, dude, I'm not in the finance department. I'm salaried. How many times do you hear an expert tell a jury they're salaried,
right?
And that they aren't making any money off what they're doing? I'm just getting my salary, man. Now you put Welcher on there. Mr. Welcher, how much have you made as a result of your work on this case? Oh, $400,000. I mean, that's going to blow the jury away.
And why
if it's allowed?
If it's allowed, why did you? And you didn't use the metered sensor crash test dummy, so they cost $150,000, right?
Yeah. So I can see. So were you saving money by doing the testing you did? So you yourself pocketed more money? Is that what was going on? Those are fair questions. I'm not so sure they're going to be allowed, but they're certainly legitimate. But compare that against the guys like, man, I'm just salaried. I'm not making a penny off of all of this back and forth and putting up with your crap. That's that. Make a note, folks. If you watch trials often, get back to me when you hear that again.
Yeah. By the way,
because it ain't often.
The fan of injustice is up, so you got a couple more questions probably before I leave you. Do you think there's any hint of threat of blackmail on any level in this case for the parties to behave, testify in a certain way? You got 2 more questions after that.
Well, yeah, in theory, there's always that. In this case, maybe I think everybody's heightened to the thought that might be going on because it sounds like some of the witnesses may be testifying in a way favorable to the side they're representing and have been caught in lies to either the FBI or the grand jury. So, yeah, is there a threat? I think there's always a threat. Is it likely? I don't think it's likely. I try not to take the dark side, in the absence of hard evidence, but anything's possible.
Another question for you, Becky Denard, Justice Serve TV, is like sitting in a class and having the most highly skilled and educated teachers, and you can't wait to get into the classroom.
That's so
Thank
nice.
you. Oh, how nice is that?
That's right. Yeah, having done a little teaching, and you've done teaching, obviously, the
Yes.
Harvard way.
Yeah.
I've not
other
done,
courses, other
Harvard won't
courses,
even
right.
let me drive by. So my teaching has been elsewhere as an adjunct professor on things like moot court. But there's nothing like having a conversation with people who care about the subject. I mean, it's simple. We obviously care. People who are watching this stuff, hopefully they care because there's 1 or 2 other things in the world you could be watching. It ain't like the good old days when you just had 3 channels. Remember those days?
Right.
You got ABC,
Right. Those
NBC,
days,
and maybe an
I think
independent
I think I was
somewhere.
a wee toddler. Okay.
I was already a teenager. So so we hope that people select this kind of programming for a very good reason, and if we can connect on that, man, that's great.
And you heard we hit over 15,000.
I know. Well, last night we were, we're always,
like 9 away.
we're looking at these things. I'm not going to lie. We're looking at these things, and so I see last night we were within like a handful, and it just. It's like when you watch something, a watch pot never boils. Is that the old line?
Yeah, that's it. That's the old
So
line.
I stopped looking at it, and somewhere in the middle of the night, we popped over it. So it was nice. Yeah.
And by the way, we have Joanna loves her hoodie. Dizzy's going to make, just on the fashion level, she's going to make pants, all sorts of different pants that match the pattern of the hoodie. So our store, by the way, check our store out just to do a little hawking because everyone's having a great time.
Is there anything left in there? Because you've been buying a lot of stuff. The rack's empty.
I think I'm our biggest customer because every time I buy something, it's so great. It's like, I got to go buy more. And my husband says there's more. I've got Justice Serve TV cups all over the place. I've got yoga pants. I'm getting gifts everybody. I'm having a great time. Shopping is my thing,
Nothing like it. It is, what do they call it? Retail therapy.
Yeah, retail therapy. I don't know what the defense team is going to use when they finish this because they have been, in this case, obviously it depends on what happens after this trial. Again, the fan of injustice is up. Now, they did have a problem with the juror who wasn't feeling very well, who was a little faint. I don't know whether or not she'll be coming back. The judge has so many jurors. If she's not feeling well, she's likely to just dump her off the case.
And I wouldn't disagree with that. They're so close to the end now. Do you want to lose a half a day? I think let's talk scheduling because I think it's pretty clear. Most likely there won't be closings tomorrow. And we've sort of planned accordingly. There could still be closings on Friday. Let's assume you have continued cross of Rentschler, and we assume he's going to get to the substance sometime soon.
Yeah, and then redirect.
Covering the ham sandwich and the salary and all the other stuff. He's going to get to the substance of each of his. I wrote down. I had 7 different opinions.
And redirect, and it's going to be redirect.
So he should go through all of those opinions one by one if he's going to do his job right, if he has time, and then redirect. So that's the rest of today for sure, right?
Right, and then you've got 3 other witnesses, 2 DNA, and I forget who the third one was, but there should be short witnesses.
And then Welcher.
I think that's the 3. Wait a second. You have 4 witnesses as rebuttal witnesses, 2 DNA, Welcher, and I forget who the other person was, but they should not be very long, but they're going to take a whole day, at least.
I would think, depending on how many interruptions and outbursts. So that puts us, to me, Friday at the earliest for closings, and that I think that's going to be a Judge C decision as to whether or not it can be done versus should be done.
Yeah, because
Probably,
apparently they've been doing their jury charges back and forth behind
yeah.
the scenes. Right.
And that's going to be whittled down. They're going to have like 5 that are, to die for. You got to, which ones you're going to pick. And we know one of the Commonwealth is the one about the witness intimidation. Let's can we get an instruction on a charge that doesn't exist? Is that all right? I'll allow it. I mean, and who knows what she's going to do?
Right.
But yeah, there will be a fight on a handful of potential instructions.
That's right.
Proposed instructions.
By the way, Blessed in Texas, I know that a lot of people are reporting judges. This is not we're not suggesting you do that, but this is the Board of Bar Overseers to report a judge because I said I didn't know. I mean, I know.
Is that a local agency? Is that a state agency?
It'd be the state
agency?
the bar, the State Bar of Overseers. Okay, thanks for researching that, Blessed in Texas. Appreciate it. That's not to say you should report her, but at all. But that's who is over. And they can, in New Jersey, they have to get I think they can even do it sua sponte if they see something wrong. But remember, she's a big deal up there. I don't think they're going to find anything wrong because remember, the U.S. Supreme Court didn't find she did anything wrong with the sending the jury back. The Massachusetts top court didn't find anything wrong that she didn't do anything by not, asking the jury questions. So.
In that case, though, if I can draw on distinctions, it may make a difference. They relied on the fact that this new trial was the remedy, right? They can give her a pass. Right. So I don't think they had to dig in too much into what she did wrong because the remedy was already in place. It was coming.
Right.
I still am waiting to find out whether or not there's an instruction on. Can you come to a unanimous decision on any counts versus all counts?
We should go look at the California instruction that they gave in ASAP Rocky, which was about 2 lines, and that's basically what it said. By the way, Linda, thank you for the donation from Linda. Do they give the same amount of time for closings? They're each going to get an hour, unless the judge.
That's the latest we heard. Yeah, that's always subject to Judge. Could you reconsider that? Give us an hour and 15 or whatever.
And they'll get the same amount of time. Whatever it is, they're going to get the same amount of time. Okay, whatever it is. If she decides to extend that rule and give them an hour and 15 minutes, they're going to give you the same amount of time. Okay, so you have my rant up there for today. It was a mini rant. I was very calm, but I was very passionate in how I felt about what is happening out there. And I think that people, I said, please don't do that on our stream. Talk about, whether Judge Beverly could be drinking or not, or anybody, because I just don't want, if some people have an alcohol problem, alcoholism is a true disease. We've seen family lives ruined from that. And the same with how you look, how you feel, what your health is. Let's not go there. Let's be great on the stream because you all are great. And for those that have streams, and there's I saw a couple of major networks. One major network that we know very well had all these people on. I guess they weren't monitoring their Instagram or whatever. You really should say, don't do that here. I mean, that's my opinion. On the First Amendment, I agree that you have a right to say anything. But you can ask people not to do it on your stream. You don't have to remove them, but you can ask them.
Yeah, this is not public property per se, so we do have the ability to at least request some sort of civil discord.
Right.
And if you don't,
and that's what we do.
Then there's 1 or 2 other places you can go.
Right. Yeah.
We hope you don't, but if you want to be that way, then this is probably not the place to be that way.
Yeah. That's what we ask. I mean, we're First Amendment fundamentalists. That's why Michael sued for the First Amendment rights. But we do ask that you try to be decent. And then even last night when I was answering some questions, I come after the show airs, and there were a couple of them that were pretty bad. I said, look, we believe in the Constitution of the United States, proof beyond a reasonable doubt. And in Massachusetts, it goes further. It's not only does the state have to prove beyond a reasonable doubt, they have to prove it by a moral certainty. It's like California. So.
Yeah. And that's, it's kind of ethereal type language, like, ooh, what does that mean? Mm-hmm. I mean, really, I don't know how close you can get to 100%. If can you be 99% and that's a moral certainty, or does it take 100%? I don't know.
Well, for me, it's 100%. I've got to be 100% before I'm going to put somebody in jail for murder. I've got to be 100% sure.
Yeah. It's just
maybe because
I don't know if that added language makes a difference. I mean, beyond all reasonable doubt is also kind of squishy,
Right.
So
what does that mean? No one really knows what that means.
Of course not. Yeah.
So, but
Okay.
but you know, it means a good amount of certainty. So, are they back yet? No. The fan of injustice is
I don't even see the
reeling.
fan. Is the fan still there? Oh, it's
Yeah,
down below.
still
Okay,
there.
I got you. I got too many things opened up.
The fan of injustice. So, do you
So you're
mind
heading
if
out.
I
You got
leave
something
you?
going on,
Yeah, I
right?
have something going on. I will be listening. I will take my AirPods with me, and I will be listening. And then I will be back at 6 with Stephen Plord. I did send a text back to Stephen Plord and say, look, if your meeting ends at 6:30 and it's better for you, we can start then. I have not heard back from him, but he is going to be on tonight. He's probably going to be on at 6 because I know that he's been watching this
I'm sure he's
we've had
got
a
some
call.
thoughts.
Yeah, I'm sure he does too. I'm sure he
Well,
has
before you
thought a
leave,
lot.
one further update. I heard back from Imran, attorney for Weinstein.
What's
and
happening there?
He said tomorrow night, and so we'll see. He said, "Sorry, I'm kind of slammed." I said, "I don't know what you're slammed doing. Come on, can you just come on?" But obviously, they made a motion for mistrial yesterday, which was denied. So
Well,
I'm not sure.
you saw that's happening there. What a
Well, yeah.
wild jury
Yeah,
discussion.
they've got,
you know?
talk about, I mean, that's a rogue jury. Now, that is nasty. So they have the two people that have reached out, I guess, or made it, I guess they haven't hidden their thoughts about whether others on the jury are being influenced by things outside of the trial. They're basically suggesting, these two jurors, that people are bringing in the information that was purposely excluded and led to the retrial. Remember, there were a number of people who testified in the first trial against Harvey Weinstein that they suffered sexual assault, etc. Those were left out of this trial on purpose because the higher court said that was inappropriate. Well, apparently some jurors are taking it on their own to find and incorporate those prior bad acts, which is what they were, which were excluded, into decision making in this case. How is that not a mistrial? But anyway.
I love the fact they want coffee. I mean, why don't you just set up a Starbucks in the jury room? I mean, you're sending a jury in without coffee? I mean, are you kidding
They aren't
me?
getting any.
I
I
would
mean,
die.
I don't drink coffee, so I'd survive. But do they not have it available in the
I
courthouse?
guess not. I guess
That's
they don't. I
weird.
guess well, maybe in the courthouse, but not in the jury room where people want to get more coffee.
I can't believe they. I mean, usually when the jury's deliberating, they're very important people, and they usually, they arrange the lunch. What do you want for lunch? Whereas coffee?
Budgets. We've heard about budgets. It
Yeah,
all
well,
comes down to
California,
budgets.
as a Californian, I've seen how that works. I didn't know it was that bad here as well, or in New York as well.
Well, I guess the FBI has restrictions too because they have budgets on they don't want to have people spending $450,000 on three crash test dummies when you could just buy, $200 lights, 12 of them. That's all.
Okay, get out of here. Go do your thing.
I will see you. Oh, by the way, Carol, just before I go, I see this is directed towards me, and so I'll answer it. Linda from Carol Johnson, I'm a retired attorney. You are by far the most knowledgeable and articulate person on the trial streaming platforms with my partner here.
Yeah, thanks.
I appreciate your experience, knowledge, and candor. Thank you so much. Thank you very, very much. We really appreciate that, Carol. All right, I will see you all 6. I will be listening. Please keep Michael Bryant company. Okay.
Yeah.
All right. I'll see y'all. Bye.
Okay. So let's talk a little bit about what happened earlier today with the testimony, because there actually was some testimony. You may have gotten sidetracked by all of the shenanigans and all of the nastiness and the backbiting and the objections that were or were not sustained, depending on who was making them. So I mentioned when Linda was here that there were 6. I have 7 different opinions that were offered by Dr. Rentschler, and I've proposed a. We do a little thumbnail. By we, I mean Missy does a little thumbnail for our show at 6 o'clock. And I've proposed Rentschler's list. Is that bad? Is that disrespectful? Is that inappropriate? Anyway, his list includes a number of opinions, all of course suggesting that Welcher / Aperture just dead wrong on everything they did, everything they should have done, everything they didn't do. I love the way he just what became known colloquially as the paint test, it just got trashed, and it should have, because it was, as our crash daddy, and he'll talk about it a little more tonight, I'm sure, Steve Plord said, he didn't go far enough. I don't know if he even got out of the box, because it just looked like a joke. It looked like a high school play. Here's Welcher dressing up, literally dressing up like the decedent, and then smearing some paint on the taillight area, holding his arm in a way that they believe it happened, and then having a car back up at 2 miles an hour to imprint his arm with the paint. And Rentschler went as far as to using their own video against them to say, look, see how from the shot down the side of the car, you can see that the car would be hitting him about, let me do it this way, about like this, not even touching his elbow or the upper part of the arm. And we know there are wounds in this area here, all through here. And at the last minute, he darts in front of it, sticks his hand. I don't know if that's what happened. Nobody knows if that's what happened. But to point out that it was just kind of a random way to incorporate the entire arm in the test has to make the jury, at least the goal is to make the jury question whether that test means anything at all, rather than, it's Welcher's opportunity to play dress up, right? Because the results, as Rentschler made it very clear, they don't mean anything. They don't weigh forces. They don't weigh impact. They don't talk about body mechanics. It's just this guy dressed up as a victim, as a decedent, and having a car very slowly bump into him. Anyway, you'd like to think, I'm not naive enough to think everybody on the jury is nodding along with Rentschler, that they're saying, yeah, Welcher is a clown. I'm not naive enough to think that. I hope that people see the mistakes that might have been made in the testing done by Welcher, or the lack of testing. But I don't know. There could be people that just like Welcher and don't like Rentschler. It's possible, right? I saw some. I try to keep up. Linda is so much better at the gathering of the notes. She's really, really latched onto them. Not me. I've got to see them go by. So I apologize for that. In timeout, Rentschler pretty much told Brennan, no one knows what happened. Hank didn't hear that. That's been my argument since day one. We get to the end of prosecution case. Okay, they should, when the prosecution's done, you should be like, hands down, this is what happened. This is how it matches the law, guilty, not guilty. I don't know what the hell happened. Not just at the end of the prosecution case, at the end of the defense case, which is where we are pretty close. We believe Rentschler will be the last defense witness today. Then we're going to have a few rebuttal. There is nothing, well, almost nothing I could hear between now and the official resting of the entire case that would lead me to know what the hell happened that night. Might get a couple more tidbits that make it sort of possible this happened versus this. That's not certainty beyond a reasonable doubt. And so to me, just on that common sense level, it's an easy decision. If I'm in the jury room, I'm asking my fellow jurors, okay, tell me what happened. And then let's talk about how you got there. Because there will be people that just jump to the conclusion that they want or that they believe is being sold to them and have no real reason to understand how, they really just won't understand how they got there. So you got to probe, So you think, let's start with this. You think John Okeffe was hit by the car. Okay, how do we get there? What do you think? What do you believe? And then you just, you want that person. That's how the process works. It's the challenging of one juror against another. And if you've got the wolves versus the sheep, the wolves will win, period. The wolves will win. The question always becomes, how many are there? And is the foreperson one of them? And how many, if you have more than half of them sheep, they have no choice and no chance. They will fall for the wolves, whomever they are. You saw the juror from trial number 1. I call him Bowtie Ronnie. That's a sheep. That's a follower. That's a guy, may have some ideas, may have some thoughts, but he's going with the pack. And that's the way jurors fall. They're humans. That's just the way it is. So how do I get into that part of the process? Because it's coming up, I guess. And I haven't been convinced yet that anybody has told me what the hell happened that makes perfect sense. Bits and pieces. Yeah, I could see some bits and pieces that do seem to connect, but not the whole story. Not the whole story. Let's see. Oh, this was a follow-up to the prior. Acquittal is too much reasonable doubt, even for people who would like to see her convicted. That, again, if you go into this wanting or preordaining a conviction, you just, it's the case for whatever reason. Either you have friends that believe it, you just think based on the overall situation. Somebody had to have done something wrong for Officer John Okeffe to be dead that way. You're going to listen to what you think gets you there. I mean, talk about confirmation bias. We talk about it all the time. That's the real world application, not the legal world. That's the real world application. And there are people, we see them online all the time. And what their motivation is, I don't know. But I believe they're closing their eyes to things that take them off track. They're closing their eyes to things that dissuade them from that confirmation bias. If something comes along that doesn't support that narrative, they never hear it, never see it. And that is human nature. And I'm not saying there ain't somebody on the jury that will fall for that, to be part of that. That voir dire process with the jury, nothing's more important. And part of what you're doing is trying to ferret out those people. I just don't know that it's possible. I just don't know that you can be certain somebody hasn't pulled a fast one on you, and they are, I think Linda calls them the stealth jurors, that they're on there because they want to be. Saw you on True Crime Show the other night, talking to expert, giving evidence. I can't remember what trial it was. Well, I'm not very memorable. So I've been, there's so many of those shows that I've done. I mean, some of them I've done over the years. Remember the World's Dumbest Criminals? Did a ton of those. I'm trying to think of others that I appeared on regularly. A lot of Forensic Files. Any of these true crime things. Quite often they would say, "Yeah, can you do this?" I said, "I have no idea what the case is about, but I can find out. I can study, and I can do that for you." And so I would. I did notice somebody sent me a picture. Dang it! I wish I had it here. Somebody had posted in the chat not long ago the new Pee Wee Herman documentary, that they'd seen a picture or some video of me when I was at Extra interviewing somebody or following the case. Then a friend of mine sent the picture. If I could find it, I should, because it's embarrassing. My wife sees the picture and she says, "You look decades younger then." I said, "Well, thank you very much for that." But I have not seen the show. So if anybody's seen that Pee Wee Herman documentary, let me know how it is. I've heard decent things about it. I can't remember. Is it on Netflix? I think it might be. No, it's on HBO. That's right. It's on HBO. Anyway, it's well, here, I think I might have found it. At least I can hold it up and show it. It's so embarrassing. Okay, so there's the picture. Can you see the dude in the back? There's the woman there. The woman, I think, is maybe one of his attorneys. I don't know. Anyway, see that dude in the back with the extra microphone? It looks like my very much younger brother. Yeah. Anyway, so I want to see that show. If somebody's seen it, give me an idea whether it's a recommendation or not. Wait, we have further information on this. A candid photo that showed on the screen. They were talking about the expert appearing in world renowned. Wish I could remember. Okay. Thank you, Terry Friday. So what do you think about the scheduling? I'm so relieved. I know it's all about me and it's my schedule. But I was going to be hitting the road tomorrow. I've got these cases. Their filing deadline is looming. And I thought I'm going to go up there and I'll come back, spend all weekend on these cases. Then I have to go right back Monday, because I don't believe, even if they got the case late tomorrow, early Friday, that they're going to come to a decision that quickly. I just don't. Remember 4 days last time. Every jury is different. I always look at the OJ case. They have that dumb rule that 1 day of testimony, 1 day of deliberation for every week of testimony. And you have the OJ case, 9 months of trial and 4.5 hours to a verdict. So I would say that's on one end of the spectrum. So now the plan is, if they do actually get done tomorrow and closings are scheduled for Friday, I'll just go up very early Friday morning, do my thing, come back Friday night, then go back again Monday and camp out for however long it might take. So anyway, what do you guys think about the scheduling? When we see these witnesses and the way it's halted, and then sidebar, and then it's restarted, and then, do you have any doubt that they're going to need most of tomorrow just to get through the last handful of these folks? I can't imagine Brennan getting done with Rentschler before the end of the day. Because if he's truly going to go through, as I was going to go through before I got sidetracked, we're going to go through these different opinions, he is nothing if not deliberate. And because he's allowed to ask and re-ask the same questions, it takes longer. You know, if some of these objections were sustained because he's asking questions that are inappropriate, they're called for speculation, they misstate the evidence, they're calling for inappropriate opinion. All of those are being allowed, and they all take time. So I can't imagine it. I'm looking through my notes. How do you like my little baby notepad, my baby legal pad? When I was driving the other day from here to Pittsburgh, dropping off the kid, as I mentioned, he started a new job with the Pirates since his graduation a few weeks ago from college. So I was listening and actually joined the broadcast from the road somewhere, just through the Starlink up, which is amazing to be able to do that. But as I'm driving, I've got this on my knee, sort of, and I'm just kind of making brief notes as safely as I'm very safe. I'm an excellent, excellent driver. So I'm making the notes as best I can. So I've got a few of these left over. So now I'm just using them. It reminded me of when you fly as a pilot. I've got a pilot's license. And so you use something called a knee board or a knee pad, because you quite often, if you're flying instruments, meaning you're in constant control with the air traffic control, just like commercial pilots, they'll give you a route, you know, fly runway heading, blah, 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 turn left to heading, blah, 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 you know, descend and maintain altitude, blah, blah, blah. You want to write that stuff down. So you have a little knee board. I should get one of those. It's great for driving until you cause an accident. But yeah, so that's what I was thinking as I was doing that. So this is like when I was flying. Anyway, looking at some of my notes. Don't forget, we have our own Crash Daddy on tonight. We will go through some of these things ad nauseum, because his perspective is obviously not just real world, but it's interesting. You know, it's stuff you don't think about. And for him, it's like breathing, right? He's been doing it for so long. Let's talk about, I'm going to talk about a couple of the opinions before we get back in there and pick up the cross-examination. Obviously, the key opinion is none of the injuries that we see to John O'Keeffe's arm were caused by contact with the SUV. I mean, that's game over, if you believe that. Maybe the jury does, maybe they don't. But that's game over. To get further into it, all of these slides, remember all the slides at the court, that's not coming in. That's not coming in. You need to take the text off of that one. You need to redact that. You need to move, you know, the court gutted the presentation by Rentschler in terms of all of these slides. I think it's been great anyway. The jury doesn't know what they're not seeing, right? That's a very good question. Domino was, you know, when Lisa's home, he kind of hangs with her and he's less needy because she's right there. But, you know, if I'm here by myself, I almost always leave that door just a little bit askew, a little bit open, so that he can pop in. And, you know, it's so funny. He just, you know, if you're a dog person, you get it. He'll just come in, kind of say hi, check in, and then just toddle off to whatever he's gonna do next. Let's see. Oh, here's a question. Yes. That's a short answer. Yeah, when I was back in my 20s, I was there's a family that I was in a prior life. They were all pilots. It was, you know, so I was exposed to it. And so I said, well, I'm going to learn to fly. And so I did when I was in my mid-20s. And then after that, I learned VFR. That's called Visual Flight Rules, which is when, you know, it's a nice day, you can go fly. And I'm not flying crazy planes. They're single engine, fixed gear, fixed prop. They're very simple airplanes. And then I thought, well, I was in California at the time, in the Central Valley. They have a ton of fog. That's their winter is a lot of fog. And so if you can't see 3 miles, right, 3 miles, and have a ceiling of a certain height, ceiling meaning the cloud deck, you can't fly. Those are visual flight rules, right? But if you have IFR, instrument flight rules, you can go to what are called flight minimums, which is what commercial pilots use, which is usually like 200 feet and clear of clouds. So you could fly if you can see only 200 feet, which ain't very far. Think about driving and only being able to see 200 feet as you're going 60 miles an hour. It's gone like that. But with flight instrument rules, because you're flying on instruments, you can really get down to almost, you know, pea soup. If you've been in a jet and they're taking off, and you're like, how did they even see the runway? Well, quite often they don't. And it's clear of clouds, meaning you can't fly in a cloud unless you're on the instrument system. So I did that. That was the second thing that I did. Next level of stuff. Haven't used it in the last few years. It's become less needed. And so, I've still got it. In fact, I carry, I think I have it. Hold on. Oh, it's not within reach, but I have my pilot's license. I always keep with me just because it's one of those things that once you earn it, you go like, I'm going to keep it because at least I earned it. So that is a very long-winded answer to your question there, Brooklyn. And I love it. It's just what it does, though, is makes me a worse commercial passenger because I know more than I should. And so I'm more kind of in tune to things that seem a little off, even though I've never flown a jet. Still, you got to, the air traffic control system, you know a lot more than, sometimes it's good to be naive. Sometimes it's good to, not know when a problem is on the horizon. Sometimes it's good not to know that more crashes happen on takeoffs than on landings. I mean, sometimes it's good to know those things or not know those things. Anyway, where was I? Oh, the question from Brain McBran. I wonder what the jury members will think when the trial is over and they get a chance to see everything that we're not allowed in. I always think about that. And when I've talked to jurors after the fact, they will have questions that, make it very clear if they had learned everything that you knew and that was kept out, it would have changed maybe their opinion on the case. But most of the time, that stuff is left out for a reason, a good reason. In this case, we got so much stuff that should be in. The one key thing that keeps coming back, and especially in the ARCCA testimony context, FBI. What is the big problem if the jury knows it's not an organization, not the insurance company, it's something else, some sort of other agency? Why not? I just don't understand why the judge, who is so interested in instruction giving, can't just say, ladies and gentlemen of the jury, there was an FBI investigation prior to this trial. It is not your concern, the nature of that investigation or the results. Thank you very much. And then you move on. It's just so simple. Anyway, we'll see, because I guarantee you there will be talk in every jury. There are talkers and there are people that want to get the hell away from you and never talk about the case again. Do you find knowing IFR helps with helps you deal with problematic judges? Funny, I've not been able to mesh those two disciplines, flying in clouds. But if I think about it, an analogy, I could come up with one: flying in the clouds and crazy judges. In both cases, it's difficult to see where they're going. In both cases, crashes can happen. Anyway, no, instrument flight rules does not seem to apply directly to trial work. No. This is also a good question. We know you can indict a ham sandwich. Can you impeach a ham sandwich? Good question, Creedam. Have you ever heard of impeaching a ham sandwich? When that started happening, I thought somebody put an SNL skit on. So what is going on here? He's talking not just about the ham sandwich, but he's talking about an Uber ride. Where does Mr. Brennan come up with this stuff? I guess there was a ham sandwich, but the witness says, I didn't even consider an Uber ride. I took the ride that they provided. It's just, as I've mentioned way too many times, it's so desperate. It is just such a desperate sign. When all hell is breaking loose, you're grasping. And that's clearly what is happening here. Sorry, just cruising, just wandering around. Hey, I love how you guys talk about everything. It's really, and I'm not trying to out anybody by highlighting a comment, but some of them are just so funny. Yeah, so in the same theory here, Creed. I know you've heard of indicting a ham sandwich. Yep, I know you've definitely focused on. I'm guessing that Creed is going to have a ham sandwich during the lunch break right now, which actually sounds pretty good. My meals are all screwed up. I'm eating breakfast too late, so then I'm eating lunch too late, which messes up whenever dinner might happen. I'm blaming this trial. That's all. Okay, 007. I hope they deliberate for half an hour, but then will we be live to chat during the deliberation? If so, I don't care how long they take. Well, that's an interesting perspective. Uh-oh.
What is now open, you may be seated.
All right, while the jury is on their way in, I need to see counsel at Sidebahhh.
Of course you do. Okay, so that was fun. So this, I'm guessing, is going to be some scheduling, perhaps, because I'm assuming they hashed out all of the substantive battles that they were having prior to the lunch break. But let's hope they give us some insight. You know, don't you think, Judge, that the parties after, has it been 8 weeks? I know this is the 31st court day, and I will say that on balance, they've been pretty efficient in using their days of the week. They had a hiccup here and there, but not bad, really. I think they've probably averaged more than 4 days per week. So where are we? Week 7, something like that? Don't you think all of the players can take a breath, including the jury? I know we had a long weekend at one point a few weeks ago, but now we're there. You know, the last thing anybody really wants is a jury that's exhausted and can't pay full attention to what's happening in closings, instructions, and the beginning of jury deliberations. And they're going to need some energy for those deliberations. So let's give everybody a break, set it up, get everything done, clean, neat, tidy by Friday, come back Monday, fired up. And we're back to the fan. Was the jury not in place? I guess maybe the jury was not in place. So this will be interesting after the tongue wagging of Hank Brennan and the outrageous commentary that had nothing to do with the questions being asked, but were snide, just pissy little remarks. Again, signs of desperation. Let's see what this is about now. Where is he going? Is he going to actually jump into the opinions like, oh, I don't know, Dr. Rentschler, it's your opinion that the vehicle never struck the arm because the injuries are inconsistent? How about that? How about that for a question or a line of
Mr.
inquiry?
Brennan.
Let's go.
Jurors, hopefully it'll be comfortable enough in here this afternoon. The court officers has done a great job keeping the AC going while we were out of the courtroom. So.
Dr. Rentschler, you wrote a report back in February 2024?
That's correct, yes, sir.
And in that report, you provided a number of opinions, didn't you?
I did, yes.
Do you remember if you opined or had the opinion that the injuries on Mr. Okeffe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct, yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. Okeffe's right arm.
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder, correct, and the wrist.
And so you're saying not superficial abrasions, but in the arm?
Yes, when you look at, and you can see from the testing we did for this case, for this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
And the x-rays that we looked at, or that we saw, and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself, no, sir.
And a crash test dummy is different than a person, isn't it?
Certainly it is, yes,
No
sir.
muscle,
That's correct.
no ligaments.
That's correct.
The crash test dummy does not react or respond like a human being.
Well, it does to a certain extent, yes.
There are differences.
Certainly there are, yes.
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside?
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm, you would agree, doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside?
No, of course, that they're not the same. No, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did, yes.
And in his report, there were a number of references, weren't there?
There were different references, but I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references, did you look up the references?
I did, yes, sir.
Okay. And when you were saying earlier that there was only one reference, you were referring to the paint test, correct?
Well, I was referring to, there's only one reference specifically with respect to automobile pedestrian impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer-reviewed?
Yes, sir.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references did you read out of those 20 pages of references that he offered?
Well, I didn't read any because they weren't referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those references?
We don't allow that.
He didn't cite to any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
I know what he cited to and he referenced to in his report in PowerPoint. That's the extent.
The question is, you don't know what he was referring or reading or relying on other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yes, certainly other articles in the 60s, 70s, and 80s he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
Well, I think there were, let's see. 26, I think.
Those 26 references, are they offered in your report to suggest some type of support for the proposition that you're promoting in the report?
Well, they support the opinions or the methodology or both with respect to what I've offered in this
The
matter.
reason why you put a cite in is suggesting that it supports whatever proposition you're footnoting on that.
To some extent, or the methodology or some information pertinent to that opinion, yes, sir.
Regarding crash test dummies and prediction in soft tissue injury, you provided 3 sites, didn't you?
And soft tissue injuries?
Yes.
Can you show me where it says that, sir?
Footnote 11 of your report, Mr. O'Keefe's right arm kinematics during impact with the Lexus are inconsistent with producing the documented cuts damage to his right sleeve as well as the abrasions to his right arm. Did you write that?
Yes, and which one was that again? I just want to make sure. What was the number?
You cited footnotes 24, 25, and 26.
Yes.
And when you cited 24, 25, 26, did any of those 3 sites, in fact, those are the only sites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of sites is limited to those 3 articles or 3 papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the 3 that were provided, yes.
Starting with number 24. When you looked at 24, did it ever suggest in this paper Did it ever suggest that it was appropriate to use a crash test dummy in the material of a crash test dummy to make an analysis or determine whether or not there would be documented damage to someone's skin?
No, it didn't, and that's not what I did in this matter.
In this article you cite supporting the claim that you made, there is nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not, no, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cutability and its relation to lacerations, severity, indices. You know that, you cited that.
That's correct, and it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
And it tells you 3 types of skin were examined and used for this type of study. Post-mortem human skin from 2 different body sites, Cameos leather, and Napa goat skin. Is that correct?
Right, to look specifically at laminated glass and it's the cutability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it is different, sure.
Yeah.
And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that. No, not in that manner. No, sir.
And then you cited number 24 or 25. You cited a book, Forensic Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that crash test dummies are appropriate to use when making this type of analysis, does it?
Correct, and that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involves, sir.
My question was, nowhere in that book does it say that crash test dummies are appropriate for analyzing skin lacerations on a collision, does it?
Sure, I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article, Understanding the Acute Skin Injury Mechanisms Caused by Player Surface Contact During Soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
Are you aware of literature relative specifically to the use of the hybrid 3 crash test dummy, which was used in this case?
There's a lot of literature with respect to the hybrid dummy, yes.
Have you ever heard of the person by the name of Stanley Bakatis?
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field with crash test dummies?
He is, yes.
Right. Would you agree that we also do not believe the current instrumented arm configuration is suitable either for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used for that. It shouldn't be used in that manner. That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keeffe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation position of the taillight cover. And then right under that, he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the taillight cover. If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John Okeffe when he was hit by Alexis?
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that, and again, that's the only test that he's performed or referred to in this case.
You inferred that?
Inferred that that's how he believes that the arm was positioned?
I think we understand your perspective is that the only test he performed, but what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welcher ever represent that he was trying to describe the actual body position of John Okeffe when he was hit?
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keeffe's right arm to compare and apparently demonstrate that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose, but if it's not, again, then I'm not sure what that test actually accomplished or represented.
You've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right, I'd change my opinion that there's no evidence, no analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer. Is there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keeffe's arm was when he was struck by Alexis?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Rentschler, anything, that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keeffe when he was struck?
Objection.
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keeffe was actually positioned at the time of this alleged incident. You're correct.
Do you know whether Dr. Welcher has been clear that he does not know? Let me say this a different way. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keeffe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keeffe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that that actually occurred. That's the basis. Yeah.
So,
if you don't have the information, you can't replicate what happened. You can't determine You can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
So if you were to do a crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision, that wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
So if an expert does a crash test and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you?
I'm gonna, very briefly.
All right. Sorry. Once again, I'm plugging, I'm unplugging, plugging back in. And I assumed as soon as they got up there and I got plugged in, they'd be done. So here's Hank Brennan and his reverse psychology, because he knows that Welch's one experiment is trash and it's been trashed. So here's his theory. You go back against the experts' opinions, which have been made over and over again based on a reasonable degree of scientific certainty, right? And he's saying, well, how can you make your opinions certain if you don't know the distances or the weights or if it actually happened? Well, that's the process. These are hypotheticals. You know, here, and the hypotheticals, all of the facts are certain. The weight of the dummy, the speed of the car, the location of the impact. Did those things happen or not? Hank Brennan is making the defense argument. He doesn't know what the hell happened. The witness doesn't know what the hell happened. The jury doesn't know what the hell happened. I'm not sure this reverse psychology play by Hank Brennan is paying off here. Is the jury supposed to think, oh, he's right. Nobody knows what the hell happened. I think the Commonwealth's proven their case. I don't get it. I don't get it. And then he likes to attack. First, he attacked Rentschler's CV for referencing working with wheelchair mechanical issues, making them safer, understanding how people were injured in wheelchair related incidents. And then he's now moved on to attacking the work he did with some sort of soccer study. That does not help you in any way in determining the issues in a motor vehicle accident as happened here, correct? No. Next. Anything else? And then I think he got in trouble too when he to go. I don't know what else to tell you because that's the only test that that Welcher did. So, okay. More Brennan, please.
In reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his paint test was supposed to be a reenactment, identifying the details of how Mr. Okeffe was standing, moving, or holding his arm at the time of the collision?
He did not state that. That's correct.
So when you've made your criticisms that you've done testing regarding Dr. Welcher, you don't have any evidence, any statement by him that he was trying to reenact the actual collision?
When I did that, there's one test with the arm like this. That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keeffe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Other than your opinion, let's get back to my question if I could.
I believe I answered at the beginning of that, sir.
I'm going to ask you again. My detailed question is, there is nothing in Dr. Welcher's report or any of his presentation that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keeffe when there was a collision. It's not anywhere in there where he stated that, is it?
It's not stated. I'd be curious to find out what that, if that wasn't the intent of the test, I'd be curious to see what the actual intent was.
Is the answer no, it's not in there?
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again, is the answer no?
The answer is no.
When you do crash tests, you have a controlled environment in some respects, don't you?
You do, yes, sir.
You get to control some or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, doctor?
I don't know, is it?
What I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where the variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to conclude that something happened and this is how it occurred, you have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing a certain test to prove something, you have to look at how those variables may affect it. But there's basic information you have to know to perform that type of an analysis.
So my question again is, are there scenarios where variables are impossible to predict?
There could be, yes.
Have you had cases yourself where there are variables that were impossible to predict?
I suppose I probably have. I mean, it depends. If you don't know what happened, sure, then you don't know those variables necessarily.
How many cases have you done on pedestrian accidents?
Done hundreds of cases.
So you have a good background and basis to know whether or not there are variables that sometimes you can't predict, don't you?
Sure. As I said, it depends on the case.
When you did the crash tests in this case, did you actually do them?
I did not, no.
Were you even there when they happened?
I was not, no, sir.
So you're relying, in part, on Dr. Wolf's work.
I am, yes.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in tests E and F on a forklift, you remember those?
I do, yes.
When it's on the forklift, it does not allow the crash test dummy after being struck to move, to be thrown, does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction. It's can it show the throw? Can it throw or move the crash test dummy in its natural course after the collision to a resting spot?
No. In those tests, though, there wouldn't be any throw.
If a crash test dummy is restrained by a forklift, If a crash test dummy is restrained by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it does not. Well, no, actually it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down anyway.
Have you seen crash test dummies where it is held in place electromagnetically, and when the collision happens, then the dummy can move? Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash test with crash test dummy where there is a light? I'm sorry. Have you seen crash tests with crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before the impact?
I have, yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
If you answer my question.
I just did answer it. I said it wasn't.
When the crash test dummy is held by a forklift and the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move at the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion, and you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and a fender vault, isn't there?
There is, yes.
A fender vault is a different type of collision than a center of mass collision, isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios with a crash test dummy on a fender vault collision, isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have 59 of Dr. Rentschler's PowerPoint, please? In your PowerPoint, you cited an article, Vehicle Pedestrian Collisions, Validated Models for Pedestrian Impact and Projection, correct?
Yes.
And you put snippets up on the board?
Yes.
Okay. And these snippets talk about an engagement with the pedestrian in the vehicle?
Correct.
Okay. Is there a reason why you took out a piece of that article that falls between those two paragraphs?
No, I don't think so, no. Those are the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle front? Alternatively, the transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet, and these situations are known as fender vault. The models presented here do not apply to fender vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many, many sources where it talks about front-end collisions, because that is the majority of pedestrian collisions, the front end, isn't it?
The majority,
Yes.
It is, yes, sir.
And so there is a difference between fender vault and a center of mass collision, isn't there?
That's correct, and that's why you see a center of mass, you look at the testing we did, that's a center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass, you're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So yeah, it's completely different. It doesn't pertain to allegedly what occurred in this case.
So let me get back to my question. When the tests were done, E and F, F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was he, the
24 miles per hour.
No, it didn't hit the center of mass of the
Right.
dummy, it just hit the arm.
Exactly. So there is a difference In this case, you don't know the position of Mr. O'Keeffe's arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no. I don't know the position of the arm at impact because it wasn't hit by the car.
You don't know the angle of his body at impact, do you?
The alleged angle?
So ask the question again.
Okay. You have no information about the angle of Mr. O'Keeffe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
We have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
When you talked about force equations with this jury, you cited a number of pieces of literature, didn't you?
I did, yes.
And when you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand.
Yes.
Could we see slide 8, please? Okay. Let's try slide 56. You would agree with me, Doctor, there's a difference between a concentrated and a distributed load, wouldn't you?
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force equations, was that distributed load or concentrated load?
That was the load at the center of mass. And so you can evaluate that on a distributed load. You look at acceleration and you look at bending moment. So you can do both.
When you gave your charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
But we're assuming center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with the hand. But center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure, if we're talking about force over area. And that's what I evaluated in this case.
When you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
Okay. There's a difference between taking a small object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they use the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data?
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow that.
I'll strike it. Did you consider Apple Healthcare data?
No, sir.
I'm going to allow it.
Did you consider phone temperature, battery temperature data?
I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again. Did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Are those your words?
For a biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
Yes, sir.
And you've seen in your videos E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking.
Yeah, and I think it's
Excuse me, sir. In a collision, have you seen debris fields?
I have, yes.
Have you seen debris fields where a taillight would shatter?
I have, yes.
In fact, in your video, yes or no, after the collisions, in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no, you don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of
Could I
an
have Exhibit
individual.
73, please? Do you see that, sir?
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Right. Is that an alleged part of a taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight cover.
Well, when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, I don't, was that part of the one that was recovered by a leaf blower or not?
When you were doing your ample study, sir,
Yes.
what I'm asking you is, when you were looking at all the available evidence, did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road? Were you aware of this?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue at this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
Do you have any evidence in your biomechanical studies how this alleged piece of taillight shard ended up on the front lawn of 34 Fairview?
I don't know, sir. I didn't evaluate or investigate that.
Could I have Exhibit 76A, please? Did you see this photograph, sir?
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight shard?
It looks like it, yes.
Did you consider this in your biomechanical studies, that this taillight shard was found in front of 34 Fairview Road?
Was found. Can you give me a precise distance from where the body was found and where that was found with respect to Mr. Okeffe, with respect to a reference point?
Did you consider this, sir?
There is none, so no, I did not consider that.
Do you know how this taillight shard got there?
How it got there?
Yes.
That wasn't part of my analysis. There are certainly different possibilities of how that actually occurred.
Exhibit 99D. Do you know what that is, sir?
It looks like part of the light assembly.
Mr. O'Keeffe's hat?
Oh,
Did you
that's
look at
his
this
hat.
photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Right. Is one of those ways being in a collision with a Lexus?
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that where we're getting at, sir?
Sustained.
By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those.
It says I reviewed medical records and reports. That's how I actually word in every report I have. I just put generally that. It refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74, please. Have you seen this photograph?
I have, yes.
Okay. In your studies or your testing, did you determine how Mr. O'Keeffe's shoe ended up near the curb?
No, sir.
Exhibit 201A, please. Have you seen this photograph before?
I don't know that I have.
Have you ever seen any container that had tail light shards that matched the defendant's Lexus that were removed from his sweatshirt and his shirt? Have you ever seen any container holding those?
I haven't. Well, I believe there was evidence collected like that, but yes.
Okay, could we have 201E, please? Have you seen this photo?
I believe I have seen that, yes.
Do you understand those are taillight shards matching the defendant's Lexus, the broken taillight?
Yes.
That were recovered from Mr. O'Keeffe's sweater or shirt?
Objection.
I'm going to allow that. Did you consider that?
I'll try. I'd rather try to reformat it than come sidebar. Did you know that taillight shards were collected after Mr. O'Keeffe's sweatshirt and T-shirt was scraped?
Objection.
I'm going to allow that.
I need to see those.
Jurors, this will be brief.
All right, I'm going to need my own accident reconstruction here in the office. So now we have, I can't believe some of the questions that, Brennan is getting into. He is so under the bus here, and he's talking about, among other things, would you like to share with us some evidence you have about planting evidence? I mean, does he think that the jury's going to listen to that and think, oh, that's that crazy defense argument, and he's thinking this doctor is part of that somebody's planting evidence? He's just not seeing it. He's just not connecting with normal humans, and maybe because he's deep into this. We've talked many times before about when you're in trial, that's your world. And sometimes the real world gets kind of lost in the shuffle. But to me, common sense would say, if I accuse this witness, even though he hasn't mentioned a thing about it, of somehow fostering a story that evidence has been planted, then that will help the Commonwealth diffuse that story. That seems to be the kind of the crazy thinking that he's using here. But you got to appreciate Rentschler's response to most of these questions, especially when he got into the thing. Did you consider this battery temperatures? They don't have anything to do with what I did. Why would I consider those? And of course, objection. I'll allow it.
In your extensive study of the detail of this case, did you know that these pieces of plastic were removed or scraped from Mr. O'Keeffe's clothes, specifically his sweatshirt and his T-shirt? Did you know that?
I was aware that samples were recovered, yes.
Were you aware that these samples were consistent with the broken taillight of Miss Reed's Lexus. Did you know that?
Yes.
Did you do any analysis how these broken taillight shards got into Mr. O'Keeffe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
I'll try again.
Okay.
When you looked at these taillight shards that were objection.
Go ahead, Mr. Brennan.
When you looked at these taillight shards that were consistent with the break in Miss Reed's Lexus, did you consider how they got into Mr. O'Keeffe's clothes? Objection. Same objection.
I understand the objection. Word it differently. Start with the different one.
Yes, Your Honor. You see these pieces of broken plastic, don't you?
I do.
And you understand that these were found in the scrapings of Mr. O'Keeffe's clothes?
I do.
And you understand that these broken pieces of plastic are consistent with the taillight of Miss Reed's Lexus?
I do, yes.
In your studies and reenactments, did you make any determination how these pieces of broken plastic got into Mr. O'Keeffe's clothing?
No, when you look at those studies, first you have to know how the incident occurred. Then you can look at that and determine, if you want to, how that may have occurred. Because otherwise, there's, again, different ways, different manners in which that may have been deposited on the sweatshirt. Without knowing how this happened, you can't just then look at other evidence and try and predict how it happened. You need the actual evidence to look at the event. This all goes to the event. You need contact with the arm, I guess apparently, to actually cause this incident to occur. And without that evidence of any of that happening, knowing how the body moved, knowing how it was hit, knowing where it ended up, any conclusions drawn off of information like this is just supposition, because you don't know the movement of the body or the vehicle. It's putting the cart before the horse.
Could I have Exhibit 201D, please? Do you understand this is broken pieces of plastic consistent with the broken taillight of the defendant's car? Do you understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
Okay.
Well, I'm asking you, do you understand
Well,
that?
if that's what you're telling me, then
I don't want you to rely on me. If you didn't see them, it's okay.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph and seeing these broken pieces of plastic under a microscope with fibers near the plastic, is that something you would want to consider in your analysis, forming your opinion whether or not it was a collision between Ms. Reed's car and Mr. O'Keeffe?
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and dynamics before it. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
Can you see with your eye that parts of those broken pieces of plastic are sharp?
They look sharp.
Do you disagree? Do you think they're not sharp?
I don't have an opinion as to that, sir.
We'll take a look. Objection.
Sustained.
If you look at that for me kindly, could you tell me whether you think those pieces of broken plastic are sharp? Objection.
I'm going to allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope. When you actually put things under a microscope, it looks much different, and it is much different than
Let's go back to
looking at the normal
20E.
eye.
Perhaps that can help. Not under a microscope. If you pay particular attention to the larger one in the middle, that looks like a shark's tooth. Do you see
Yes.
that one?
Yes.
Do you think, doctor, that some of those appear sharp?
Some of those appear sharp, could possibly cause a laceration, sure, as opposed to an abrasion.
Do you think that any of those could cause an abrasion?
I don't think that you could get a consistent level of superficial abrasions along the entire arm of minimal depth of less than 0.5 millimeter through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those sharp pieces, if they were lodged in Mr. O'Keeffe's sweater, could cause an abrasion?
It's possible if you had enough punctures and holes in the sweater to correspond with the abrasions on the arm. That would be, I suppose, that could be a possibility.
In your testing, not to belabor it, I'm just going to show you one. I want to show you video E. Could we go to video E, please? Stop. In video E, the arm that is sticking straight out, who determined that angle, Dr. Wolf?
Yes, well, we positioned it just so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the alleged position of how the arm was at impact. But yes, we positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Well, I had input into how we were going to position it. It would probably be both of us, I would say.
So you and Dr. Wolf chose to position the arm straight out, correct?
In that test, we did, yes.
Is there a glass in Randy's hand?
There's not, no.
A drinking glass, no?
No.
In any of your studies, did you have a drinking glass in Randy's hand?
We did not have a drinking glass in the dummy's hand, no.
And you see when the taillight is shattering, those red things falling down. What are those?
Those are part of the taillight.
Continue a little bit, please. Stop. Did you count how many taillight pieces broke?
We didn't count the taillight pieces. We counted how many punctures or holes there were in the sweatshirt, which was 0.
If you had done this test and changed the arm angle, do you expect the damage would look different as far as the breaks in that taillight?
Well, we conducted a number of tests. It may look somewhat different, sure.
If you conducted this test and moved the arm angle, not another test, this test, but you moved the arm angle, do you expect that the break would look different?
That the break would look different?
Yes.
It could look a little different. I mean, certainly the breaks looked a little different in the test, but they were comparable to each other.
You do not know how John O'Keeffe was standing that night, do you?
Well,
No, I'm going to allow that.
You do not know how John O'Keeffe was standing that night, do you?
if he was standing, if the impact occurred, then no, nobody knows how he would have been standing.
You would not know what his arm angle was, would you?
No.
You would not know the exact speed of any vehicle that hit him that night, would you?
Sustained.
The debris, the broken taillight, is that traveling in a consistent or a different direction?
What do you mean consistent or
Is
different?
it all going in the same direction, or is it going in different directions?
No, there's some spread to the debris.
So the pieces don't all fall right in a pile with each other, do they?
They do not, no.
Continue, please. Stop. Do the majority of the pieces land on Randy?
No, they do not.
And so as they fall, if Randy were to fall, many of those pieces would not be among the immediate area of his body, would they?
If the dummy fell right there, no, they would not be.
Now, the dummy can't fall because the dummy is on a forklift, correct?
It's suspended like a pendulum, correct?
And you see in your test that the tail light, at what you say is 24 miles per hour, can be broken without the dummy's knees touching the vehicle. Isn't that fair to say?
That's correct, yes.
Okay. You can't tell the full movement and fall of this dummy the way you've set up this test, can you?
Well, knowing the physics, you can certainly determine or estimate where it would be, but no, you could release it and it would fall primarily straight down and it would fall down.
Is there something that could affect the dummy if you let it fall? Is there something that could affect its movement after being hit?
Like what?
Like, could its feet be twisted and then hit another object like a curb?
Well, there's going to be very little lateral movement of its feet, but even if it did, then it's still going to fall over right where it is.
Can you continue, please? Can you see the feet, doctor?
Yes,
Are they twisting?
they are, yes.
Is that because of the rotation of Randy after he struck?
Yeah, that's the rotation of Randy. And again, as you said, that's not a normal person because there's no normal force acting on the dummy. We just have it barely touching. So a normal individual, you aren't going to twist to that extent because this is a dummy which is suspended with just a little contact on the
And
ground.
after being contacted by a vehicle enough to break the light, could it cause a person to stagger backwards?
I mean, you're making some suppositions here. There's no evidence that would occur in this case, and not if you're spinning like that. You're not going to stagger backwards. First, you're going to spin if you get hit with your arm, as I described in my direct. But is it possible? I can't say it's impossible, but there's no evidence of that.
Could a person stumble backwards after being hit?
I'm going to allow that.
What do you mean by backwards? Because you'd be spinning. So what direction is backwards?
Could a person get their foot caught on a curb, and sneaker come off, and then stagger backwards and fall on their head?
Objection, Your Honor.
I'm going to allow that.
Doctor?
Can you answer that?
I mean, I guess you could somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that. So it's just supposition, but I won't say it's impossible.
You think John Okeffe did somersaults into the front yard of 34 Fairfield? Is that what you're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
That's not what I'm asking. I've heard that. I'm asking you
Yeah.
if he did somersaults into the front yard.
No, there's no evidence of what he did.
Your Honor, I should come sidebar quickly before I start.
Okay. Oops.
Okay, so let me ask you this: is it possible that the car brushed into Mr. Okeffe? He did a three-pointed pirouette, tumbled forward, jumped straight up, monkeys flew out of his rear end, and then he fell down. Is that possible? Objection. I'll allow it. Yeah.
I mean, how ridiculous all these questions and the objections, by the way, in case you're counting, or we're trying to learn what the heck they might be. Remember, there are no grounds allowed in this particular case. So obviously these are A, lack of foundation, B, more importantly, incomplete hypotheticals. You can ask experts hypotheticals. That's perfectly fine. It happens all the time. But you can't just start throwing out wild possibilities and then have them opine on that. Luckily, this guy is smart. Dr. Rentschler knows BS when he hears it. So he is using the opportunity every time he can to say, well, the vehicle never struck John Okeffe. So, but okay, here's, let me, if I'm going to have to answer of some sort, yeah, but maybe anything's possible. Somersaults, they're talking somersaults now. We've gone from pirouettes to somersaults, people. If we get to trial number 3, we could be talking about sow cows. You have to look that up in your figure skating. Don't get me into I'm having a triggering event with my figure skating. Anyway, some of the points made, an attempt to discredit this witness. Remember, cross-examination of an expert is all about discrediting those opinions. That's it. That's the goal. So they're working toward that in doing so by talking about things like, did he have a drinking glass? Did you know he had a drinking? Did you know he had a drinking glass in his hand? No, I didn't know that. Wouldn't matter to me. How about, oh, I love this. Where's Linda's bag of tricks when you need it? So remember the evidence bag that had all kinds of shards of glass, plastic in the bag with John Okeffe's clothing. Shake it up, put it on the floor somewhere for weeks, put it in somebody's car. I think Proctor had it, driving it around for a while, all in the same bag. And then, oh my God, I can't believe it. There are shards of taillight in the sweatshirt. Whoa, how could that be? Again, we know as best he can, Alan Jackson is going to revisit these things on his redirect, but he's going to be cut off at the knees. We know that. So he'll have to save a lot of this for closing and reinforce these things that we have talked about, that the jury has heard, but they've heard a lot over the weeks, and there's certain things that it will be very helpful to remind them of. So one of those is the cross-contamination issue in this case. All of these things that are being criticized by Hank Brennan go directly to the lack of investigation or the crappy investigation that was done. I love that part where Brennan was asking Rentschler, can you identify that piece of plastic? I don't know. Is that the one that was uncovered by the leaf blower? Now, we know there were none uncovered by the leaf blower, but still a fun reference. And I'm sure that was not lost on the jury. The leaf blower, the solo cups, those are things that everybody will take away from this case. Unfortunately, because of, oh, look, we have our solo cup up there now. Because such a crappy investigation does not give any sort of justice to the John Okeffe family. And that's the double tragedy here. Got somebody on trial that I have not yet seen proof of guilt for, Karen Reed, which means unless she did it and we just, we're missing something, then the John Okeffe family is not getting justice. And I can't imagine sitting there. I've talked about this before, but as this thing unfolds, I just keep thinking, you got Mrs. Okeffe. The shoddy attempt to trick somebody.
166, please.
It's sad.
Did you see this photograph, sir?
I did, yes.
And do you see the cut on Mr. O'Keeffe's nose, the left side of his nostril?
I do.
In your analysis of whether there was a collision with the defendant's Lexus, did you consider or know that there was evidence that a piece of glass or a piece of broken plastic was pulled from Mr. O'Keeffe's nose?
Objection.
I'm going to allow that. I'm going to allow that.
You are.
So, hold on. Let's get an answer, Dr. Mitchell. Your objection's noted, Mr. Jackson.
I was aware there was some piece of material allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
Objection.
Are you aware of that?
That's not the evidence. That is not the evidence.
So,
Glass.
hold on, Mr. Jackson. Mr. Brennan.
I can
do you have a
reword
quick-
it.
Okay.
You're welcome. Are you aware of that object that was pulled from Mr. O'Keefe's nose? What material that was?
I believe it was glass.
Did you want to know in your assessment about collision where that came from?
Well, I did evaluate that, and it's actually entirely inconsistent with coming from an impact with the vehicle.
Can we have Exhibit 52A, please? Do you know what that is, Doctor?
It's hard for me to see from here. I believe that's the drinking glass.
A drinking glass. Do you
Yeah.
know where that is in relation to where Mr. O'Keeffe was found?
I believe it was found in the vicinity of where he was found.
And could I have Exhibit 195, please? You recognize that?
That is another photograph of the drinking glass, yes, sir.
197A, please. B. C. D. And in your assessment, did you know that a piece of glass that fit the broken drinking glass was found in the street area in front of 34 Fairview Road?
Yes, sir.
Okay. 98, please. A little more, please. Do you know what that is, sir?
It's hard for me to tell from
Does it
back.
look like a drinking straw?
Okay, the black, that does appear to be a drinking straw, yes.
Have you seen that before?
I've seen that photograph before.
Okay. And do you appreciate that is in front of 34 Fairview Road?
Yes, I believe that's correct.
And sir, in your analysis, in your reconstruction analysis, did you consider the broken glass found near Mr. O'Keefe's body, the suggestion glass is found in his nose, and that glass that fit the broken glass was found on the street? Did you consider all those things in your reconstruction analysis?
Well, my biomechanical analysis, I did consider especially the glass in the nose, yes, and whether that could have been as a result of the impact.
A result of what?
A result of the impact with the vehicle.
When did you find out about the glass from Mr. O'Keefe's nose? When did you learn that?
I don't recall specifically.
Well, was it before you came and testified last time, or was it before this time?
I honestly, I couldn't tell you. I know it was before this time. I don't know when I found out about it.
Weeks ago, months ago? Could you turn the lights on, please?
I have no idea, sir.
You don't know if it was weeks or month ago?
I don't remember with that specific piece of evidence when I found out about it.
What do you mean you don't remember it? Have you seen it before?
Well, I evaluated certainly for my report for this case. I don't know if I had known about it prior to that.
Is it mentioned anywhere in your report about the piece of glass in Mr. O'Keefe's nose?
No, it's not.
When you received that information, did someone tell you about it? Did you listen? Did you watch? How did you evaluate this evidence?
It might have been in an interview or something that it was pulled from his nose, I believe.
Okay. So you saw and listened to something?
I believe so, or was made aware of it.
Okay. Just a couple more questions, sir. I had asked you at the beginning of your examination whether you denied that receiving information certainly helped prepare to understand what was going on during the trial. Do you remember those questions?
With respect to the trace DNA, correct?
Okay. approach?
Yes.
April 20th, 2025. Page 124, line 16. Yes, 124, line 16. May I approach?
Yes.
You've testified a few times under oath in this case, haven't you?
I have, yes, sir.
And you testified recently for a short bit in April, didn't you?
I did, yes.
On April 28, 2025, did you testify in this very courtroom
I believe I did.
under oath,
Yes, sir.
like the oath you took today?
Yes. Or yesterday.
Now, when I read this, I'm not attributing this in any way to the defendant's attorneys. I'm going to read you this just for clarity. You were asked, did they inform you about witness testimony? And what did you say, sir?
They did inform me, yes, about testimony in situations and events that came forth in the trial that I was not aware of.
Those are your words?
Yes, sir.
Page 125, line 7. I'm going to ask you if this is your sworn testimony, sir. On page 125, line 7, I'll read the question, and if this is your answer, you should read the answer. Were you asked, and by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it? What did you swear?
I said it certainly helped prepare me to understand what was going on during the trial, yes.
I have no further questions.
All right, Mr. Jackson? Okay.
So how do you think that that went? Did it kind of end with a whimper rather than a bang? And I hear that I'm having some audio issues, so keep me posted on that, guys. I have probably plugged and unplugged this microphone so many times I might have tweaked the connection a little bit. So let me know. I'm leaving it plugged in now. I'm leaving it plugged in. So hopefully, if it's working now, I won't disrupt that by taking it on and off. Okay. So let's talk about the drinking glass. First of all, the phrase "pulled it from his nose" leaves me concerned. I think if somebody says anything has been pulled from somebody's nose, they're thinking it's being pulled like from their nose, not, I don't know, from the, we're still not sure exactly where that was. And all of this, you know, comes from that one clip where Karen Reed said in the Body in the Snow ID miniseries, docuseries, now available on HBO Max, that she pulled a piece of glass from his nose. She said that right after saying that John Okeffe took her glass, the one she brought from the bar, the Waterfall bar that was in the center console. He took her glass with I got the impression it was like near his face, bridge of his nose, maybe. Anyway, redirect.
Yes.
Let's see how this goes.
Dr. Rentschler, you were just asked a couple of questions about they provided information about the prior trial, correct?
Correct.
They is no one associated with the defense team, correct?
That's correct. No one associated with you, and they provided information. And again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you for that.
To get through this, I'm going to let you just
you.
answer the question.
Sorry, Ron.
Rentschler.
And with regard to, and I appreciate that, Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCCA.
Okay. Wasn't them.
No,
It's a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you for that work, correct?
That's correct, yes.
Thank you. Thank you. You were asked about a fender vault collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center towards the driver's side of the car, and the car hits you. You go up over the car and you fly over the fender to the driver's side of the car. So you vault over top of the fender.
Dr. Rentschler, where is my, as I stand here, where is my center of mass?
Right about your belly button.
Right there. Right?
Yes.
So what would happen if I was hit by a vehicle, front collision, and the vehicle struck me below my center of mass?
It's going to flip you. Your center of mass will go, you'd go right up, if it was coming right at you and it hit you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different, the back of the SUV.
You were asked several questions about the debris field in the test F as in Foxtrot. Well, actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
You were shown several photographs, exhibits of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You were also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in this case, do you know when those pieces of plastic got to 34 Fairview?
I do not. No.
Do you know how those pieces of plastic got to 34 Fairview?
I do not, no.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the police reports that none of the plastic that you were shown was found at the time John Okeffe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. Okeffe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then somehow embed itself in the left side of the nose. That's entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Rentschler, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass?
Yes.
About a drinking straw?
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred, if the injuries don't match up. If you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Objection.
Sustained, you have to watch the formal question.
Of course. In your expert opinion, based on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John Okeffe?
I do.
Yeah, I'm sustaining that. You're on this call.
In your view, was there evidence of a collision with John Okeffe?
Objection.
Sustained.
In your opinion, were any of the injuries that you saw suffered by John Okeffe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Thank you, Doctor.
Doctor, you just said that you do not believe that there was a fender vault collision. Could it have been a clip?
Could it have clipped Mr. Okeffe?
Yes. Not hit him, but clipped him.
Well, I don't believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you learned of the information of the glass in Mr. O'Keeffe's nose, when do you think it was that that glass was pulled from his nose? What date?
I think it was the morning when his body was discovered.
January 29, 2022?
Yes, sir.
Somewhere around 6:15 a.m., is that your understanding?
Sometime when his body was discovered, that's correct.
Do you know or understand that, did you see any evidence that Mr. O'Keeffe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review about?
What evidence would there be? Is there a video or a photograph, you mean, of him holding a drinking glass? Because otherwise there's a drinking glass there, but there's no evidence that he had it.
We have a clip, right? Okay. Judge, could I come sidebar?
Okay.
Well, I don't think it's getting any better for Mr. Brennan. So what if he was just clipped? What about clipped? Not full impact, just clipped. No, I don't think that's consistent with any of the injuries either. And the drinking glass, who cares if we don't know how the accident occurred or if it occurred? There's just no evidence. And so the final blow by Alan Jackson, which he finally was able to say without objection, was that was the evidence you reviewed consistent with a collision between John Okeffe and the SUV? No, it was not. But all the other questions, which were perfectly fine, why can't you ask an expert for their ultimate opinion? What the hell are they doing there then, if you're not able to ask them for their ultimate opinion on these things? The opinion based on
everything we've talked about, all the testing he did, all of the proper evidence he's reviewed, all of the things that were made available to him. He's hired to give those opinions, but when you come to giving that ultimate opinion, sustained, no, I'm not. I can't allow that. It just makes no sense. And for those who are trying to make sense of the justice system, which, let's face it, can be confusing, right? You don't have to be a rocket scientist to figure it out. But, you know, as I like to say, you sell enough hot dogs, you become an expert in hot dogs. Well, the justice system is its own kind of hot dog stand. And you know, once you've sold a bunch of them, you get the sense of how it works. You start to think a little differently. This is not a good hot dog stand, okay? This is a tepid, bad New York City without permit hot dog stand. What do they call those? Dirty water dogs? That's what's going on in this courtroom. It's a dirty water dog. So don't pretend that this is the way it's supposed to go. If you decide to get into the field or you just continue to watch trials, this is not how it's supposed to work. Okay, there are rules. They should be applied equally. In this case, they're not. Let's see what else did you know about the plastic? Yeah, not found. Yeah, and Alan Jackson made a good point about that, about the pieces of plastic that allegedly were everywhere. He made a good point that even if they were found there at some point, at some time, remember, after the fact, and I always think, oh, when were they found? February 3rd, February 10th, February 8th, February 11th? Which day? February 18th? But with this witness, he made it very clear they were not found on the date of the alleged incident. So what's it matter? It doesn't. And sometimes those very obvious things need to be driven home, and I think Alan Jackson was able to do that. Brennan made some points. I get it, but I think the bigger message, Domino is right, I think the bigger message is not that he made a couple of points, and he did, about what this witness did rely upon and did not for his opinions. But he seemed to me to be reinforcing over and over again that nobody knows what the hell happened. So not only did the Commonwealth expert not know what happened, this expert doesn't know what happened, the Commonwealth doesn't know what happened, and they seem to be the ones with the burden of proof here. So my takeaway, if I'm on the jury, my takeaway would be, well, I understand this expert was trying to come up with some sort of understanding based on the evidence of what happened, but he can't testify to what actually happened. He's doing a what if. What if this happened? Boom. What if this happened? Boom. We don't know what happened. And I think Brennan's pestering him about that to minimize his opinions did more than minimize his opinions. It increased, in my mind, the fact that nobody knows. So jury members, don't worry about not knowing what happened. Just please fill in the blanks for the Commonwealth. That's what we're asking you to do. Let's see how the recross wraps up here.
You were asked about whether or not any plastic taillight shards were found near Mr. Okeffe's body. Do you know the limits of the search that the Canton Police Department did around Mr. Okeffe's body? How small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
I'd have to go back and look. I don't recall specifically.
And so when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr. Okeffe, most of them are on the right side of his body?
Well, we have the abrasions and then a half-centimeter abrasion, and then we have the laceration and scuff on the left side, and then the skull fracture. It's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the half centimeter. It's not a bruise. It's a half-centimeter abrasions, about an eighth of an inch.
When you're conducting an investigation or you're doing your analysis and you keep saying the physics and the physics, do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture that doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's
Yes,
what a lot of people
science.
were laughing about in the documentary.
Yes, science.
That we're all celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
How'd that tail light break, sir?
How to break that, Mike?
How did, I don't know. There's no evidence of how it broke.
I have no further questions.
All right, you're all set, Dr. Rentschler.
Thank you, Your Honor.
You're all set.
Is there an objection? So, subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay. They've been marked for identity. Jurors, I want to see counsel for a couple of minutes over here.
I knew this was going to happen because when they first put Rentschler on the stand and they got to the PowerPoint, which we know has been gutted by the court, right? Jackson asked that it be marked, and he wanted it marked and entered into evidence. But Brennan said for demonstrative purposes or just marked as an exhibit. So that's what happened. And so now at the end of this testimony, and this is good practice, you know, you make sure you move everything that you need giving to a given witness, move it into evidence. You can lose track of this stuff. And then the next thing you know, it's like, hey, did you move that report into evidence? No, I thought you did. So that's what he was trying to do. And of course, the court is hesitant to do that until she can find a reason not to. And so they're going to have a discussion on that now, I suppose, which is probably better than later. And we may get a clue about scheduling, because I have a feeling they're going to wrap now, unless they're going to try and bring in one of the rebuttal witnesses on kind of a short leash. And we know those witnesses in general are going to be relatively short, and then Welcher will be the guts of any rebuttal case. I can't wait for that. Woo. Anyway, what were we talking about? We're talking about the various attempts by Mr. Brennan on the recross, and how Alan Jackson tried to kind of clean up some of the mud left behind from the initial cross, which had its moments. I give him credit for some of the things that he attempted to do, but in my opinion, and we just heard it again on recross when talking about not having been clipped, talking about the glass. I don't know how the glass got there. I don't know. You continually are hearing that theme. I don't know how it got there, how that happened, when this took place. We are operating on a hypothesis here. Our conclusion, based on the evidence, is the SUV did not strike Officer John Okeffe. They mention that little knee abrasion, I think is what they decided to call it. It's 1/8 of an inch. Thank goodness for putting that into U.S. measure for us dummies, because I know there are 2.54 centimeters in an inch. So that means that's 25 millimeters in an inch. But then, I get too lazy. So 1/8 of an inch. I mean, I probably got that this morning getting out of bed. I mean, so I don't know that anybody's even proven to me that happened at the scene on January 29, 2022. Definitely not clear to me, but it's been almost just presumed to have been caused as a result of that night. I don't think there's a lot of evidence of that. Let's see. Yeah, he's. Do you know who in redirect? Do you know who put the pieces of plastic there? Do you know who put those there? You got to say that there was no objection. It wasn't, do you know when they were found? Do you know that the debris field over time changed? Do you know who put those pieces of plastic there? That question came in and by Alan Jackson. And of course, it was answered in the negative. No, I don't know who put those there. I've heard about Proctor. So I thought that was interesting. That one slipped in. What's wrong, Hank? You're losing your grip there. That clearly would have been objectionable. Oh, let's talk about the sharp edges. Mr. Brennan was focusing on, he had the picture. First, he had the microscopic picture of some of the bits and pieces that were in the bag, right? Mixed in with the John O'Keefe's clothes. And they show the microscopic picture, which you know how that is. You ever see a microscopic picture of a human hair? Frightening. So he was the witness is saying, well, I can't really tell what the hell that is. But they used the broader picture then. And he said, yeah, this kind of looks jagged. It could cause some damage. And then he used that opportunity to say, but it doesn't match up with 9 holes in the sweatshirt and 36 marks on John O'Keefe's arm. So that's what a good expert does. It reinforces his opinion, his points, every opportunity that he can. In this case, he's had plenty of opportunities because he can disagree with the question being posed by the examiner, in this case Hank Brennan, and then say because and he reinforces what his opinions might be. I was going to do this. I'm not sure if we have time. I know as soon as this happens, we're going to run. Okay, so we're learning that Harvey Weinstein has been convicted on 1 count of engaging in criminal sex. He has been acquitted on the second similar charge, also unable to reach a verdict on the rape count. That count, and to contrast what's going on in Massachusetts with trial number 1 and Karen Reed, those counts have all been looked at separately. So we have one that's an acquittal, one that's a conviction, and one that is still being deliberated. They're going to go back to resume deliberations on Thursday. I mentioned earlier that Imran Ansari, one of the Weinstein team members, although he's been slammed for some reason, he's going to make some time for us tomorrow and come on, give us kind of the inside look at what has been happening. We know there was a motion for mistrial because there are jurors that have been, let's just say, active.
We will see you tomorrow morning.
Yeah, she's killing it.
Same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. We'll see you tomorrow morning.
Yeah, we'll see if they go back to do some business after the jury leaves. So here's what's been happening with those jurors. There have been people trying to, get off the jury. This comes from Candace Owens. About an hour or so ago, the jury foreman in Weinstein has informed the judge he's been threatened by one of the other jurors, that he fears for his safety. The judge is refusing a mistrial. We know that the judge refused yesterday. They may have renewed that motion today. Another jurist, it's actually a juror because a jurist is somebody who's like on the appellate court. Another juror asked to be removed from the case over the treatment by another juror.
May be seated.
All right, so Mr. Brennan, I'm going to take a recess. You go ahead and look at that PowerPoint. I'll come back out in 10 minutes regarding the PowerPoint.
Okay, so what's happening here, I'm assuming that now Mr. Brennan is going to take a fine-tooth comb to the PowerPoint presented by Dr. Rentschler. Again, already gutted by the court. It's been just eviscerated, but it's still, nobody would know if you're on the jury. Nobody would know that there was stuff they did not get to see. It was pretty complete in terms of talking about what type of impact it would have been. Remember, they did full body, and then they did the arm swing thing. They did that full body, as I recall, as part of the FBI's request, that other organization, because there's no suggestion by anybody at this point that there was a full body impact, right? So that was just, I think that was kind of like the glass being thrown, which Dr. Wolf talked about. I think that was all part of the FBI investigation. Still important, get it out there, throw it, make it look like your investigation, your testing was far better and more complete than, blue man paint on the arm. And speaking of that, when this got me, and I noted it, but now I'm thinking about it. Brennan was trying to make it sound like this is, we don't know what's happening. You're not just making things up. You're not just, well, you got a guy, your expert, who's playing dress up, right? And pretending he is the victim in the case because he's about the same height and weight and wants to be, on camera. I don't know. It was odd, and I thought it was a little bizarre. But if you're talking about, creating what you need for your testing to get to the conclusion you want, how do you need to look any further than Welcher, the guy who puts on the same clothes as the victim and then makes himself the subject, makes himself the dummy. He is, the human crash dummy is Welcher. And I mean that in the nicest way. Okay. Talked about the edges, maybe creating some sort of injury, hard to tell, blah, blah, blah. And he also, again, Rentschler would take that information about the possibility that some of those plastic shards could cause injuries. He then says, but to create all of the different angles and lines and abrasions that we see, that's, he's basically saying that would be a miracle. I started thinking about the magic bullet in the JFK assassination. You have to go through somebody, out the side, reverse direction, back through another person. You get that sense that for these shards of plastic that were just flying in the air like a scene from The Matrix, they had to have their own propulsion system. To go left, right, down, over, cut, sideways, parallel. It just sounds ridiculous. Maybe it's not. Maybe it could happen. Well, let's talk about the fender bolt. I thought it was a new German word, like Fahrvergnügen. The fender bolt. That's a very specific. This was a thing that was criticized by Hank Brennan, and then corrected or explained better, I think, on Redirect, because Brennan just kind of went into it. Did you consider the fender vaults? And then Rentschler's like, well, that's a front impact. Somebody kind of vaults over the fender, hence the name, fender vault, which is a very typical motor vehicle pedestrian collision. Boom, woo, woo, fender vault. Pretty much irrelevant when you're talking about a car backing up into somebody. But Hank Brennan wanted to make a big deal out of it. He wanted to, and again, that's his job, to attack the presumptions, the opinions, and the basis for those opinions. So he did. I just don't think it went anywhere because people could look at it and go, what the hell does it matter? It's not a forward collision. It's a reverse collision if it happened. But I do like the name, fender vault. The fender vault. He got many opportunities to reinforce his ultimate opinion, which was there was no collision. I mean, does it need more than that? Oh, hey there she is. What's happening? Do you need something? Come on in. You need something? Yeah.
Work out at the gym and go to CVS. Need anything?
I'm good.
All right.
Yeah. Bye now. And now she's Domino's being abandoned. Where are you going? Where are you going? Hey, come back. Anyway. So further note checking here. Oh, let me see if there are any questions while I'm bloviating. Let me get into that. Hold on, please. Oh, yes. Here we go. Are you a pilot? No, we did that one. So get rid of that one. Isn't Hank's behavior intentional prosecutorial misconduct? Misconduct is a heavy burden to prove, and it happens. I think he got as close as possible in this trial with the showing of the sweatshirt and the suggestion that the holes that were in the back could have been caused, and asked the witness, could these have been caused by the road or by landing on the grass or by the impact, when he knew that they were caused in testing, when they took samples to test the material for whatever they were looking for. He knew that. That's close. In my opinion, that's close, but not in this case. In this case, get over it. It's a big deal. Come on. Yeah, that's close. A lot of his other stuff is just, zealousness that borders on being a major jerk. But I don't think misconduct. Bad style, bad form, an accusatory nature. Yeah, those really aren't misconduct. Those are just unpleasant, Will Brennan still call Welcher? Yeah. I'm going to speak for Linda now. I think we would agree that he is going to be called, but don't think he should be called. So I'm sure she'll correct me if I've got that wrong. But I want him to be called. But if I were in Brennan's position, I would not call him. The fact is, if you don't, this today, right now, what we've just seen is the last evidence the jury will hear. Do you want to leave it like that if you're the Commonwealth? Even if the problem is with Welcher, even if you bring him in on a rebuttal and you get from him a couple of nuggets that you need, he's going to be cross-examined. And that ain't going to go well in light of all the testimony from Dr. Wolf with an E and Dr. Rentschler. So Blue Man's going to be red-faced if he actually does show up. And I think he will. I think he will still testify. Let's see. What benefit does Commonwealth get out of running this trial into next week? Yeah, I don't know if anybody benefits more or less. I think the players, I always think of the jury first. I know that all of the attorneys, especially defense team, because they don't have home court advantage, they don't, the prosecution, they got offices, staff, everything. They're right here. They're right there, the Dedham area, but, in the county, Norfolk County. The defense, other than Mr. Unetti, who has offices everywhere, they're all from out of state. And so it's they're on the road and it's a drain. But so what? Boo-hoo. What I think is important is the jury. They've had plenty of time to soak this in. They're ready to see it end. I think they would better appreciate a fresh start on Monday than to cram it in by the Friday morning, maybe Friday afternoon, maybe, because they know what comes after that is deliberations. They know that once that happens, they're in. And I just feel like it would be better for them to take a beat, breathe over the weekend, come back at it fresh, ready to go on Monday. Friday verdicts, as we say, are a real thing. So I don't like putting that kind of artificial pressure on a jury to make them think, well, do you want to come back? Do you want anybody want to come back? Hell no, we don't want to come back. And I think it can force decision making that is inappropriate and rushed. Johnny Cochran said rush to judgment, and it happens in a lot of senses, not just in the OJ case where, boy, I keep thinking about that. 9 months of trial, 4.5 hours deliberation. Anyway, so I think the question is what benefit? I think everybody benefits from it being argued next week. We'll see. I think tomorrow obviously is the pivotal day. Yeah, Neil's coming on tonight. I wasn't sure who's coming on. I think Steve is coming on as well. Stephen implored. So we got a packed house. And I think tomorrow, as I was talking about the Harvey Weinstein crazy, I'm double checking to see if they've got any updates beyond what we've heard. Imran Ansari should be on tomorrow night, and we can get the inside poop on what's going on there. But if you missed it, Harvey Weinstein convicted of one count against him of sexual assault, acquitted on another. They will continue deliberating the rape charge tomorrow. Okay, did I get everything? I feel like I missed something. Hey, Paula, or it should be, hey, Paula. Yeah. What were the reasons for cutting the PowerPoint? Oh, God, where do I begin? Let me check my notepad. For every single slide, the court had a reason. I will give you just a couple that I recall that was a common theme. Some of the slides had ultimate opinions on them. For example, I didn't see them. I'm just assuming based on the discussion. As you can see, no contact could have happened, blah, blah, blah. So an ultimate opinion about the car, the SUV, not striking Officer John Okeffe. That those declarative statements, court didn't like those, so the slides were out. There were also slides that had texts on them. Now, that's interesting because I remember Brennan asking this witness questions about text. There was an objection, It was sustained. They moved on. But obviously, this witness Dr. Rentschler did consider or look at or somehow involve texts in his study and in his testing because they were on some of the slides. So, and I'm guessing it would have been sort of a timestampy thing. Don't know, because we didn't get to see it and the jury didn't get to see it. So, excuse me, in addition to those redactions or deletions, now Hank Brennan is going over the already redacted PowerPoint to see if there's other stuff in there that he doesn't like. And I guess they're going to have some discussion about that. This is normally what would happen is the parties would get together, Mr. Jackson, whomever is going to be in charge of that, and Mr. Brennan, and they would come to some agreement. Okay, this, and this is in, that these two things are out. But since it's already been carved up by the court, I don't know how likely Jackson is to give in further. So, but I think that discussion will take place, and that's the way it should be. You should be able to work that out and tell the court, Your Honor, we've worked it out. We've made the changes. We are both in agreement as to the exhibit that's going to be entered into evidence. Boom, we're done. And the court may or may not want to look at it, but generally, if they have the recommendation of both sides, the court's like, I don't care then, because on appeal, you know why the court doesn't care? All the court cares about is protecting itself on appeal. That's their goal from day one, from the moment they get there. In this case, I think it's a little weirder. The agenda may be helping the Commonwealth first, whatever happens to me second. But generally, they want a record that's clean, that protects them on appeal. So if you have two parties that say, oh, yeah, that's fine, we'll do this, this, and this to that exhibit, I'm fine with it going into evidence. Counsel, you fine with this going? Yes, I am. Court's like, I don't care, because if this goes up on appeal, you guys did this to yourselves. I didn't do it. Can't be error, reversible, harmless, or otherwise. So that's what's going on right now. They're working on coming to some agreement on the PowerPoint presentation. Let's see what else we got here. See, we got any others that I missed? Yeah, Brennan, my timeout. Is that my timeout? Something timeout. MLH timeout. Brennan keeps changing where John was supposedly hit. Well, you know, that's what I was saying about his method may have been to undermine Dr. Rentschler, but it kept reinforcing. Nobody knows what happened. Nobody, not even me. I don't even know for sure what happened. So let's try this. How about that? What about this? Maybe that. I understand the purpose in attacking the expert because you're trying to make it sound like, well, the expert's wishy-washy or didn't consider certain things. But you come off as, does the Commonwealth even know? Is there a theory here? I can't see how, in the bigger picture, it helps more than it hurts. So, yeah, I'm glad you noticed that change because I'm confident that the jury members also did. Michelle, I don't know where this came in time. Is there a timestamp on these? Oh, yeah, 3:32. Oh, so that was just, I don't know if it's directly related to something done at the end. I think what he asked for was he wanted to have this PowerPoint moved into evidence because we were talking about that it had been marked only as an exhibit. And as a good attorney, he wanted to make sure it was moved into evidence as this witness is now done. That's what led to this objection and further review, and we'll see where that ends up. I would be shocked if they come to an agreement without the court's help. That would be my first thought. All right, I think I got all those. Any other questions, let me know, because we're going to be skittering out of here as soon as they figure out what's happening with this exhibit, and then we'll be back tonight at 6. We will have our crash daddy, Stephen Plourde, will be on, and we'll talk about this testimony. And what I want to get from him, what I think is interesting, is this situation where you don't have a set bunch of accepted facts, right? It's really disputed. Did the car move backwards? If so, how fast? Because all the data used is questionable. I, of course, poo-poo most of it because I think it's the science isn't there yet. I just don't trust it. But the scientists, the experts, have to take that information, make certain assumptions that it's correct, and then they do their testing based on that. I just think that's an odd scenario, and I want to talk to Stephen Plourde about that. You know, it makes you think garbage in, garbage out. Nobody seems to know what was really happening, what are the real details, who put those pieces of plastic on the lawn. And if you can't rely on some of these very important details, how do you formulate the test, and how do the conclusions mean anything? I just don't know. I do not know. That's why I want to ask and see if our guest, and of course, Neil Rockhind, he is known as the Rockweiler. He will be joining us as well, give us his thoughts on this case, where we are, factually, procedurally, substantively, and he's always good to chime in on that stuff. Yeah, who's enjoying Sheila P? Who's enjoying their key cycles? If I never hear about key cycles again, it'll be way too soon. And I wonder, a lot of people love to get into the weeds on this stuff. A lot of people don't. A lot of people, as soon as they hear something like it's the 1162-2 key cycle, it's like everything after that is wah, 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 wah. And I guarantee you there are jurors that are in that category. Again, I'm so confused about how many there were, when they were, what they really mean in the big scheme of things, and whether anybody has proven, certainly as they need to, beyond a reasonable doubt, that they create a very specific point in time from which many other things have been analyzed. I don't know. Pick your key cycle. Oh, here's more on the key cycle, because I love this. Key cycle they're using is when the vehicle is loaded onto the tow truck, which explains the spinning of the tires. Yeah, there's that one, and then there's the 3-point turn prior to arriving at 34 Fairview, and then there's allegedly another 3-point turn when she left 34 Fairview. The only one I believe 100% is the loading onto the tow truck. Why? Because I can see it. I can see the movement of the car. Otherwise, I don't know. Secondarily, I would believe the one that happened on Cedar Crest, because I've been there. If you miss Fairview on your left, you got to make a turn and come back. And there was another vehicle with other testimony that seemed credible on that point, that as they were approaching to make the turn without missing it, the Karen Reed vehicle was returning after the Y turn and cut in front of them to go, oh, wait, where's my car? She's using my car. Yeah. So she comes in, boop, Y turn, and then another car here gives her the blinking lights. Oh, you can go first. So she goes. I think that one, I'm not too concerned about that one being legit, but one being done after the alleged event, I don't know. Got me. Marianne Nolan, she released everyone. It sounded like everybody, but the parties were coming back, she said, in 10 minutes. Anybody see or hear anything different? Like the 10 minutes passed and she changed her mind, or are we still waiting for them to come back? Anyone? My understanding, what I heard was, Mr. Brennan, why don't you take 10 minutes, go over that, and then, I don't know. She did not say, we'll go back on the record and talk about it. She just said, why don't you take 10 minutes? So give me the high sign, folks, Missy, Dizzy, if you know what they're doing in there, if anything. Yeah, so you know how the court clock works. It's not a normal clock, all right? So for those who just joined us, let me go through this again with the Weinstein, because I think this is very interesting news, and the reason that we reached out to his attorneys to get them on for an update. We know there's been a lot of discord within the jury. There have been accusations that there's been one or more jurors that have been ganging up on others. And if you recall the original trial that led to Harvey Weinstein's conviction, court allowed a number of prior bad acts, women who accused him of doing things that were not part of the primary trial. They were not named complainants or victims, but they were allowed to testify to bolster those that were named. Well, the appellate court said you can't do that. And that's very common prohibition. You can't pile on like that unless there is a very specific pattern, a signature of sorts, like they went to the same place every time, or they always went and had dinner and then went to the same place. So the pattern has to be very, very specific. And those folks Even if they had been assaulted, and those are the allegations, they didn't meet that criteria. So the appellate court said, that's severe enough, you got to have a new trial. That's where we are. So there was a new complainant added to this case, a third complainant who did testify. And you have the jury now apparently saying, this is, jurors talking about other jurors, that people have been talking about these other bad acts that were part of the first trial, as if they could consider them in this trial. Obviously wrong. And so now they've gotten past that somehow to come up with a conviction on one charge, one of the sexual assault charges, a conviction, an acquittal on the other. Again, they're separating out the charges. What a crazy idea. And deciding on each of them individually. And then the rape count is still in balance, and they're going to go back at it tomorrow. So that's what's happening there. And in the middle of that, the jury foreperson has told the court that he or she has been threatened by somebody else on the jury and is afraid to be there. Boy, not a good situation. Anyway, so hopefully Imran Ansari can tell us whatever he can tell us when he joins us. He has said tomorrow night. It's clearly a very fluid situation with the deliberations continuing tomorrow on the rape charge. So, I would give him a pass if it didn't happen, but that's what he told me today. He said, how about tomorrow night? So we'll see. My huge red flag list. I like that. Can Hank cause an intentional mistrial at the last moment when he's desperate, right? Well, yeah, he could. I mean, any attorney could. He would have to. Let me think. How would that play out? What would be the easiest thing for Hank Brennan to do, other than reveal a piece of information that has been prohibited, that helps the Commonwealth? So it could be he's already dabbled with DNA, so it'd have to be something worse than that. He's already presented clothing with holes cut in it, suggesting it was done at the time of the incident. So it won't be that. That wasn't enough. So maybe this is a rhetorical question. In this setting, is there anything Hank could possibly do to cause a mistrial? In this setting, maybe there isn't. But in theory, yeah, if he were to expose something, even let's say he went into the prior trial, and he starts talking about how in the first trial, the jury had voted, the majority had voted to convict on the second charge, and it's the same charge you're considering. We're done. We're done. It would have to be something pretty darn severe. This is interesting. Hey, Terry Friday. Do you know Dr. Park Dietz? The name sounds familiar, but I do not. I do not. Care to elaborate? Blessed in Texas. Oh, this is for Diz. Sorry, I've entered your private conversation here. And I'll tell you, Blessed in Texas, you're not the only one mixed up with a lot of the stuff that's happening in this case. That is for sure. But how would you feel if you were the jury? Now you're at it for 7+ weeks. You're finally able to. Again, this assumes they've not talked about it with anybody internally in the jury or at home or friends. How would you feel on that moment when you get in that room and finally chat about this case, where you think it's going, what you think's been proven, what do you think hasn't been proven? Good question, Debbie L. You wouldn't rest until all your evidence is in, right? Because let's assume you do, you just you got a brain fart and you're tired and you rest, and then that night, yeah, that's a moment you don't want to happen. The adrenaline rush. Oh crap! I didn't get into evidence. All these things. You then have to make a motion to reopen, because technically, if you've rested, that evidence that hasn't been moved in to evidence officially can't come in because you've rested. So you have to make a motion to reopen just to enter the material and evidence. Most of the time, I mean, unless it's really getting nasty, and maybe this case qualifies, most of the time, the other side is not going to object to that. Remember, if their theory is, if it wasn't objectionable evidence in the first place, now if it was something they objected to, the other side objected to, and it was never moved in, they may continue that objection, and the court now has a perfect reason to say, sorry, we're not going to reopen because you screwed up and forgot to get that into evidence. It's not impossible, it's not unheard of, but that's what you'd have to do. So you don't want to rest until all of your stuff is in, and I'm sure that was in part Alan Jackson's reason for confirming the PowerPoint was not into evidence yet, because they are on the verge of resting. And what they should be doing right now is Mr. Woke. Is he a court employee or is he one of the defense team? I can't remember, but he's sitting in the back doing all those. I think he's the defense team, right? Anyway, somebody on that team should be grinding away.
Court is back in session. You may be seated.
All right, so I had a minute to look at the PowerPoint. Are you in agreement on the PowerPoint?
We're not. I do not want to admit it. I don't think it's substantive evidence.
Okay. Mr. Jackson?
Exactly the substance of Dr. Welcher's
Which was not objected to, right?
No, the court keeps saying that, yes, there were things that were less like evidence, so yes. There were things that
But did he object to the PowerPoint coming in?
it's been, we're all under pressure. I don't know what Mr. Lesson's going to do regarding the PowerPoint. That's not the question. The question is whether this PowerPoint is admissible, and it is. There's nothing in it. We've taken out all hearsay. Our discussion of the opinions or thoughts, thought processes. These are all tests that were completed and done exactly as Dr. Wood's PowerPoint was done. Dr. Wood's PowerPoint is in evidence. This PowerPoint should be in evidence.
Is there anything in this PowerPoint by way of videos that is not already in through Dr. Wolf?
I believe the video of the drop test is in Dr. Welcher's PowerPoint. There are most of the videos are included. Oh, no, I'm wrong. Things have been slowed down. So the videos are the same, but the videos that Dr. Rentschler used because of the side of the case that he was handling, the biomechanics side of the case that he was handling, were slowed down significantly to show the deformation of the arm, the force impact on the elbow, the hand, forearm, about which he testified. So what he did, and I remember asking him this before I ever saw the PowerPoint, is there going to be anything different? He said, I use the slow motion cameras more than Dr. Wolf does because I need it.
Okay, so I need you to tell me tomorrow which slides specifically answered that question for me, okay, whether they're in evidence or not, and which ones are not, regarding the videos.
Is the court suggesting that it's not going to let just the entire PowerPoint?
Maybe. I'm going to take a look at it. There's an objection before me now,
I realize that.
so I have to rule on the objection. So I will take a look at this, okay?
Okay.
So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes.
Very briefly?
Yes.
I am objecting. It's not admissible. It's hearsay. It's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welcher's. I did not object to Dr. Wolf's, but that was a strategic decision. I'm objecting.
Okay.
The defense objected to Shannon Burgess. Only a select amount of documents were allowed. I wanted the whole thing in. I was precluded properly from introducing it because it was hearsay and they objected. I'm objecting.
Okay.
There's no hearsay. They objected to certain slides. We took out the slides. If they had an objection to the PowerPoint, they should have imposed that objection before it was displayed for the jury.
Well,
The jury has now seen the entire PowerPoint. I think it's tactical. It's not strategic. It's tactical. They just don't like it because it hurts their case. If they didn't want certain things before the jury, which is exactly what admitting it into evidence does, brings it before the jury so that they can see it, they should have objected in a timely manner. When they objected, they chose certain slides, certain data on certain slides, and we took all of that out at their request and at the court's instruction. We did that with the court's instruction, with the Commonwealth's instruction, and there was no objection to playing before the jury. Given the fact that it's been displayed not in part, but in whole, as it now sits before the jury, sits before the court, quadruple K for identification, it should be admitted.
Okay.
Just like Shannon Burgess, it's no different.
All right.
Shannon Burgess's PowerPoint is in evidence.
So, Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay. All right. Is that it for today? Will we see everybody just tomorrow morning? What else do?
Mr. Leslie needs to, I didn't mean to interrupt.
After the defendant rests, we will not be calling any witnesses, putting on any further evidence.
Okay. All right.
Your Honor, it's late in the day. We would like to review our motion for required finding of not guilty after the close of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning if the court prefers when we got tomorrow morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would it?
I'd like to respond to that, Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
Okay, great. So,
The technical thing is we need to move in the 3 items of evidence, the documents associated with the sweatshirt. I think they've been marked for identification.
no, they were marked as evidence, right?
They're private markers exhibits.
Yeah, they're exhibits.
But no, they're come into evidence, Your Honor, I mean, ruling that
Are they?
I thought they were marked as identification, not evidence. If they're in evidence, they're in. If it's identification.
So I need to find that. It would be my intention that they get put into evidence. I'm not going to display them and bring a jury in just to see those at this point.
I'm not asking for that.
Okay.
As long as they're in evidence and I can use them in closing argument, then so be it.
if I can for clarity, Your Honor, they're exhibits. I have Y.
So that's not an exhibit, Mr. Alessi, if that's how it marked. That's identification.
I have a different parlance. I'll use this court's parlance. Yes, it's YYY, ZZZ, AAA, BBB.
So that means that, all right, so that's for identification. Letters are identification, numbers are exhibits.
Your Honor, I understand that. We all know what we're talking about, and Your Honor agreed that they're going to be in evidence.
Right. So, and I've ruled that they're in evidence. I just need to know for this record whether they're in evidence or not. What you tell me, you just told me they're in evidence. They're not. They're exhibits. They're identification. Now they will become exhibits. Can we do that now? Do we have them? Where are they? Oh, Jim, they're in there? Okay.
Yeah, and Your Honor, my whole point in wanting to be heard is that they're not in evidence, and I want to make sure they get it. That's my point.
What number are we at, Madam Court Reporter?
Exhibit 230.
Okay, and we'll do A, B, C, D.
So is it Y, Z, A, and B? I think I have. I don't think I have those. Counsel, I'm not sure I have those.
All right, so we will make, so as of now, they're in evidence. Tomorrow, we need to physically put the sticker on those.
Can I just get the numbers? While we're waiting to-
Yes.
230A,
I'm sorry, say that one more time.
230A through C. 230C.
All right.
Council, there are 4,
Four of them,
A through D.
just so the record, this is limited to saying different things. They were marked for identification as triple Y, triple Z, quadruple A, and quadruple B.
Okay.
And all I need to do for my records is figure out which one is which in terms of the whole court's marking. As soon as we do that, I'm good and I'll get out of here.
We will do that first thing tomorrow morning.
That's fine.
Right? We will, so everyone is in agreement, then I will let you have tomorrow without the jury. We'll have our charge conference here in person. Then I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9 o'clock. Is that fair?
That's fair.
Mr. Brennan, are you in agreement?
I'm in agreement. I'm not interested in arguing tomorrow.
Okay. All right. So we'll give you tomorrow. We'll have a charge conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7 o'clock tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9 o'clock, we'll do arguments and charge. Tomorrow morning will be the charge conference. Since we don't have jurors, do you all want to come in at 10 o'clock instead of 9 o'clock?
That would be great.
Does that work for the Commonwealth as well?
Yes.
Okay. So I'll see everybody tomorrow morning at 10 for the charge conference. Do you have them now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D. If you want to look.
In the same corresponding order. So you know what they are, Mr. Jackson, in order. Okay?
223.
223.
Thank you. My only other question, Your Honor, was regarding the parameters of closing argument. Last year, we were relegated to 1 hour. I would ask for an hour and a half.
Just let this pass. No, I got it, but now you can go.
I would ask for. I would ask for an hour and a half for a final summation, given the case, the length of the case, the amount of evidence that's been adduced. I think that's outrageous, and the court normally allows only an hour.
You might get an hour and 15 minutes out of me. Let me see it out an hour. Let me see. You would not have got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want the same?
I don't have a position. I'll take whatever the defense is.
Let me think about it.
Yes,
All right.
Your Honor.
So we will see.
Thank you.
All right. So I'll see everybody at 10 o'clock tomorrow morning. Is there anything else we need to discuss?
No, thank you, Your
All
Honor.
right. We'll see you tomorrow morning.
All rise for the court, please.
All right, you can kind of sense a collective relief, like we're almost to the end of this effing thing, everybody. So let's, as you can see, getting stuff into evidence so important, and there's been a little scuffle about it. And of course, Mr. Brennan is objecting to the introduction of the PowerPoint. I mean, Welcher's is in, Burgess is in, Wolf is in. Remember, the Wolf, Rentschler, the different reports have a lot of shared information, but we'll see. They're going to talk about it again tomorrow morning to see if that's actually going to go in or not. And Alan Jackson made a good point. Like, why in the hell are you letting me show the jury, not just, normally if it's an exhibit, you work with the witness, you work on that. But if it's going to be displayed to the jury, only after it's in evidence. So Bonehead Brennan is now making this argument after he let the whole thing play out in front of the jury. Now, is it possible they've seen all they need to see? Well, who knows? You want them to have that when they go into the jury room. So, just a classic dick move at the end by Brennan. So anyway, the big takeaways, tomorrow is effectively off for the jury. We'll see if they're going to stream the jury instruction conference. I'm not confident they are. They did not last time. We'll see. We will have it if they do, with or without commentary. Not sure at this point. Linda will be on the road, but I'll be here to pop in if necessary. But I'm not sure yet if they're doing it. Most importantly, for my schedule, of course, Friday closing arguments, instructions and closing arguments. And the way she made it sound, and again, I've asked people to check me on this because I don't remember. Did they instruct after the arguments? She made it sound like that's what they are going to do. We'll have argument and instruction. And if that's the case, I think that's bad. Should be the other way around. But that's me. Anyway, so that means we'll pop up there very early Friday morning. We'll be there for React and for On the Street interactions for Friday as the jury hears closing arguments and then gets the case. The only thing I would bet on is that they won't come to a decision Friday. That's as far as I'm going to go. Either way, any version. And we've seen now in the Harvey Weinstein case, if you haven't joined, just joining us, you're going, oh, what the hell happened there? Guilty on one charge of sexual assault, not guilty on another. Rape charge still hanging in the balance. They'll go back to deliberating tomorrow. Why is that? Because they're allowed to evaluate each charge separately. You don't have to be unanimous on everything before you bring to the court your decision. You have basically a separate verdict on each of the charges. That's what's happening in Weinstein. Hope to have Imran Ansari on tomorrow to chat about this. He's on the Weinstein defense team with Mr. Aidala. So that's it. Interesting. We've answered some very important questions. Primarily, what's my schedule look like? How am I going to be affected by what they're doing in the courtroom? And now we kind of know. Let's see. I know we wanted to plug at least one more time what's happening tonight, right? Can we do that? Neil Rockhind, the Rockweiler, and of course Stephen will be on tonight, our crash daddy expert. We can talk about what Dr. Rentschler could talk about, what he couldn't talk about, what to me, the weird nature of a situation where nobody knows what the hell happened. Now discuss. Now experts put all that vague information into a bouillabaisse. Give us some opinions. I think what he has to say on that is going to be very interesting. Yes, Missy, jury not present tomorrow. Lawyers only at 10. So the question is whether they're going to stream that. I don't know. Missy, if you learn, your sources, check your sources, producer Missy, and see if you know they're going to do that or not. Obviously, we will learn that sooner rather than later. But at the moment, it's uncertain. It is certainly more formal than what we think happened last time. But is it going to be public? Should be. We'll see if it is or is not. So make sure I've grabbed all the questions before we get the heck out of here. And don't forget to join us at 6 o'clock. Ms. Linda Kenney Baden will be here, of course. We'll have Stephen Pleward. We'll have, let's see. Yeah, this was part of that discussion. I can't leave this one alone. Did Brendan say he objected because the defense objected about his witness? Brennan, I don't know. I mean, we may have to pass the mantle. From Mr. Lewin to Mr. Brennan. But yeah, he's, then he makes it sound like, well, they did not object to the Burgess, and then Jackson said, yeah, we did object. And it's still, it's still in. So the court didn't help the defense, shocker, by whittling away at the PowerPoint before Dr. Rentschler even testified. And so that set if I'm on the other side, if I'm the Commonwealth, and I see the court is attacking a proposed exhibit / piece of evidence for the other side, I might as well capitalize on it, even if I'm just being a jerk about it. I'm just going to give them a hard time because I know I got the court's ear on this thing. And they do. They definitely do. Okay, let's see. Anything else I need to cram in here? Yeah, this is a conspiracy theory. Conspiracy theory, do you think Bev and Brennan are talking or texting to each other or other people? Her hands are over her mouth, and sometimes Hank appears to be texting. It's like baseball, like when you go out and you have a conversation with the pitcher and you put your hand over there. Okay, I'm not buying into the conspiracy theory. No further witnesses. That's right. That's the other takeaway, and that's why we're talking about a day off tomorrow, instruction conference tomorrow. Closings on Friday is because, we had this conversation during the last break. Will Welcher make a reappearance? I was torn because I felt it was stupid. I would never call him back. But I felt that Brennan, maybe felt like he was leaving the room flaccid. Even the last thing this jury heard, now they will know when they get the call. Last thing they heard was Dr. Rentschler basically saying, the car never hit the guy. The end. Brennan would have had to put Welcher on there to counter that. But like I said, then Blue Man would have had a red face because on cross-exam, he would have been shredded. So that's it. No rebuttal case, which of course is more normal. But what's normal about this case? Yep, I'm just reading through here, confirming everybody's buzzing about what? No rebuttal case? I can't believe it. Yep, that is it. That's the story. Let's see. And this, I cannot help you with this. I got confused thinking today was yesterday, Tuesday. I can't help you. I can't help you with it. Linda. Oh, it's at 6:45 tonight. Thank you. We'll have Neil on before that to do some chatting. Well, here's the update on the doctor I did not know, Dr. Park Dietz. forensic psychologist. Pretty sure that's who I saw you with on Trooper. Well, that explains everything. Why would I actually remember who I might have appeared on a given show with? There are a lot of these shows, as you probably know, you're doing your interview one day and maybe a week later somebody else is. And then as both a producer of shows like I Survived a Crime, available on Netflix, or Cult Justice, available on Hulu, as a writer, producer, creator of some of these shows, you're doing them in pieces. They're in pieces. So it's very unusual that two talking heads will be interviewed same place, same day, like, hey, I'm done. See you. Have a good day. So if I haven't seen the show, no. How was Dr. Park Dietz? Good? Was it a good show? I always like to get some of that feedback. So I would like to fix things that I could have done better. Let's see. Yeah, and here's a refresher for you. Thursday, no jury. Charging conference for counsel. Friday, closing arguments. There you go. You heard this too, or maybe you didn't, because damn those guys, they are so off mic now. They've given up. They've given up worrying about poor little us wanting to hear what they're saying. And I noticed on the lectern the other day, I'm looking for a microphone like the one on the witness stand, along, like a game show host microphone. The microphone on the lectern, I'm looking for something that kind of, it's like this. It's here's the surface, and it's this big. So the pickup pattern is bizarre, but it explains why it's really useless unless you're right in front of it. Anyway, you may or may not have heard Alan Jackson lobbying for more time for closings. And the judge sort of made a joke about if you'd asked for 90, I would have said, no way. I'm going to have to look back at that. Maybe Dizzy or Missy, you can re-rack that and take a quick look at the last minute or two. So I think he may have asked for maybe an hour and 15. And then, of course, what does the suck-up, favored student say? Mr. Brennan, would you want the same? Whatever the court wants, that's fine. We have no position on that. What a liar! What a liar! So anyway, that was one of the last things that was heard. Okay, I'm going to get out of here. I think we've covered all that we can cover. We've caused all the damage we can cause for a day. Did we hit? We only hit 7 hours and 35 minutes. Bah! Not even overtime. But in the words of Dr. Rentschler, I'm salaried. Dang it! I was hoping we could get to that with Welcher, so we could contrast. I don't know about the money. I'm salaried with. Let's see. Let me check my latest bill. Cha-ching! $450,000. Thank you very much. Okay, so we'll see you back here at 6 o'clock. We're getting things all lined up. It has been a pleasure. Appreciate you being here, joining in, chiming in. If you're on X, just it's not very far down the hallway. Just go right down the hallway, take a left, just past the bathroom. You see YouTube. Go in there. Give us a like, give us a share, give us a subscription as we pass 15,000 today. Thank you all for that. And give us a howdy. Hit the howdy button. There should be one, but I don't know if there is. And then you can go off and do your X thing. All right. So I'm Michael Bryant. Try to do the right thing, and we will see you later on right here at Justice.